ಹಲೋ ಸರ್, 22 ಲೈವ್ ಡೇಟ್ ಚೇಂಜ್ ಆಗಿದೆ ಸರ್. ಹೌದಾ? ಅಲ್ಲ ಸರ್, ಇವಾಗ ಅದು ಅಡ್ಮಿನ್ ಯೂಸರ್ ಅಲ್ಲಿ ಡೇಟ್ ಚೇಂಜ್ ಆಗಿದೆ ಲೈವ್ ಕೊಡಕ್ಕೆ. ಇವಾಗ ಕೊಡ್ತಾ ಇದ್ದೀನಿ ಅಲ್ಲಿ.
Your for 29 counsel for the
Serial number 27.
Lordship, serial number 24 and 28, your Lordship.
Counsel for the petitioner filed a memo. They noted dismissed as also. Yes.
Serial number 27, my lord, I appear for a petition. A petition, petition has become infructuous.
Which one? 27.
Serial number 27, my lord.
27. Shivramu.
Yes, your lord.
Counsel for the petitioner submits that the petition is rendered infructuous and the same may be disposed of. Submission is placed on record. Petition is dismissed as the same is rendered infructuous. Yes.
Page 8, serial number 34. Ma'am.
Yes, which is your match?
Serial number 24 and 28. In fact, these are coffee board matters, your Lordship. It was connected with writ petition number 43616 of 2019. Batch matters it used to get listed before your Lordship. And your Lordship has adjourned for 2 weeks. This is how these two matters got separated and listed today. No idea, your Lordship. 24 and 28.
The other matter is
436.
Connected. They are separate, I think. 24 and 28, is it?
Please, your Lordship.
Those matters are listed.
These two matters are listed. Those batch matters, Lordship have adjourned for 2 weeks, Lordship. So, filing of synopsis.
It may be listed along with those.
24 and 28. The counsel for the petitioner submits that this writ petition is connected with WP number
43616.
matter, which is
that is the one, your Lordship. 43616 of 2019.
19.
Yes, please, your Lordship.
List.
The interim orders may be extended, your Lordship. Interim orders.
Yes.
Great.
Serial number 32 for the respondent. Prays for a week's time, my lord. Senior is out of state.
32.
32.
Counsel for the petitioner prays for time. Serial number 14. ನಿನ್ನೆಯಿಂದಲ್ಲ ಅದು yesterday's matter. You cannot, sir, you cannot mislead the court. ಅಷ್ಟು ನೆನಪಿರುತ್ತೆ ಸ್ವಲ್ಪ ಹೇಗಿದ್ದಾರೆ ನೋಡಿ, ಅದು ಕರೆದಾಗ ಮಾಡಿದ್ರೆ ಬರಲ್ಲ ಅಂತ ಹೇಳಿ. ನೋ ಸರ್ ಬರ್ಲಿ, ಅದೇ ಏನಿಲ್ಲ ಅದರಲ್ಲಿ, ಸುಮ್ಮನೆ ನೆಸಸರಿ. ನೋಡೋಣ ಬರ್ಲಿ.
Serial number 1, non-compliance of office objection for first time.
List 2, my lord. Serial number 4. List 2, serial number 4. Inconvenient.
ಏನಾಗಿದೆ? ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಅದು ಖಂಡಿತ ಇದೆ. ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಎಕ್ಸ್ಪರ್ಟ್ ತಾನೇ ಇದೆ. ಇದೇನು ವೈ ಫೊರೆನ್ಸಿಕ್ ಸೈನ್ಸ್ ಲ್ಯಾಬೊರೇಟರಿ ರಿಪೋರ್ಟ್?
My lord, cooperative society, the allegation may be with the signature forgery, my lord.
How that will come? How that can be decided by this court in a writ petition?
A writ petition, my lord, clear.
What inquiry that could be held in the writ?
The signature verification.
Similar
only for signature
verification.
verification.
Please. Disposed, my lord.
ಯಾಕೆ ಎಲ್ಲ ಮಾಡ್ತಾರಾ?
No, Lord.
Is it permissible?
No, my lord. It is, my lord. They are, my lord, objecting that the sign is not signed.
Maybe.
Please.
What is the remedy?
My lord.
Whether under the writ petition, we can have such a.
Disputed question of fact, my lord. Disputed question of fact cannot be, my lord, entertained in the writ petitions.
Very strange procedure. ಅದು ಯಾವಾಗಿದೆ?
Lord, ಅದು dispose ಮಾಡಿರುತ್ತೆ.
Already disposed
Please,
of.
please.
ಇದು ಬರಲ್ಲ ಇದೆಲ್ಲ.
Next week any date, senior out of station, my lord.
Counsel for the petitioner prays for time.
Both connected matters.
He undertakes to address his
4.1.
arguments
Petitioners.
on the next date of hearing without fail. Submission is placed on. I will not, no more adjournments.
Okay.
Yes.
List 1, page 1, serial number 1.
Petition, my
Sridhar K.
1 week's time may be employed.
Fourth
The
time lift ಆಗಿದೆ.
certificate copy has been applied, not to be
Counsel for the petitioner prays for a week's time to comply with the office objections. The matter is listed for the fourth time. However, list of finally as elections, 2 weeks bit TD. Next.
Serial number 2, Chiranjeevi KR.
Counsel for the petitioner is absent, no representation. Office has raised as many as 7 objections. Matter is listed for the fourth time. There is no progress in the matter. I do not find any reason to adjourn the matter. However, for final opportunity is done. Next.
Serial number 3, B. Keshamurthy.
Well, press for week's time and I will come. Certificate copy ಸಿಕ್ಕಿದೆ
ಇದರಲ್ಲೂ ಹಾಗೆ fourth time ಇದೆ. Finally posted.
Please.
Next. Finally.
Serial number
ಅದೆಲ್ಲ
4,
ಒಟ್ಟಿಗೆ.
Dilraj Jude.
ಇದು same. 15 office objections. Serial number 2 the ಪ್ರಕಾರ.
5, Shivayogi.
My lords, in this case, my lords, had one office objection regarding my lords, a typed copy of.
8 objections are there.
Yes, my lords, court fee I have paid, my lords, but the typed copy of order sheet is there around 40 pages.
The time it is posted.
ಆಗಿ ready ಆಗಿದೆ. 4 days may be granted, my lord.
For the petitioner prays for 4 days time to comply with the office objections. ಮತ್ತೆ ಉಳಿದಿದ್ದೆಲ್ಲ ಅದನ್ನೇ ಹಾಕಿ. Finally as a last chance.
Serial number 6,
Fifth time.
Dr.
listed.
S. Armugam.
Serial number 6.
Armugam.
Counsel for the petitioner is absent, no representation. Listed for the 6th time, there are 3 objections. ಅದನ್ನೆಲ್ಲ ಒಟ್ಟಿಗೆ ಹಾಕಿ. Finally as a last chance. Next.
Serial number 7, K. Lakshmikant.
Petitioner, my lord.
Yesterday the matter was listed.
Yesterday identification period not held.
TAP ಆಗಿಲ್ಲ my lords. TAP was not.
Yes. ಅಷ್ಟೇ. Any
My lords, in the further statement of the victim, my lords, the alleged incident on 2024, my lords.
age of the victim?
He is 52 years, my lords. He's 52 years. 24th was the incident. 26th
was
husband of the complainant, my lords.
My
26th his statement was recorded. At page number, my lords, 58, my lords. Below, my lords, in page 58, my lords.
See, co-accused are already enlarged on bail.
Some of the co-accused are.
Now, how many accused are there?
There are totally 8 accused.
7 accused.
7 accused.
7 accused.
Please.
Out of them, 4 are already enlarged on bail.
4 are already enlarged.
A1 is upstanding, my lord.
This petitioner is?
It is A4, my. He is A4. They are all habitual offenders, my lords.
What about 5
He is also on bail, my lord.
on bail?
Please, my lord.
Seven accused, huh? Yes. What about 7?
My lord, in the charge sheet they have mentioned as absconding, my lord.
Absconding.
He is absconding.
So good.
My lord, the petitioner is in jail since from 1.5 years, my lord, since from the date of arrest.
Yes.
He is arrested on 8/4/2024.
The petitioner accused number 1, ಇದು the criminal petition 6708. ಅದರದ್ದು para number 1 same, para 2 heard so and so, para 3 same, para 4 same, 5 same, same. 7 ನಲ್ಲಿ ಹೇಳ್ತೇನೆ. Learned counsel for the petitioner contended that accused number 2, 3, 5 and 6 are on bail, even though similar allegations were made against them. Accused number 1 and 7 are absconding. The present petitioner had approached this court by filing criminal petition number 6708 of 2024. The same was deemed to be dismissed with an order dated 25/7/2024, only on the ground that the test identification period was scheduled to be held and the petitioner is required to be detained in custody. Then a counsel submitted that in spite of such submissions, which led to dismissal of the petition filed by the petitioner, till date no test identification period was held. Detention of the petitioner in custody would amount to pre-trial punishment. Last sentence better. Till date, no test identification. This fact is not disputed by the learned HCGP. On the other hand, he concedes that no test identification period was held to enable the witnesses to identify the petitioner. Yes, what about criminal antecedents?
There are 5 cases against him.
My lord, in all, one of the cases is acquitted, my lord.
It is 302 nu ide.
302 ಇದೆ, 307 ಇದೆ.
My lord, I have. My lord, ಮಂಡ್ಯದಲ್ಲಿ SC 122 of 2016 ಇದರಲ್ಲಿ A7 ಆಗಿದ್ರು ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ ಅಕ್ವಿಟ್ ಆಗಿದೆ. ಅಂಡ್ ಮಂಡ್ಯ ಪೂರ್ವ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ CC 2810 ಇದು 399 and 402 ಅಫೆನ್ಸ್ ಸ್ವಾಮಿ, ಇದು ಬಾಕಿ ಇದೆ. ಇದರಲ್ಲಿ A6 ಇದ್ದಾರೆ. ಮಂಡ್ಯ ಗ್ರಾಮಾಂತರ ಪೊಲೀಸ್
399 and 380.
399 and 400 ಅಲ್ಲಿ
402 my lord.
400 of IPC.
Similar allegations.
Please.
Then
ಅದರಲ್ಲಿ is absconded ಅಂತ ನಮಗೆ ರಿಪೋರ್ಟ್.
ಯಾವ್ದ್ರಲ್ಲಿ?
399 400
ಇದ್ರೆ ಇವಾಗ ಜೆಸಿನಲ್ಲಿ ಇದನ್ನಲ್ಲ.
ಅದೇ in that case is reported as there is
abscondence ಇದ್ರೆ ಈಗ ಎಲ್ಲಿದೆ?
ಈಗ
ಕಸ್ಟಡಿ ಅಲ್ಲ.
ಕರೆಕ್ಟ್.
ಎಸ್
A6 ಆಗಿದ್ದಾರೆ ಸ್ವಾಮಿ ಆ ಕೇಸ್.
ಆಯ್ತು.
ಅದಾದ್ಮೇಲೆ ಮಂಡ್ಯ ಗ್ರಾಮಾಂತರ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಕ್ರೈಮ್ ನಂಬರ್ 603 of 2023 ಇದರಲ್ಲಿ ಇನ್ನ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ.
ಆಯ್ತು, ನೀವು ಅಕ್ಯೂಸ್ ತಾನೆ?
ಅಕ್ಯೂಸ್.
ಏನು ಅಫೆನ್ಸ್?
307 ಇದೆ ಸ್ವಾಮಿ.
307 ಎಸ್.
ಮಂಡ್ಯ ಗ್ರಾಮಾಂತರ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲೂ ಅಲ್ಲ CC 136 2023 ಅದರಲ್ಲಿ A3 ಆಗಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಇದು 323 324 is the major offense. ಕಗ್ಲಿಪುರ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ CC 6086 ಇದರಲ್ಲಿ A5 ಸ್ವಾಮಿ. ಇದು 302 IPC ಇದ್ರಲ್ಲೂ A5 ಆಗಿದೆ. 302
ಎಲ್ಲ ಸೀರಿಯಸ್ ಇದೆ. 302 ಇದೆ, 399 ಇದೆ, 400 ಇದೆ, 307 ಇದೆ, 324 ಇದೆ. ಮತ್ತಿನ್ನೇನು ಉಳಿತು?
My lord,
376 only last time.
My lord, he is married, my lord. He have a small female kid, my lord.
This is not the way to eke out your livelihood.
My lord, all the other accused are already on bail, my lord.
Were they having the antecedents?
My lord, A2 ಮೇಲೂನು A5 ಮೇಲೂನು 16 ಕೇಸ್ ಏನೋ ಇದೆ ಸ್ವಾಮಿ.
A5 ಎಲ್ಲಿದೆ ಅಲ್ಲಿ?
ಸ್ವಾಮಿ ಇದ್ರಲ್ಲೇ ಇದೆ. My lord, ನಮ್ಮ ಹತ್ರ ಇದ್ರಲ್ಲಿ ಏನು ರಿಕವರಿನೂ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ. ಅದು ಸ್ಪಾಟ್ ತೋರಿಸಿದಾಗ ಅಲ್ಲಿ ಹೋಗಿ ಅದು ಆಯುಧಗಳು ಮತ್ತೆ ಖರ್ಚೀಫ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದ್ ಬಿಟ್ರೆ ಬೇರೆ ಇವ್ರ ಹತ್ರ ಪರ್ಸನಲ್ ಆಗಿ ಯಾವುದೇ ರೀತಿ ಅಂತ ರಿಕವರಿನೂ ಆಗಿಲ್ಲ. ಇವ್ರದ್ದು
What was recovered?
My lord,
What was recovered in this case?
ಖರ್ಚೀಫ್, ಮಾಸ್ಕ್.
Mask from your custody.
From your custody. ಮತ್ತೆ my lord, kindly come to page number 45, my lord, of the petition. It is the charge sheet, column number 17, my lord. My lord, ಇದ್ರಲ್ಲಿ ಹೇಳ್ತಾರೆ ಇವರು ಅಮೌಂಟ್ ನ ಇವ್ರಿಗೆ ಜೊತೆಲಿ ಇದ್ದವಂತವ್ರು ಅವ್ರಿಗೆ ವರ್ಗಾವಣೆ ಮಾಡೋದ್ ಬಿಟ್ರೆ ಅವ್ರು ಜೊತೆಲಿ ಇದ್ದಿಲ್ಲ ಸ್ವಾಮಿ ಅವರು. ಅಂದ್ರೆ ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲಿ ಅವರು
ಆಯ್ತು.
ಅದಾದ್ಮೇಲೆ ಅವರು ಅದು ಜೊತೆಗೆ
party to the conspiracy, you are party to the unlawful assembly, you are party to the crime. ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ
ಅಲ್ಲ ಇನ್ನ ಎಲ್ಲಾನು ಅದು ಟ್ರಯಲ್ ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. ಅದ್ರ ಟ್ರಯಲ್ ಅಲ್ಲಿ ಇದೆ ಮತ್ತೆ ಒಂದ್ರಲ್ಲಿ ಆಲ್ರೆಡಿ ಅಕ್ವಿಟ್ ಆಗಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಒನ್ ಆಫ್ ದ ಕೇಸ್
ಆಯ್ತು. ಸ್ಟಿಲ್ ದೇರ್ ಆರ್ 4 other cases including 302.
ಪ್ಲೀಸ್ ಮೇಡಮ್, ಅದ್ರಲ್ಲಿ ಇನ್ನ 2 ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿಲ್ಲ.
ಆಯ್ತು, ಏನ್ ಮಾಡೋದು? Yes.
Antecedents are there, my lords. But recovery, with respect to recovery, there is no recovery from.
Why test identification period was not held?
My lords, unfortunately, my lords, the complainant party, my lords, is not cooperating. Repeatedly, there was a notice given to the complainant party because this accused, my lords, they are habitual, my lords. He is little afraid, my lords. There is a serious threat of his life, my lords. Therefore,
the HCGP submits that the petitioner is having criminal antecedents, as many as 4 criminal cases for the offence under section 399 and 400, 307, 302 and 323 and 324 are pending against him, and therefore the informant is not ready to come and identify the petitioner in the test identification period. Therefore, he apprehends that if the petitioner is enlarged on bail, there is every likelihood of endangering the life of the informant and the petitioner committing similar offense.
My lord, A2, my lord, ಅವ್ರ ಮೇಲೆ 16 cases ಇದೆ.
On materials on record, it is noticed that case number 1 to 7 have committed the heinous offense by criminally conspiring and doing the overt act in furtherance of their common object. It is stated that the kerchief used by the petitioner to cover his face was recovered at his instance. However, test identification period could not be held for the reasons as stated by the learned HCGP. It is not in dispute that the co-accused against whom similar allegations are made, and even though it is stated that they are also having criminal antecedents, are already enlarged on bail. The trial in this matter may take long time to conclude. Under such circumstances, detention of the petitioner in custody may amount to pre-trial punishment. Reasonable conditions may be imposed while enlarging the petitioner on bail. It is made clear that from the date of his release, if the petitioner is involved in any other case, the prosecution is at liberty to move for cancellation of bail before this court. In view of the above, I proceed to pass the following affirmative for the following reasons. Reasons are petition is allowed subject to conditions. If he involves in any other case, you can file an application for
Please.
cancellation of bail.
Serial number 8, Hiremetan Maheshaya Rudaya, Manikati Deepak.
Huh? For whom? 3 to 17. Yen Hesru? Adana Hesru Tabu. So and so submits that he has filed wakalat in the counter for respondent number 3 to 17. This is directed to verify the same and to show his name in the cause list. Yavaga nodi. Next.
Kindly extend the interim order.
Interim order extend madi after 4 weeks. Next.
Serial number 9, Idi Sandesh, H.N. Basuras, K. Anand.
Hearing first respondent. Who filed IA1 of 2025 for impleading? Who filed IA1 for impleading?
One Mr. Tilak Raj is filed.
It is out from our office, it is filed.
Objections are raised on that. Copy is not served on you?
Copies are.
Served? Adu onde objection.
So the impleading application.
Counsel for the petitioner submits that he is served with copy of IA1 of 2025.
Tilak Raj is we advocate for the proposed respondent number 18 and
R5. Statement of objections by respondent number 7. Who is the respondent number 7?
We filed the statement objections, we have filed it appears. It is they sought for inclusion of their name in the eligible voter.
No, it's not eligible voter
No,
list
your
inclusion.
statement. Who is respondent number 7?
When I'm appearing for respondent.
Yaar instructing yaar, sir.
Instructing Tilak Raj is H.N. Basuvaraju is on record.
ಮತ್ತೆ ಅವ್ರು ಇಲ್ದೆ ನೀವು ಮಾಡ್ತಿದ್ದೀರಾ?
Some colleague is there. My colleague is here. My colleague is here.
He is not opening his mouth. ನೀವೇ ಹೇಳ್ತಾ ಇದ್ದೀರಿ ಎಲ್ಲದು ಅಬ್ಜೆಕ್ಷನ್ಸಿಗೂ ನೀವೇ ಹೇಳ್ತೀರಿ ಮೆಮೋಗೂ ನೀವೇ ಹೇಳ್ತೀರಿ.
Respond 11, sir. Respond 11.
11 and 7 both are one and the same.
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದ ಯಾರಿಗೆ? ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ ಯಾರಿಗೆ?
ಯಾವ ಏನು
7 ಗೆ
ಅಲ್ಲ
R18 ಅಂತ
ನೀವಾ?
Is one of the contesting.
Yes.
There is counsel Shri Tilak Raj is absent. There is no representation. Of his objections are not complied with. ಈಗ ಏನಾಗ್ಬೇಕು ಇದ್ರಲ್ಲಿ?
Impleading application ಹಾಕಿದೆ ಅದ್ರ ಮೇಲೆ.
Who filed that? Nobody knows.
I'm representing impleading application. The applicant filed this application, so sought for implication of this impleading.
Who filed? Who filed?
Additional respondent.
Yaru, who is the advocate who has filed that?
That is Tilak Raj filed application. He is one of the contesting candidates.
ಅಲ್ಲ objection statement serve ಮಾಡಿದ್ದಾರೆ. This application is not served on us.
He says he is served.
No, that is objection statement by the.
Specifically, I asked him.
Yes, there is a mistake.
Yes, antar.
I will serve it on matter. I asked my colleague to do it.
Sir, office has raised objection that Tilak Raj has never filed wakalat. Who has
I
to
will
answer
verify
that?
and make my submission. He is not here. That's the handicap I am facing.
Sir, unfortunately, you are embarrassing the court.
No, I'm sorry, my lord. I'm sorry.
Every day, this is the position. What is to be done? ಯಂಗ್ಸ್ಟರ್ಸ್ ಆದ್ರೆ ಏನಾದ್ರು ಹೇಳಿ ಕಳಿಸ್ಬೋದು ಅವ್ರಿಗೆ.
ಅಲ್ಲ ನನಗೂ ಗೊತ್ತಿಲ್ಲ ಇದು ಮೈ ಅಡ್ವೊಕೇಟ್ ಅಂಡ್ ರೆಕಾರ್ಡ್ ಹ್ಯಾವ್
Then you should not venture to make any submissions, sir. ಅವ್ರು ಸುಮ್ನೆ ನೇಮ್ ಲೆಂಡರ್ ಬೇರೆ ಯಾರೋ ಹಾಕಿರ್ತಾರಲ್ಲಿ ಅವ್ರಿಗೇನ್ ಗೊತ್ತಿರುತ್ತೆ, ಅವ್ರ ಮೇಲೆ ಕೆಳಗೆ ನೋಡ್ತಾರೆ.
In the office objection in the cause.
Who is behind the screen?
Who is filed this year? Where Rakal?
Rectify and I will get back to my lords. Sorry.
What you have filed?
I think some
Mistake in what?
lords, I will check with my clerk, my lords, whether he has filed wakalat or not.
So clerk instructed you.
Sorry, my lords.
Then
I'll get back to you, my lords.
what is this?
Kindly pass on, my lords.
He told Lemon Counsel Tilak Raj, even though present before the court, he is not aware as to what is the application filed by him. What are the objections raised on such application? Lemon Counsel for the petitioner submits that he is not served with the copy of the application agreement. List after 4 weeks.
Serial number 10.
Interim order extend ಮಾಡಿ.
Maheshwarappa, Jayaprakash Reddy.
Interim order in the earlier matter.
Extended.
Lord, I am the
10 is concerned, my lord. I want to some time, my lord. Serial number 10 is concerned.
petition.
I had undertaken to file wakalat for respondent number 7, Parmeshwara. And your lordship has informed to serve a copy of the writ petition along with all the objections.
Also,
They haven't served a copy of the.
Have you filed wakalat? Have you filed wakalat? You already filed wakalat?
No, my lord, they haven't
Then?
served a copy of the writ petition.
So only after service you file wakalat, is it? What is this strange procedure you? Unless you file wakalat, you are not entitled for a copy. Do you know that?
Oh, yes, okay.
What is your locus standi to submit before the court? You are not in picture yet.
Apologize.
Non-filing of wakalat, Jayaprakash Reddy.
ಯಾರಿಗೆ
Respondent number 7, Parmeshwara.
Yes, when will you file wakalat? Whether you will file or not?
I'll file, my lord.
When?
By tomorrow I'll file.
Then counsel Jayaprakash Reddy pays for time to file wakalat for respondent number 7. This after 4 weeks.
Interim order.
Interim order extended.
Serial number 11. Varun Jacob Patel. Sandesh Reddy, Jacob.
Matter, I am permitting to file a impleading application.
Lords, in this case, my lords, I am appearing for the society and I have to file my own application to transpose application to the this petition.
You are for respondent number.
Transposition?
Please. Transpose application.
Transpose as what?
What is
As
it?
As a
petitioner.
petitioner,
Respondent number?
respondent number, my lords,
7.
7.
Where is the application?
I have to file, my lords, I pray for time.
ಹಾಕದಾಗ ಹೇಳಿ, ಇವಾಗ ಯಾಕೆ?
In this matter, I am filing a impleading application. I am the,
Implead whom?
we are the members of the respondent member society.
How many are to be impleaded?
There are 6 members here.
ಹೆಸರು ತಗೊಳ್ಳಿ, so and so submits that here he is filing the application seeking impleadment of the applicants. The
ಕೊಟ್ಟಿದ್ದಾರೆ
members
ಕಾಪಿ ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ ಕಾಪಿನ
members of the
Respondent number 7 society.
respondent number 7 society.
ಮೆಂಬರ್ಸ್ ಡೈರೆಕ್ಟರ್ಸ್ ಮೆಂಬರ್ಸ್.
Counsel for the petition.
Now the copy is served, my lord, will file.
Objections to the application. Yes, list of. Next.
There is an interim order.
Yes, that will be extended.
Please.
Serial number 12. G. Odayar, M. R. Ravichandra.
Matter, but
Due to subsequent development, the petition does not survive.
Counsel for the petitioner filed a memo. seeking to dispose of the petition as the same is rendered infructuous. Memo is placed on record, petition dismissed as the same is rendered infructuous. In view of disposal of writ petition IA 1 and 2 of 2025, also stand dismissed, disposed of.
Serial number 30, Mahesh S. Rupesh Kumar.
Petition, my lord. My preliminary submissions, I pointed out that the proceedings are not maintainable because it was against the non-members.
Which one?
The proceedings under section 70 was against the non-members. And your lordships.
They were not the members.
Yes, members. So for that, we stopped at that. Your lordship.
What is your
Kindly page
instructions?
number 83 may be kindly looked.
ಏನು submission ಏನು ನೋಡಿ ಆಮೇಲೆ ಬರೋಣ ಅಂತ page number.
I contended that the petitioner is the agent of the society, man. When he is an agent, my lord.
Agent ಅಂದ್ರೆ ಏನು? Agentಗೆ
Agent, yes, man.
under what provision of law?
182, my lord, of the Contract Act.
Contract act ಐತ್ರಿ.
ಇಲ್ಲ, it is
Cooperative
not defined.
society.
ಇದರಲ್ಲಿ Cooperative Society Act ಅಲ್ಲಿ define ಮಾಡಿಲ್ಲ.
Then
Then the only
what is the
available-
applicability of the act?
My lord, the agent is defined in the, my lord, section 70.
Section 70 ಇದೆ, but agent ಅನ್ನ
ಒಂದು ನಿಮಿಷ sir.
ಎಲ್ಲಿದೆ?
My lord, section 70B, my lord, may I?
Between a member, past member or person?
Between a member or a past member or person claiming though the members, past members, this is members, it's any officer, agent or employee of the society.
Here agent of the employee society now.
He says that my lord is the agent anta ಹೇಳಿದ್ರು.
Agent or employee of the society.
Society. Agent or employee, my lord, it is not,
ಅಲ್ಲ ಸರಿ.
please.
Why you are saying that they are the agents of the society?
Kindly you see page number 83, my lord.
Page number?
83 of the writ petition. Roman letter 2, my lord.
ಏನಿದೆ?
Page number ಏನು change ಆಗ್ತದೆ sir.
Yes.
Whereas Sri H.K. Ramesh, partner of first party, has an exclusive and independent arrangement, wide sale agreement with the owner and rights holder of this scheduled property to acquire the interest in the scheduled property to facilitate the development and sale of the scheduled property to any third party, And based on this contingent right over the scheduled property, the first party is entering into this memorandum of understanding, promising the second party to convey the rights in the scheduled property of the scheduled property so as to facilitate the second party to sell the scheduled property to its members. So this is the covenant.
Page number 83 na.
83, my lord. In my writ petition, it is 83.
Roman 2, my lord.
Roman 2.
84 ಅನ್ಸುತ್ತೆ ಸ್ವಾಮಿ. 84 ಅನ್ಸುತ್ತೆ.
84.
Please.
Please read it again.
ಓದಿ.
Whereas Sri H.K. Ramesh, partner of first party, has an exclusive and independent arrangement, wide a sale agreement with the owner of and rights holders of the scheduled property to acquire the rights in the scheduled property to facilitate the development and sale of the scheduled property to any third party, and based on this contingent right over the scheduled property, the first party is entering into this memorandum of understanding, promising the second party to convey the rights in the scheduled property of the scheduled property so as to facilitate the second party to sell the scheduled property to its members.
Oh, who is the petitioner now?
Petitioners, my lord, developers.
Yes.
Yes, ma'am. And he becomes an agent, my lord, by virtue of this clause, my lord. And as there is a duty, my lord, cast upon the petitioner to sell the developed sites in favor of the members of the society, my lord. And further, the same is also iterated in reiterated at paragraph next in the next page, my lord. At paragraph 4, my lord. 4 and Roman 4, and as well as at para number in the third page, fourth page of the agreement, my lord. 88.
89.
Roman 4, my lord. And wherefore, based on the aforesaid consensus addendum, the first party offered to acquire the rights in the scheduled property to facilitate development and sale of the scheduled property to second parties members in the condition and status the property to be converted and developed area at consideration of rupees 490 per square feet of siteable area fully developed as MUDA norms in the schedule A and B properties.
Which
Roman 4, my lord. Next page.
Lord, 85.
Yes.
85, my lord.
Page number 7.
Page number 80.
And wherefore, based on the aforesaid consensus addendum, the first party offered to acquire the rights in the scheduled property to facilitate development and sale of the scheduled property to second parties members in the condition and status that the property to be converted and developed area and consideration of rupees 940 per square feet of siteable area fully developed as per MUDA norms in the schedule A and B properties, total extent of 6 acres 10 guntas approximate cost of siteable area and project is rupees 11 crore 40 lakhs, and the second party has accepted this offer of the said consideration excluding land user site area. And in the same page, my lord, numerical 2, my lord. First party has agreed to get land converted and registered in the name of the second party or its members after development of land into sites as agreed upon.
Number 5, sir.
Yes, what is it?
No, please look at Lord, this section 70. If my lords look at section 70B,
Yes.
between member, past member, person claiming through a member, past member, deceased member, and the society, its board, officers, agent, or employees of the society. It must be, my lord, an agent to the society.
Yes.
Now, please come to, my lord, what my learned friend read in page 83. Please come to, my lord, what is the agreement? Please have a look at the agreement.
That is memorandum of understanding.
Correct, my lord, memorandum of understanding. memorandum of understanding between Lakshmi Properties by its managing director, Mr. Chandrahasa, in favor of, my lord, in favor of, my lord, this society. Now,
Chandrahasa and also Ramesh.
Correct.
HK Ramesh.
Correct.
as
Correct.
the
No difficulty
partner.
about it.
Yes.
Yes. Now, my lord, what is it that, what is the agreement about? Please come to, my lord, in page 83. After that, my lord, the parties, whereas the first party is engaged in the business of real estate developer, possesses claims, proclaims rights on the property described in the schedule hereto, and seeking to collaborate and enter into an arrangement with the second party, why this memorandum of understanding, whereas the first party of the second part is a registered housing society based in Mysore, constituted and registered for the purpose of acquiring, developing properties for the residential purposes to be allotted and sold to its registered members. And that the housing society is herewith collaborating with the first party to develop the properties under this arrangement to be later allotted to so and so, so and so. Whereas in the name of so and so, so and so. Now, my lord, please come to, my lord, what? Please come to, my lord, paragraph 2, which my learned friend read. At page 84.
Yes.
Whereas, Roman 2, my lord. HK Ramesh, partner of the first party, has an exclusive and independent arrangement, wide sale agreement with the owner and the rights holders of the scheduled property to acquire rights in the scheduled property, to facilitate development and sale of scheduled property to any third party. Based on this contingent right over the scheduled property, first party is entering into a memorandum of understanding, promising the second party to convey the rights in the scheduled property. What I am doing, my lord, is to convey it to them. I am not their agent. Now, please, what my learned friend is now trying to say is, so as to facilitate the second party to sell its member to scheduled members. They may do whatever they want. Am I the agent? Answer is no. I am selling it to them. Therefore, my lord, an agent is one who acts, my lord, for and on their behalf. I don't act for and on their behalf. I act for and on behalf of the owner. Please look at, my lord, again, paragraph 2. First party, whereas Ramesh, partner of the first party, has an exclusive and independent right wide sale agreement with the owner and the rights of the scheduled property to acquire the scheduled property to facilitate development and sale of the scheduled property to any third party. I become, my lord, the agent of the owner, if at all. And based on this memorandum of understanding, promising the second party to convey the rights in the scheduled property to. So I am, my lord, conveying it to the second party. I am not their agent. To facilitate the second party to sell, Lord, they may do what they want. Ultimately, my lord, question is, am I the agent? Please look at, my lord, what is it that, my lord, the authorities have done? Please look at the order itself. They are not saying, my lord, that they are relying upon, my lord, 117. Please look at, my lord, the order. Please come to, my lord, running page, impugned order. 91, my lord. 91 is a petition. Sorry, my lord. Sorry, 1 minute. 1 minute. I have my list of dates. On the list of dates on Madiden, Lord, I'll just pass on that list of dates also.
Yes. Yes.
Please come to, my lord, the impugned order at page 106.
Annexure N.
Annexure N, my lord. And annexure R. My lord, there are two.
Yes.
Please come to, my lord, the operative portion at page 107. ಮೇಲೆ ವಿವರಿಸಿದ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸಂಸ್ಥೆಯ ದೃಷ್ಟಿಯಿಂದ ವಾದಿಯು ಕರ್ನಾಟಕ ಸರ್ಕಾರ ಸಹಕಾರ ಸಂಘಗಳ ಕಾಯ್ದೆ ನಂಬರ್ 107 ಸಲ್ಲಿಸಿರುವ ಮಧ್ಯಂತರ ಅರ್ಜಿಯನ್ನು ಪುರಸ್ಕರಿಸಿ ನ್ಯಾಯಾಲಯವು ದಿನಾಂಕ 10/8/20 ನೋಟಿಸ್ನಲ್ಲಿ ತಿಳಿಸಿರುವ ಪ್ರತಿವಾದಿ 1-2 ಕೇಳ್ಕೊಂಡು ಸ್ಥಿರೀಕರಿಸಿದೆ. ದಟ್ ಇಸ್ ಮಲಾಟ್ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಆರ್ಡರ್ ಇಸ್ ಕನ್ಫರ್ಮ್. Now ಮಲಾಟ್ ಪ್ಲೀಸ್ ಲುಕ್ at the impugned order at page annexure R. At ಮಲಾಟ್ running page 115.
Yes.
Nowhere does my lord the authority come to the conclusion 70B will be applicable. Because my lord, my learned friend, my lord, as an astute lawyer, my lord has tried to give a twist. But if my lords look at page my lord 116 ಅಲ್ಲಿ ಈ ಹಂತದಲ್ಲಿ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ my lord.
Yes.
ಈ ಹಂತದಲ್ಲಿ ಪ್ರತಿವಾದಿ ಲಕ್ಷ್ಮಿ ಪ್ರಾಪರ್ಟೀಸ್ ಇದರ ಮಾಲೀಕರಾದ ಎಚ್ ಕೆ ರಮೇಶ್ ಲೇಟ್ ಕೃಷ್ಣೇಗೌಡ ಇವರು ದಿನಾಂಕ 10/12/2021 ಪ್ರಮಾಣ ಪತ್ರದ ಮೂಲಕ ಕರ್ನಾಟಕ ಸರ್ಕಾರ ಸಹಕಾರ ಸಂಘಗಳ ಕಾಯ್ದೆ 21(3) ಅಡಿಯಲ್ಲಿ ಸಲ್ಲಿಸಿ ತಾವು ವಾದಿ ಸಂಘದಲ್ಲಿ ಭೂ ಅಭಿವೃದ್ಧಿದಾರರಾಗಿ ನಿವೇಶನ ಅಭಿವೃದ್ಧಿಪಡಿಸುವ ಸಲುವಾಗಿ ಹಣ ಪಡೆದಿದ್ದು ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿಯ ಸದಸ್ಯರ ಭಿನ್ನಾಭಿಪ್ರಾಯದಿಂದಾಗಿ ಸಂಘದ ಜೊತೆಯಲ್ಲಿ ವ್ಯವಹರಿಸಲು ಸಾಧ್ಯವಾಗುವುದಿಲ್ಲ. ವಾದಿಯವರು ಈ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ದಾವೆ ದಾಖಲಿಸಿ ದಾವೆಯ ಜೊತೆಯಲ್ಲಿ ಸಲ್ಲಿಸಿರುವ ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘ ಕಾಯ್ದೆ 1959 ಕಲಂ 103ರಲ್ಲಿ ಅರ್ಜಿಯಲ್ಲಿ ಸಲ್ಲಿಸಿರುವ ಶೆಡ್ಯೂಲ್ಸ್ ಆಸ್ತಿಗಳು ದಿನಾಂಕ 10/8/2021 ಪ್ರಕರಣ 103ರ ರೀತಿಯ ನೋಟಿಸು ನೀಡಿ ನಂತರ ನಿಗದಿತ ದಿನಾಂಕದೊಳಗೆ ಸ್ಥಿರೀಕರಣಗೊಳಿಸಲಾಗಿರುತ್ತದೆ. ನಾನು ಅರ್ಜಿದಾರರ ಸಂಘಕ್ಕೆ ವಹಿಸಲು ಉದ್ದೇಶಿಸಿದ 1ನೇ ಐಟಂ ಸ್ವತ್ತು ಸರ್ವೆ ನಂಬರ್ 64/1ರಲ್ಲಿ 1 ಎಕರೆ 31 ಗುಂಟೆ ಪ್ರದೇಶವನ್ನು ಈಗಾಗಲೇ ಏಲಿಯನೇಷನ್ ಅಂದ್ರೆ ಸೇಲ್ ಮಾಡಿದ್ದೀನಿ. ಅಲಿನೇಷನ್ ಮಾಡಿದ್ದು ನಕ್ಷೆ ಅನುಮೋದನೆಗೆ ಹೋಗಿರುತ್ತದೆ. ಸಂಭಾವ್ಯ ನಕ್ಷೆಯಂತೆ 39,500 ಚದರ ಅಡಿಗಳಂತೆ ನಿವೇಶನ ಸಿಗುತ್ತದೆ. ಅದರಂತೆ ಇಂದಿನ ಮಾರುಕಟ್ಟೆ ದರದಲ್ಲಿ ಸುಮಾರು 7,18,00,000 ಆಗುತ್ತದೆ. ಆದರೆ ನಾನು ಅರ್ಜಿದಾರ ಸಂಘದಿಂದ 3,18,00,000 ರೂಪಾಯಿಗಳನ್ನು ಮಾತ್ರ ಪಡೆದಿದ್ದು ಅರ್ಜಿದಾರ ನನ್ನ 2 ಸ್ವತ್ತುಗಳ ಮೇಲೆ ತೀರ್ಪು ಪೂರ್ವ ಜಪ್ತಿ ಆದೇಶವನ್ನು ಪಡೆದಿರುವುದರಿಂದ ನನ್ನ ಎಲ್ಲಾ ವ್ಯವಹಾರಗಳು ಸ್ಥಗಿತಗೊಂಡಿರುವುದರಿಂದ ಹಾಗೂ ಜೀವನ ನಿರ್ವಹಣೆಗೂ ತೊಂದರೆಯಾಗಿರುವುದರಿಂದ ಸರ್ವೆ ನಂಬರ್ 67ರಲ್ಲಿ 4 ಎಕರೆ 19 ಗುಂಟೆ ಸ್ವತ್ತಿಗೆ ಪೂರ್ವ ಪಶ್ಚಿಮ ಉತ್ತರ ದಕ್ಷಿಣ ಇದು ಈ ಐಟಂ ಸ್ವತ್ತನ್ನು ಪೂರ್ವ ಜಪ್ತಿ ಆದೇಶದಂತೆ ಕೈ ಬಿಡುವಂತೆ ಈ ನ್ಯಾಯಾಲಯವನ್ನು ಕೋರಿಯುತ್ತಾರೆ. ವಾದಿ 1ನೇ ಪ್ರತಿವಾದಿಗೆ ಮಧ್ಯಂತರ ಅರ್ಜಿಗೆ ತನ್ನ ಆಕ್ಷೇಪಣೆಯನ್ನು ಸಲ್ಲಿಸಿ 1ನೇ ಪ್ರತಿವಾದಿಯು ಸಲ್ಲಿಸಿರುವ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 64(1)ರಲ್ಲಿ 1 ಎಕರೆ 31 ಗುಂಟೆ ಜಮೀನು ಮಾರುಕಟ್ಟೆ 7,18,00,000 ರೂಪಾಯಿಗಳಾಗಿರುವುದರಿಂದ ವಿವರಿಸಿದ್ದು ವಾದಿ ಸಂಘದಿಂದ 3,18,00,000 ಪಡೆದಿರುವುದಾಗಿ ಒಪ್ಪಿರುತ್ತಾರೆ. ದಿನಾಂಕ 18/9/2015 ಪ್ರತಿವಾದಿಗಳು ವಾದಿ ಸಂಘಕ್ಕೆ ಮಾಡಿಕೊಟ್ಟಿರುವ MOU ಕರಾರುಗಳ ಸರ್ವೆ ನಂಬರ್ 64(1)C ರಲ್ಲಿ 1 ಎಕರೆ 31 ಗುಂಟೆ ಜಮೀನು ಹಾಗೂ ಸರ್ವೆ ನಂಬರ್ 67ರಲ್ಲಿ 4 ಎಕರೆ 19 ಗುಂಟೆ ಹೀಗೆ ಒಟ್ಟು 6 ಎಕರೆ 10 ಗುಂಟೆ ಜಮೀನುಗಳನ್ನು ಕರಾರುಗಳನ್ವಯ ಕೃಷಿಯೇತರ ಮತ್ತು ವ್ಯವಸಾಯ ಭೂಮಿಯನ್ನಾಗಿ ಪರಿವರ್ತಿಸಿ ಸಂಬಂಧಿಸಿದ ಪ್ರಾಧಿಕಾರದಿಂದ ನೀಲಿ ನಕ್ಷೆ ಅನುಮೋದನೆ ಪಡೆದು ಬಡಾವಣೆ ರಚಿಸಿ ಸಂಘದ ಸದಸ್ಯಗಳಿಗೆ ಅನುಸರಿಸಿ ವಿವಿಧ ಅಳತೆಯ ನಿವೇಶನಗಳನ್ನು ರಚಿಸಲು ಸಂಘದೊಂದಿಗೆ ಒಪ್ಪಿರುವುದಾಗಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. 1ನೇ ಪ್ರತಿವಾದಿ ವಾದಿ ಸಂಘದೊಂದಿಗೆ 18/9/2015 ಮಾಡಿಕೊಟ್ಟಿರುವ ಕರಾರುಗಳನ್ವಯ ಸರ್ವೆ ನಂಬರ್ 64(1)C ಯಲ್ಲಿ 1 ಎಕರೆ 31 ಗುಂಟೆ ಹಾಗೂ 67 ಸರ್ವೆ ನಂಬರ್ 67ರಲ್ಲಿ 4 ಎಕರೆ 19 ಗುಂಟೆ ಹೀಗೆ ಒಟ್ಟು 6 ಎಕರೆ 10 ಗುಂಟೆ ಜಮೀನನ್ನು ಕೃಷಿಯೇತರ ಮತ್ತು ವಾಸಯೋಗ್ಯ ಭೂಮಿಯನ್ನಾಗಿ ಪರಿವರ್ತಿಸಲು ಸಂಬಂಧಿಸಿದ ಪ್ರಾಧಿಕಾರದಂತೆ ನೀಲಿ ನಕ್ಷೆನ ಅನುಮೋದನೆ ಪಡೆದು ಬಡಾವಣೆ ರಚಿಸಿ ವಿವಿಧ ಅಳತೆಯ ನಿವೇಶನಗಳನ್ನು ಸಂಘಕ್ಕೆ ನೀಡಲು ಒಪ್ಪಿರುವುದರಿಂದ ಹಾಗೂ ಒಂದನೇ ಪ್ರತಿವಾದಿಯು ಆಸ್ತಿಗಳು ಹಾಗೂ ಈಗಾಗಲೇ ಕಲಂ 133 ಅನ್ವಯ ಆದೇಶಪೂರ್ವ ಜಪ್ತಿಗೆ ಒಳಪಟ್ಟಿರುವ ಕಾರಣದಿಂದಾಗಿ ಸದರಿ ಒಪ್ಪಂದವು ಒಂದನೇ ಪ್ರತಿವಾದಿಗೆ ಬಂಧನಕಾರಿಯಾಗಿರುವುದರಿಂದ ಕಲಂ 103ನೇ ಅನ್ವಯ ಆದೇಶಪೂರ್ವ ಜಪ್ತಿಗೆ ಒಳಪಟ್ಟಿರುವ ಶೆಡ್ಯೂಲ್ ಆಸ್ತಿಯನ್ನು ಕೈಬಿಡುವ ಪ್ರಶ್ನೆ ಉದ್ಭವಿಸುವುದಿಲ್ಲವೆಂದು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. Then, my lord, please come to last paragraph in the next page. It is nobody's case that, my lord, I was an agent and then, my lord, this is, my lord, section 71B will apply. Now, my lord, let us look at, my lord, what is the that, my lord, I am not a member of the society is admitted. If my lords look at, my lord, their own application, sorry,
yes,
page 129, my lords may come to, my lord, page 129, the application filed by them. For the reasons shown in the accompanying affidavit, petitioner above, petitioner is, my lord, society, administrator represented by, my lord, representing the society. Please come to paragraph 4 at page 131, my lord, of the affidavit. 131 Para 4. I state, respondent number 1 and herein are not members of the nominal society and hence present application filed seeking permission to prosecute the case before the honorable tribunal against respondent number 1 as they are interested parties, not even, my lord, an agent. Today, my lord, their whole case is twisted. They don't say I am the agent. Sorry, my apologies. My lord, under section 70, a dispute can be only between members. Can I, my lord, give you a lordship, my lord?
No, as per this application, who is to be impleaded then?
Please, my lord.
Permit petitioner to prosecute the above case against
By, my lord, the administrative officer.
respondent number 1 and 2.
Correct. Prosecute against respondent 1 and 2, my lord. In fact, my lord, since my lords are on that affidavit, please again have a look at, my lord, para 4 again, my lord. They want to prosecute against us. And what do they say? I state that respondent number 1 herein are not members or nominal members of society. Hence, present applications filed before this court seeking permission to prosecute the above case before this tribunal as against respondent number 1 herein as they are interested party, not even agents. Today, my lord, their whole case is twisted. And your lordship saw, my lord, the memorandum of understanding says, I am selling it to them.
Yes.
Please have a look at, my lord, what is the law, my lord, with regard to, sorry.
Yes.
In fact, if my lords take, my lord, the judgment compilation are given to my lords. Other legal continuity.
Yes.
Yes, my lord. First judgment ತಾವು ತಗೊಳ್ಳಿ. ILR 2006 Karnataka 2180. ಇದರಲ್ಲಿ please come to, my lord, running head note A and, my lord, paragraph 25. Para 25 ಬನ್ನಿ ತಾವು. Page 16 ಅಲ್ಲಿ ಬರುತ್ತೆ. My lords get that at page 16, or running page 16. In order to appreciate the scope and ambit, sorry. In order to appreciate the scope and ambit of section 70 of the Act, it is necessary to carefully consider the words used in section 70. Section 70 reads thus, my lord, I'll skip all that. Now, my lord, please come to, my lord, the next page, page 18. Last paragraph of page 18, my lord. A reading of section 70 of the act makes it clear that subsection 1 of section 70 deals with parties with the disputes, whereas subsection 2 deals with the dispute is, and subsection 3 states that if any question arises where the dispute referred to the registrar under this section is a dispute or not, decision thereon of the registrar shall be final and shall not be called in question in the court. Therefore, for an application of section 70, firstly, dispute should be between persons who satisfy the requirements of section 71 of the act, and the dispute should fall within the categories mentioned in section 70, subsection 2 of the act. Careful reading of section 71 of the act discloses dispute touching constitution, management or business of a cooperative society should arise among the members, past members, persons claiming through members, past members, deceased members, or between the said aforesaid category of persons, or between society and its committee, past committee, any present past officer, agent, employer, nominee, legal representative, deceased officer, agent, employee, etc. Unless a dispute is between the aforesaid category of persons, registrar would get no jurisdiction to entertain a dispute under section 70. If it is averred in the dispute that the opposite party is not a member of the society at all, question whether the opposite party is a member of the society or not cannot be gone into in a dispute under section 70. Same would be the question, my lord, whether I am an agent or not also can't be gone into. If it is averred in the dispute that the opposite party is not a member of the society at all, question whether the opposite party is a member of the society or not cannot be gone into in the dispute under section 70. Principle embodied under order 7, rule 11 squarely applies to such a situation. In other words, if the dispute do not disclose aforesaid jurisdictional aspect, adike ಹೇಳಿದ್ದು ನಾನು ಅವರ application ತೋರಿಸಿದೆ, they don't even whisper that I am an agent. The principles embodied under order 7, rule 11, my lords, my lord, are so familiar with order 7, rule 11, squarely applies such a situation. In other words, if the dispute do not disclose the aforesaid jurisdiction aspect, dispute shall be rejected at the threshold, as it is settled law to find out whether the dispute is maintainable or not.
Yes.
What is to be seen is only averments in the dispute and not the averments or the statement of objection filed by the defense. So, my lord, neither in the application nor, my lord, in the application filed by them, my lord, for permission to prosecute, not a whisper that I am the agent. Then, my lord, this can't be, my lord, decided in section 70. Next judgment, my lords make, sorry, my lord, my apologies. Please come to my lord, page 32. Idರಲ್ಲಿ paragraph 11, my lord, at running page 34, my lord, 34. The my lord, para 11, my lord.
Yes.
The exclusion of the civil courts jurisdiction under the Cooperative Societies Act in the light of the aforesaid, in the light of the provisions already referred to, must be limited to the extent of matters expressly placed within the jurisdiction of special tribunal or authorities created under the act, for which purpose we have to read section 70, which shows that a dispute to which one of the parties is a member, parties is a person who is not a member of any cooperative society cannot be brought within the scope of section 70 or be submitted to any cooperative society, or be submitted for adjudication by the special authorities under the statute. That such a situation, such an intention or the statute is also clear from the provisions of subsection 4 of section 71, as well as the enumeration of the 3 different modes of execution of the awards in section 101. The former provision makes it clear that if the presence of a person who cannot be made a party is essential for an effective adjudication, he cannot be brought within the scope of the statute and made a party, nor can to special authorities functioning under the statute make any effective order. Statute itself requires and indicates the bar of the civil court's jurisdiction created by it shall not be given effect to, but that despite the bar, entire matter may be referred to ordinary civil court for proper and effective adjudication. Idea of providing the 3 modes of the execution is also the same, etc., etc. Now, my lord, please come to page 37, the next judgment. Paragraph 2 ಅಲ್ಲಿ ಇದರಲ್ಲಿ at page 40, my lord, 40.
Yes.
A perusal of the material and record would indicate that in the first instance, respondent number 4 and 5 society instituted proceedings under section 70 before the respondent number 3 joint registrar of cooperative societies against respondent 6. Subsequently, respondent 4 and 5 who were petitioners before the joint registrar of cooperative society filed an application seeking implement of the petitioner and respondent number 10. Petitioner and respondent number 10 have been notified about the said application. Respondent number 3 proceeded to pass the impugned order at annexure W, allowing the said impleadment application. Now, my lord, para 3. Meanwhile, proceedings are pending before respondent number 6 to 9 against the petitioner and respondent number 10 under the Arbitration Conciliation Act. My lord, I'll skip all that. Now, please come to, my lord, paragraph 5 and 6. Next page. Sorry, our page bottom. Learned counsel for the petitioner, page 41 bottom, submits that the petitioner was not a member of the respondent number 4 society, and since the petitioner did not claim to have acquired any interest in the property from either respondent number 4 and 5, or respondent number 6 to 9, question of petitioner being impleaded as additional party or respondent to the proceedings would not arise in the facts and circumstances. It was also submitted that the petitioner was neither a proper nor a necessary party to the said proceeding, and having regard to the limited scope and ambit of the proceedings under the said Act of 1959, that's the Cooperative Societies Act, section 70, petitioner could not have been impleaded as additional party or respondent to the proceeding. Per contra, counsel for the respondent number 4 submits that by virtue of section 117 of the Act, respondent number 3 was not only justified in impleading the petitioner as respondent number 10 to the proceeding, but also passing the impugned orders of attachment and confirming the same, and as such there was no merit in the petition, so on so on. Now, my lord, please come to paragraph 10 on the page, my lord, at 47. 9 and 10, my lord, I'm sorry, page 46 again. In the instant case, page 46, my lord.
Yes.
In the instant case, rather than the petitioner claiming to have acquired any right from either respondent number 4 and 5 or respondent number 6 and 9, it's a specific contents of the respondent number 4 and 5 that they had acquired right from the petitioner, and consequently having regard to the language employed in section 117(3), particularly when the petitioner does not claim to have acquired any right from either respondent number 4 and 5 or 6 and 9, I am of the considered opinion the petitioner is neither a proper nor necessary party to said proceeding. Consequently, the impugned orders deserve to be set aside. So on so on. So idರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ, they, my lord, claim in this particular case, my lord, which I just now referred to, my lord, of Justice Krishna Kumar, the contention was 117 applied. ಇದರಲ್ಲೂ ಅವರು ತಗೊಂಡಿದ್ರು. Now, my lord, they changed it to say, my lord, 71B. Not a whisper, as I pointed out, anywhere. 117 also will not apply, because if your lords look at it, our case only, the contention was 117 andru. Page, my lord, 42, my lords get that. At page 44 only 117 is called out.
Yes.
Court held, my lord, that neither of these sections, my lord, are applicable. Now, my lord, look at, my lord, the next judgment. Cooperative Societies Act only. What, my lord, would be? Please come to, my lord, paragraph page 48. Para 2, my lord, if your lords come to, my lord, at page 50. Facts are, my lord, almost nam tarane baratte. Adukoskara, my lord, I thought I'll give this, my lord, citation. Para 2, my lord. Facts as narrated by the petitioner are as follows. Petitioner is said to be absolute owner of the property bearing number so and so, measuring about 40 feet by 30 feet. It is said to be a residential site formed by a house building cooperative society known as Avani Housing Cooperative Society, the first respondent herein. Para 3. The above property was said to have been originally allotted to one Saumya and conveyed to her under absolute sale deed dated 22/6/1999 by the said society. Physical possession appears to have been delivered under a possession certificate dated 11/7/2001. Then, my lord, para 5. Petitioner said to be a dependent on her sons for all her needs, including the management of her properties, as she is aging and had also suffered injuries in the recent past. Apart from being diagnosed for several age-related illness and was hence totally bedridden, it transpires that when one of her sons, Narsimha Murthy, had routinely visited above property, as on 15/3, 2015. It was found to be free of encroachment. However, it is stated that when he again visited the site on 18/8, he found that there was construction activity in full progress on the said property. Having failed to gather the proper details of the person or persons at whose instance the construction was being carried on, it is said that he had immediately approached the jurisdictional police to prevent the illegal construction. However, police had opined that it was a dispute of a civil nature and that he could have to take civil action. It transpires a civil suit was filed in OS number so and so before the civil court. Then, my lord, please come to para 6. It transpired the second respondent who had entered appearance set up a defense that the site in question has been allotted by the first respondent society in favor of the third respondent and had been conveyed under registered CLD dated so and so, and that the said third respondent had in turn executed a registered CLD in favor of the second respondent dated so and so, and she was putting up construction as an absolute owner. Then, my lord, please come to my lord paragraph 10. Allene a page alle bottom. Petitioner contends that the mala fides and criminal intention on the part of the intention of the said secretary further becomes evident from the fact that fourth respondent was set up to file mischievous petition raising a dispute under section 70. What happened was suit on section 70 my lord was raised under the section 70 of the Cooperative Societies Act for brevity. Act for brevity. Within 1 week from the date of amendment against Soumya and her family members, including her deceased brother, claiming that 4 sites have been allotted to members of the same family in violation of the amended bylaws. It is alleged that the fifth respondent had, without reference to basic document such as encumbrance certificate, which would have disclosed the status of ownership of the site, had promptly allowed petition on the basis of the statement filed on behalf of the society, represented by Dayanand, conceding that there was indeed violation of the bylaws, so and so, so and so, so on. Then, my lord, please come to my lord paragraph 14. It is in the above background that the above petitions have been filed. Second of the above petition number, my lord, in WP number so and so, it is seen to have been filed seeking quashing the seal deeds, etc., seeking that the impugned order passed by the additional registrar of cooperative societies be quashed. Para 24 of Bandre, this honorable court, my lord, quashed it. Page, my lord, 55. It may hence be said that a dispute as to validity of sale deed in favor of the deceased under whom the petitioner claimed could not have been raised before the additional registrar of cooperative society. Reading of section 117 of the KCS Act would not also indicate that the said authority is vested with any such power to address the validity of a registered CLD. Consequently, even the appellate authority prescribed in the KCS Act would have no jurisdiction to address the order passed in such a dispute. Writ petition is hence held maintainable, and then ultimately it is allowed. Why I am pointing this out is 117 and our first togondru. Egamalot, they are saying section 71B. Not a whisper anywhere that I am the agent. Therefore, my lord, my submission to your lordship, in the light of my lord, the earlier 3 judgments which I had given to your lordship, question as to whether, my lord, I am a member, I am an agent, and therefore, my lord, amenable. It's all a matter, my lord, which can't be adjudicated in section 70. They're all, my lord, absolutely, my lord, arbitrary summary proceedings there. Therefore, my submission to your lordship says that, my lord, this is a case, my lord, where the petition has to be allowed. That's all, my lord. Grateful to your lordship. Sorry.
Next.
Para 6. The senior advocate for the petitioner, drawing the attention of the court to G, the memorandum of understanding dated 18 September 2015 contended that the terms of the memorandum of understanding makes it clear that the partnership firm, yes, the partnership firm, partnership firm and the partner, who is none other than the petitioner number 2 hearing, are referred to as party, first party, and the society is referred to as the second party. The agreement between the two is to the effect that the first party is being the first party who is engaged in the business of real estate developer and possesses and proclaims a right on certain properties described in the schedule therein, seeking to collaborate and enter into an arrangement with the society under the memorandum of understanding. As per the terms of the memorandum of understanding, petition number 2, being the partner of the first party, purchased first party being the owner in possession. Petition number 2 being a purchaser of survey number 64/1C under the registered sale deed has transferred the same as which was transferred to him by H.M. Changappa, who was also the owner of survey number 67/67 measuring 4.19 acres. The memorandum of understanding discloses that the property, the scheduled property, was belonging to one Chennaya and others, who sold Schedule A property in favor of H.M. Changappa under the registered sale deed. The RTC stood in his name pursuant to the sale deed. The said Changappa entered into a registered sale agreement with H.K. Ramesh, the petitioner number 2 herein. And therefore, the memorandum of understanding was entered into between the parties, whereunder petition number 2 as partner of first party who has an exclusive and independent arrangement under the sale agreement with the owner and right holders of the scheduled property, has undertaken to acquire the rights under the scheduled property to facilitate the development and the sale of the same to any third party, and based on this contingent, the first party entered into the memorandum of understanding with the second party society to convey the rights of the scheduled property so as to facilitate the second party to sell the scheduled property to its members. Therefore, the learned senior advocate contended that the terms of memorandum of understanding is very clear and under no stretch of imagination, as petition number 2 can be termed as an agent of the society. The senior advocate further contended that annexure N and R are impugned in this petition. Senior advocate contended that Annexure N is the order passed by the Joint Registrar of Cooperative Societies confirming the attachment before judgment in respect of survey number 64, 1C and 67 measuring 4.19 acres. He also contended that Annexure R is the order passed by the JRCS where the contentions taken by both the parties are highlighted. At no point of time, the society has taken up a contention that the petitioner herein is the agent of the society. But on the other hand, the allegation is that the petitioner herein had not complied with the conditions undertaken under memorandum of understanding. But however, now an attempt is being made to contend that petitioner is the agent of the society, which has no basis. Next part. When a senior advocate also drawn the attention of the court to Annexure S, copy of IA number 3, dated 19/6/2023, filed under Order 7, Rule 11A and D, CPC, by respondent numbers 1 and 2 before the Additional Registrar of Cooperative Societies, seeking to implead allow the application and to dismiss the filed by IA 5 of Annexure U. IA number 5 Allah 21/8/2023, filed by the society, seeking to implead seeking to permit it to prosecute the dispute against respondent numbers 1 and 2, that is the partnership firm and its partners. The senior advocate, drawing the attention of the court to para number 4, contended that even according to the society, the respondent number 1, the partnership firm, is not a member or nominal member of the society, and the application was filed seeking permission to prosecute the above case only because the partnership firm is not concerned with the society in any manner. Even in this application, it is not stated that the partnership firm or its partners are the agents of the society. If that was the case, there was no need to seek permission to prosecute by filing IA number 5. Next part. Learned counsel, learned senior advocate, placing reliance on the decision of this court in ILR 2006 Karnataka 2180 contended that the coordinate bench has categorically has referred to section 70 of Cooperative Societies Act and categorically held that when there is a specific averment in the dispute that the opposite party is not a member of the society at all, the question whether the opposite party is a member of the society or not cannot be gone into in a dispute under section 70. Next paragraph. Learned senior advocate places reliance on the decision of this court, the decision of the division bench of this court. In 1970 Supreme SCC Online Karnataka 126 to contend that section 70 of the Karnataka Cooperative Societies Act cannot be invoked when there is a dispute between the society and a non-member. If such a dispute was raised against a person who cannot be made as a party, against a person, if the presence of such person cannot be made a party, or is essential for an effective adjudication, he cannot be brought within the scope of the statute and made a party, nor can a special authorities functioning under the statute make any effective order under such circumstances. The matter may have to be referred to the ordinary civil court for a proper and effective adjudication. And its senior advocate also referred to the decision of the coordinate bench of this court in K. Chandrasekhar versus State of Karnataka, WP number 1250 of 2024, dated 23rd September 2024, to contend that even if section 117(3)(a) of KCS Act is taken into consideration, the petitioner cannot be brought under section 70 of the Act. And under such circumstances, the coordinate bench held that under such a bed. The senior counsel also referred to the decision of this court in 2016 ACC Online Karnataka 1105. contend that the dispute as to the validity of the sale deed in favor of the deceased, under whom the petitioner therein claims a right, could not have been raised before the registrar of cooperative societies. The court has held that a reading of section 117 of KCS Act would not indicate that the said authority is vested with any such power to address the validity of the registered sale deed. Consequently, even the appellate authority prescribed under KCS Act would have no appellate authority prescribed under the Act. Next, placing reliance on these decisions, the senior counsel contended that when, even according to the respondent society, the petitioner is neither an agent nor a member, and when in categorical terms it is stated that the petitioner is not a member of the society, and it was never stated that it is an agent, the dispute under section 70 could not have been raised. He further contended that when the dispute was raised before respondent number 1, it was never the contention of respondent number 2 that the petitioner was an agent under such circumstances. Further, the recitals in Memorandum of Understanding makes it clear that the petitioners are not the agents of the society to come within the ambit of section 72 of KCS Act. Therefore, the impugned orders passed by respondent number 1 is liable to be set aside as without jurisdiction. Accordingly, he prays for allowing the petition. Next, per contra. Learned counsel for respondent number 2 submits that petitioner society is the agent. Petitioners are the agents of the respondent number 2 society. Section 72 of KCS Act refers to the agent of the society. Therefore, the dispute is maintainable. The dispute was maintainable before respondent number 1. And the dispute was rightly considered, and the impugned orders were claimed to be passed. There are no reasons to interfere with the impugned order and prays for dismissal of the petition. Learned counsel for respondent number 2 prays for time to go through the decisions relied on by the learned senior advocate and to make his submissions. Bracket Order sheet and the third learned senior advocate for the petitioner. Learned counsel for respondent number 2 prays for time for further arguments. List on Ava.
May I request on? May I first my this day then?
Weekdays very well. Monday and Tuesday. Monday. First is.
The stay is in operation.
Next time.
Operation.
Serial number 14, Naraji Deepak, case in Rajesh.
My lord, I am for the second respondent.
Yes.
My lord, if it's convenient, kindly have it tomorrow. Because
tomorrow, no, sir.
Yes, my lord. Here, only two submissions, my lord. The interim order. Interim order has been passed on 10/9, Your Honor, 10/9/25, and it has been served on 15/9/25 at 10:45 a.m. Your Honor, Your Lordship, kindly peruse R23 annexure R23.
No, whatever may be, but by the time the order was already passed, is it not?
No, my lord. Evening 4 o'clock, the resolution has been passed. Evening resolution passed, my lord.
First defect is that they cannot ask for stay for a
10:45
problem.
order has been served.
Cannot ask a stay
10:45
of
a.m.
notice, which is maximum.
Stay.
That is the problem. Subject matter. Yesterday
Stay of articles of charge.
No,
Yes.
Stay of articles of charge.
that cannot be done in. There is a report also.
You have not participated in the proceedings?
Notice
He has
not served,
he
my
has
lord.
filed
Notice
application,
not
he has
served.
also start
Initially,
application.
your
He has
lordship may
participated.
kindly see their own synopsis. Your lordship may kindly see their own synopsis. On 11/7/2025, board meeting was held
That
to
is for
take
taking
to take a
inquiries.
decision. On
Not for
6/9/25,
decision.
on 8/9/25, directly the notice has been issued of notice of charges.
Hello, sir.
That
Committee was
I
formed. That
have
is for
challenged
meeting
by
was there.
filing a dispute, my lord.
Is there kindly?
And in violation of the order
No,
of the
Sir, when you raised the dispute,
on 8/9, my lord. Sorry, 10/9.
same day.
Same day interim order, ex parte order has been granted. And 15/9/25, order has been served in the morning itself. In spite of service of order, in violation of the order, they have taken a decision in the evening. Hence, I have filed IA number 2.
Whether this synopsis is correct,
So,
dates and events.
date at 11/7, it was board meeting was held not for this thing, for constituting a committee on the allegation. Kindly see the page number 30
I am asking you whether this synopsis, dates and events is correct.
also.
They took decision to verify the truth of the allegations and formed a committee.
Also, it is only for forming committee.
Committee, inquiry committee.
Inquiry committee. That is after that notice was issued, and
Then
our best
the
committee
board
has
of
issued a
directors
notice.
who headed the committee submitted their report finding allegations are true. And then 8/9 issued notice by registered post and by registered WhatsApp number, and also published the report inquiring why action should not be taken. That is the show cause notice.
Yes, sir. Calling
Yes.
them to explain why it should not be taken.
My lord, one word background I would like to
At that
submit.
time,
Only one
One
word.
minute, sir, I'll come back.
Yes, much of.
Wait for some time.
Yes, much of.
Respondent number 2 filed dispute challenging the notice issued. The board of directors in the meeting. No inquiry was held?
inquiry was held.
No.
When?
was
After,
report
after issuance of show cause notice, any inquiry was held?
Yes, sir.
Really?
With regard to show cause notice, he has not appeared, sir. Further.
When he was supposed to answer?
We are given 7 days time to him to answer.
Huh.
He has not appeared and answered.
When it will expire?
That is on notice was issued on 6/9/25. Sir.
How many
7
hours?
days was given to him.
When he was served with that?
He was served on the same day, but through WhatsApp also through register posted.
Register post, how many days it will take?
I have submitted annexure 3 days locally. Yes.
When you are notified about the dispute raised by respondent number 2?
On 15th, sir. On evening, after passing the order, it was notified by the manager.
At what time you passed the resolution?
Meeting was held on the timing was not given, sir.
Why?
I've been recorded.
ಮೀಟಿಂಗ್ ಇಂತಿಷ್ಟು ಹೊತ್ತಿಗೆ ಅಂತ ಇರುತ್ತಲ್ವಾ?
ಹೌದು ಸರ್.
ಎಷ್ಟೊತ್ತಿಗೆ ಮಾಡಿದ್ರಿ? When you call for a meeting, generally it will be stated by this time the meeting will be held.
Mistake, they are not mentioned the timing.
ಅದೆಲ್ಲ ಮಿಸ್ಟೇಕ್ obviously it was done.
Not like this. No. The problem is subject matter of notice. They are calling for the stay. That itself is a cannot be done. It is an act following actual justice. I have fixed the notice.
I'm
Correct, Swami.
asking
Correct,
you.
Swami. I have not violated any natural justice against him.
Sir, ಕಾಂಡಕ್ಟ್ ಇಲ್ಲೇ ತೋರಿಸುತ್ತಲ್ಲ,
Swami.
ವಾಟ್ಸ್ಆಪ್ ನಲ್ಲಿ ನೀವು ನೋಟಿಸ್ ಕಳಿಸ್ತೀರಿ.
Notice ಕಳಿಸಿ ಸರ್, ಲಿಸ್ಟ್ ಪೋಸ್ಟ್ ಕಳಿಸಿ.
ವಾಟ್ಸ್ಆಪ್ ನಲ್ಲಿ
annexure page number 65 sir.
Very strange procedure.
Page number
we have
65 sir.
adopted.
Page number 65.
Which is the document you are relying on to contend that on 15/9/2025 the notice of stay
Madam.
was issued.
Exhibit
on the petitioner.
R2 my.
Exhibit ಇರೋದಿಲ್ಲ.
ಇಲ್ಲ ಇದೆ.
Sorry, annexure
Yes, sir,
files.
ಏನಿದೆ ಇದು?
10:45 AM it has been served.
10:45.
It was not brought in the meeting, Swami. That is a board meeting. It was.
Whose fault it is?
It was
For
not.
all practical purpose, it is served on you in the
Also-
morning itself.
But problem is, Swami, the inquiry report was already submitted when notice was challenged. Order was passed. Report was already submitted.
ಅದು ಬೇರೆ.
ಹೌದು.
ನಾನು ನಿನ್ನೆ ಅದನ್ನ
ಹೌದು.
ಮಾಡಿದ್ದೀನಿ. But now I am considering the conduct of the respondent. What was the hurry?
There is no hurry.
When at 10:45 AM this was brought to your notice.
We are not aware of this dispute itself, sir.
Who has
That has brought to notice on 15th.
received it?
That is manager, Swami. Kapala like.
What is his responsibility? Is he not accountable? He is your employee. Then you cannot escape saying manager ಗೊತ್ತಿತ್ತು ನಮಗೆ ಗೊತ್ತಿರಲಿಲ್ಲ.
ಇಲ್ಲ ಮಾತಾಡೇನಿಲ್ಲ.
Then
that was not dispute was not at all brought to our this thing. It was brought only on the 15th by the this thing.
yes, 15th morning it was brought to your notice.
But meeting was scheduled to be held on that day 15th.
No, after serving this, I don't think you could have passed this.
One more submission. In the case of Virendra Singh versus Delhi Cooperative Society, where the first subject matter in the prayer is the stay after notice. Even that is issued to give explanation, not any penal action, to take any penal action. The notice issued on 31/7/2025 was issued to explanation. For that, stay cannot be given. This is the principle laid down on that. This decision was came to. They can file a dispute, but they cannot ask for a stay of a notice which was issued.
Now, whether the stay was properly granted or not, it is entirely different issue.
The subject matter which they have sought.
Rightly or wrongly,
That
stay
is-
was granted.
Now, before this.
You should have sought for vacating that stay.
That I have filed, sir. That I have
But in
filed.
the
Kindly
meantime,
see-
you passed this. That
No,
is
no,
not
no, Allah,
permissible.
sir. Kindly see that. I have filed that vacating application on. Kindly see the page number 68, sir. 1410, sir. Page number 69, sir. Kindly see page number 6. Order sheets. 69, sir. ಪ್ರಕರಣಗಳ ವಾದಿ ಮತ್ತು ವಾದಿ ಪರ ವಕೀಲರು ಹಾಜರಾಗಿದ್ದು ಪ್ರತಿವಾದಿ ಪರ ವಕೀಲರು ಹಾಜರಾಗಿ ಪ್ರತಿವಾದಿ ಪರ ವಕೀಲರು ಹಾಜರಾಗಿ ಮಧ್ಯಂತರ ಅರ್ಜಿ ಒಂದು ತಮ್ಮ ಆಕ್ಷೇಪಣೆಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಐ ಫೈಲ್ ದ ಅಬ್ಜೆಕ್ಷನ್ ಟು IA ನಂಬರ್ 1 ಹಾಗೂ ಮಧ್ಯಂತರ ಅರ್ಜಿ ಎರಡನ್ನೂ ಸಲ್ಲಿಸಿ ಮಧ್ಯಂತರ ಅರ್ಜಿಯನ್ನು ತೆರವುಗೊಳಿಸಲು ಕೋರಿರುತ್ತಾರೆ. I felt after obtaining a notice, he has kept that as within his knowledge, not submitted within that prescribed time limit, that he has not entitled for any equity. So court was pleased to not to grant further stay. Kindly see the next date of hearing, sir. On 23/10. ಪ್ರಕರಣವನ್ನು ಕರೆಯಲಾಯಿತು. ವಾದಿ ಮತ್ತು ವಾದಿಪರ ವಕೀಲರು ಹಾಜರಾಗಿ ಪ್ರತಿವಾದಿಗಳು ಗೈರು ಹಾಜರಾಗಿದ್ದಾರೆ. ವಾದಿಪರ ವಕೀಲರು ಮಧ್ಯಂತರ ಅರ್ಜಿಯನ್ನು ತಮ್ಮ ಲಿಖಿತ ಆಕ್ಷೇಪಣೆ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. They filed an objection to my IA. Citation ಗಳನ್ನು ಸಲ್ಲಿಸಿದ್ದಾರೆ. ವಾದಿಪರ ಮಧ್ಯಂತರ ಸಲ್ಲಿಸಿ ಮೂರನೇ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. 24/10/2025 ಸಭೆ ತಡೆಯಾಜ್ಞೆಯನ್ನು ಕೋರಿರುತ್ತಾರೆ. ತಡೆ ಮಧ್ಯಂತರ ಅರ್ಜಿ 3 ಪುರಸ್ಕರಿಸಲು ಬಾರದು ಎಂದು ತಿರಸ್ಕರಿಸಲಾಗಿದೆ. They at that time IA number 3 was rejected, not IA2. IA2 was mine application which was filed by me. They did not file any IA. The impugned order which they have passed in annexure G Swami 76 is based upon the IA number 2, which is my IA. Their IA was not at all on the record. That's why yesterday senior counsel IA3 was for dismissal, for not to conduct a general body meeting, board of meeting. It is scheduled to be held on 24/10. Kindly see the page number 51, sir.
Now you are challenging the order dated 30.
30 out submit. Not 10 was not the subject matter. 31 was passed based upon the application filed there. As per them, it's 8/10/2025.
What is this order? 30/10/2010.
That is based upon the IA filed by them in the IA number 2, dated 8/10/2025. Sir. Kindly see page number 51, sir. That is on the not record.
Sir, why you are aggrieved by the order dated 30/10?
Because my copy was not served on me and no objection.
What is the order passed?
IA. So not to, what are the steps taken by the Wadi ಅವರು ವಾದಿ ಸಲ್ಲಿಸುವ ಮಧ್ಯಂತರ ಪುರಸ್ಕರಿಸಿ ಕರ್ನಾಟಕ ಸೌಹಾರ್ದ ಸಹಕಾರಿ ಕಾಯ್ದೆ 1997 ಕಾಲಂ 41 ಸರ್ಕಾರ ಸ್ವಾಮಿ.
What is that you are reading?
Impugned order, ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ?
76 page number 10/9 is not the impugned order which I have challenged it. I have challenged that 30.
Annexure F you are challenging.
Oh, sir. That was passed with regard to the application number 2, IA number 2, page number 51, sir.
This is dated?
This is dated 30/7, 30th.
10, my lord.
10, sir.
Page number 71.
2025.
Same day.
Same day, sir. That is connected with page.
So IA2 was allowed.
Kindly see that page number 51, sir. 51, sir.
51.
Oh, sir. As per them, IA2 is, this is the IA2.
51 application, my lord. Order is, my lord.
Page number 51. Sir. This is the application 8/10/2025. Sir. Now kindly see that order.
All further actions.
Kindly see the order sheet for me now. With regard to 8/10 ಪ್ರಕರಣ ಕಳೆಯಿತು. ವಾದಿ ಪರ ವಕೀಲರು ಹಾಜರಾಗಿದ್ದಾರೆ. ಪ್ರತಿವಾದಿ ಗೈಜ ಹಾಜರಾಗಿದ್ದಾರೆ. ಪ್ರತಿವಾದಿ ಪರ ವಕೀಲರಾದ ಎನ್ಡಿ ಅವರು ವಕಾಲತ್ ಸಲ್ಲಿಸುತ್ತಾರೆ. ದಿನಾಂಕ 19ರಂದು ಹೊರಡಿಸಿರುವ ತಡೆಯಾಜ್ಞೆಯನ್ನು ಮುಂದುವರಿಸಿದೆ. ಪ್ರತಿವಾದಿ ವಕೀಲ
ಯಾವುದು ಓದ್ತಾ ಇದ್ರಿ ಅಂತ ಹೇಳಿದ್ರೆ ನಾನು
ಪೇಜ್ ನಂಬರ್ 68, sorry. 68. Because you connect to that application dated 8/10, order sheet is there, sir. 8/10. 8/10 also. Here, that application, they have filed it, not been mentioned, nor my copy was served. There is a grievance to me. Yesterday, senior counsel has submitted, that is the aspect. If they have taken on record and given me copy, then objection I have filed.
8/10, my lord. Their sort.
Actual justice, they have not followed it.
Kindly see, my lord. 8/10, their sort.
Minimum justice. Kindly see the order sheet, sir.
In the meantime, what should happen to your resolution after receiving this?
That I have kept it, the order and modulus, because they have stayed the matter. I have kept that matter like.
I will set aside this order. And also, you are not supposed to go
further. I'll take any further action.
Now the dispute is still pending.
House.
Before?
Yes. Before RCS, JRCS.
Yes.
Savarda, joint register.
Both of you go and agitate the matter.
That is.
Yes.
Only
Yes,
one
Mr. Rajesh.
submission, my lord. The reason for these activities, actually the present president has been.
I will not go into the merits of the case because the matter is still pending.
Much obliged.
Before respondent number 1.
Yes, my lord.
I will not make any observation regarding the merits of the case.
Much obliged.
Much obliged.
Per contra, when counsel for respondent number 2 opposing the submissions made by the petitioner contended that the order of stay order of stay was granted on which
That
day?
is annexure rep, sir. 30 sir.
ಎಲ್ಲರೂ ಇದು
Page number 77. sir.
ಅದಲ್ಲ earlier stay I am asking, which was communicated to you on
10/9 sir.
10/9.
Also. IA number 1 sir.
Page number 67.
10/9, 10/9.
Granted on 10/9/2025. Preventing the respondent number 2. Order of stay of the show cause notice issued by respondent number 2 was communicated it on 15/9/2025 by 10:45 AM.
Moreover, appealable order, my lord, this is because my lord, section 41 of the act, so are that also there.
ಇಲ್ಲ appealable ಅಲ್ಲ.
41
It is decided. I'll give judgment. Appealable
In
ಅಲ್ಲ.
spite of
Is
that,
IA.
respondent number
ಅಲ್ಲ
2
ಬಿಡಿ ನಾನು
proceeded
ಗೊತ್ತಿಲ್ಲ ಕೊಡ್ತೀನಿ judgment.
to pass
ಇಲ್ಲಿ ನಮ್ಮ ಕರ್ನಾಟಕ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. BC ಪಾಟೀಲ್ ಅವರೇ.
an order dismissing the petitioner from service
46 ಅಲ್ಲಿ ನೀವು ಹೇಳೋದು.
on the very same day in the afternoon that shows the conduct of respondent number 2 in passing the order hurriedly without affording any opportunity to the petitioner to respondent number 2. The respondent number 2 taking into consideration these facts, respondent number 1 passed the order as per annexure F. If there is no illegality in the said order, hence prays for dismissal of the petition. What is your contention?
Lord, my first contention is, my lord, to regarding the
AGA for respondent number 1.
to appealable order under section 46 of the, my lord, Savarda Act.
14 submitted that under section 41.
46, my lord, appealable of the Karnataka Savarda Sakari Act 1997. This is, my lord, not Cooperative Societies Act, it is Savarda Act.
Savarda Act.
That is one submission. Another submission, my lord, as per the submission made by the respondent number 2, the order is passed in the morning session itself they have given. Still, my lord, they will, on the merit, my lord, I am not say anything because, my lord, lordship.
No, morning and they are ಹೇಳ್ತೀರಿ.
Please, my lord.
Why you are saying that it was passed in the morning?
To regard, no. So their submission communication is, my lord, recorded say that, my lord, society itself received, my lord, 10:45. That is the reason, my lord, I submit that. I am not going to the merit of the case.
10:45 it was communicated.
Please, please.
Order of stay was
Please,
communicated.
please.
At what time the meeting was held?
My lord, that
4
4 PM, my lord, that is the reason, my lord, is a disputed fact.
Whenever a meeting is called,
Please,
definitely the timing will be mentioned.
please, please, please. Lord, that is the reason, my lord, it is disputed fact, my lord. I can't, my lord, but to say that warning and but I am saying that only
Fortunately, the manager of the
Society.
petitioner
Please.
specifically mentioned at
45.
10:45
Please,
AM.
please. On that is only my submission, my lord. I am not going to the merit of the case.
AGA, opposing the petition only submitted that the order impugned is an appealable order under section 46 of
46, my lord, Karnataka Savarda Sakari Act 1997.
However, on merits, he has not addressed any arguments. As the dispute is still pending consideration before respondent number 1. On perusal of the materials and reports, is same, but the show cause notice was came to be issued by the petitioner to respondent number 2 on 8/9/2025. On 10/9/2025, the dispute was raised by respondent number 2 with respondent number 1. However, on 15/9/2025, the meeting of the board of directors of the petitioner was convened and the decision is taken to terminate the membership of respondent number 2. It is pertinent to note that respondent number 2 has produced a copy of the letter dated 15/9/2025 communicating the order of stay passed by respondent number 1 against the petitioner. Staying the notice dated 8/9/2025 as per the endorsement seen on the copy of the letter. The same was served on the manager of the petitioner society up to 10:45 a.m. There is no materials that are placed before the court as to at what time the meeting of the board of directors was convened and the decision to terminate the membership of respondent number 2 was taken. Obviously, it must be after service of the order passed by respondent number 1 communicated to the petitioner after 10:45 a.m. Next, the materials on record in the light of the argument addressed by both the parties and consideration of annexure F discloses that respondent number 1 has hurriedly proceeded to pass the order annexure F without providing the copy of the application to the petitioner and to have his say in the matter. By the time annexure F was passed, the order terminating the membership of respondent number 2 was already passed. Taking into consideration all these facts and circumstances, and also the fact that the dispute is still pending consideration before respondent number 1, I am of the opinion that it may not be proper on the part of this court to discuss about the merits of the case. It is suffice if the impugned order annexure F is set aside, and at the same time directing the petitioner not to take any further decision in the matter during the pendency of the dispute before respondent number 1. Then counsel for the petitioner fairly consider. Then what is that you said? You are not acting upon the respondent.
My lord, one submission. Sorry for interference.
That the petitioner will not precipitate the decision of the board of directors taken to terminate the membership of respondent number 2 till the dispute before respondent number 1 is decided. The same is placed on record. Yes, what is that?
La membership ತೆಗೆದ್ರೆ ನಮಗೆ ನೆಕ್ಸ್ಟ್ ಎಲೆಕ್ಷನ್ ಕಂಟೆಸ್ಟ್ ಮಾಡಬಾರದು ಅಂತ that is why they have removed my membership, my lord.
Then
next
you
February,
have to expedite the dispute. Expedite the dispute. Don't keep it pending.
Yes, my lord. But
immediately
at
ask
least,
the respondent number 1.
At least membership may be continued. Membership may continued. The same membership number.
It is needless to say. It is needless to say that respondent number 1 shall dispose of the dispute, decide the dispute expeditiously, at least within
3 months, my lord, though both are cooperative, my lord, we will consider.
within
So in February election is there. If membership gone.
before that.
Please.
Before ಅದು ಹಾಗೆ ಹೇಳ್ಬೋದಾ ಬಿಫೋರ್
Please,
ನೆಕ್ಸ್ಟ್
please.
ಎಲೆಕ್ಷನ್
ಅಲ್ಲ till my
Before
submission,
January
my
month.
lord, till disposal
Within 2
that the
months.
membership may kindly be continued, my lord.
from today with the cooperation from both the parties.
Please.
Cooperate. Yes. Accordingly, we proceed. The petition is allowed. Next, we have to dash to respondent number 2. Sorry, petitioner is directed not to precipitate on the decision taken on 15/9/2025 terminating the membership of respondent number 2. Being the dispute is decided, respondent number 1 is directed to dispose of so and so expeditiously. Yes.
Much obliged.
15, KP from Ravindranath.
15.2, my lord, LR application has been filed and ಅದಲ್ದ ಒಂಚೂರು ಅದ್ರಲ್ಲಿ HS ರೇಖಾ ಅಂತ ಬರೋ ಬದಲು HS ರೇಣುಕಾ ಅಂತ ಆಗೋರಿ ಸೊ ಐ ಆಮ್ ಸಾರಿ
ಏಕಾಂಗು ರೇಣುಕಾ ವ್ಯತ್ಯಾಸ ಗೊತ್ತಾಗಲ್ವಾ?
ಸಾರಿ ಮೇಡಮ್, ಐ ಆಮ್ ಸಾರಿ. ರೇಣುಕಾ ಅದು ಟೈಪಿಂಗ್ ಅಲ್ಲಿ ಏನಂದ್ರೆ ನಮ್ಮ ರೇಣುಕಾ ಮ್ಯಾಮ್ ಬಂದ್ಬಿಟ್ಟಿದೆ ಅಂತ ಕಾಣುತ್ತೆ ಬೈ ಮಿಸ್ಟೇಕ್ ಇನ್ ಆಫೀಸ್. ಸಾರಿ.
Waiting service ಏನಾಯ್ತು ಇದು? LRs of deceased.
First 15.2, my lord, 15.2. How so?
Wait service of notice in respect of legal representatives of deceased respondent A and B ಏನಾಗಿದೆ? Still awaited.
ಅದ
ಎಲ್ಲಿ 15.2 ದಲ್ಲಿ ಕಾಸ್ಟ್ ರೈಟ್ಲಾ?
ಇದ್ರಲ್ಲಿ ಸ್ವಾಮಿ, ಅದ್ರಲ್ಲಿ ಕಾಸ್ಟ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ರೇಣುಕಾ ಅಂತ ಟೈಪ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಮಾಡ್ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ, ಇಲ್ಲೇ ಮಾಡ್ಕೊಡ್ತೀನಿ. ಐ ಮೇ ಪರ್ಮಿಟೆಡ್ ಟು ಡೂ ದಟ್.
ಏನ್ ಮಾಡ್ಕೊಳ್ಳೋದು ಏನು ಅದು ಅಷ್ಟು ಈಸಿನ? ನೀವು ಬೇಕಾದಂಗೆ ಕರೆಕ್ಷನ್ ಮಾಡ್ಕೊಂತ ಹೋಗೋದಾ? ಅಯ್ಯೇ ಕೊಡಿ. That is Srimati H.S. Rekha.
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 House.
Learned counsel, so and so, or his report. Submits that in the application, year 3 of 2025, filed under Order 22, Rule 3 and 4 of CPC. The legal representative, first legal representative of deceased respondent is referred to as Srimati H.S. Renuka, but it should be Srimati H.S. Rekha.
Please.
Rekha. Next, learned counsel for the petitioner submits that by mistake the name is mentioned as Renuka, and he seeks permission to correct the said name as H.S. Rekha, for which counsel for respondent has no objection. Counsel for the petitioner is permitted to correct the name of H.S. Renuka into H.S. Rekha in the application. Next.
These applications may be allowed, my lord, so that I'll bring the.
No objection. Then counsel for Akila inna. So and so undertakes to file wakalat for proposed respondent number 1A and B, 1A and B, and submits no objection to allow IA 3 of 2025. Office is directed to show his name in the cause list. For the reasons stated in so and so, IA 3 of 2025 is allowed. The proposed Respondents are ordered to be brought on record as respondent number 1, A and B.
I'll file the amended.
Counsel for the petitioner is permitted to carry out the amendment and to file the amended cost title.
Much of it.
Await service of notice.
ಇಲ್ಲ ಅದನ್ನೇ ವಕಾಲತ್.
Yes. List of points.
Interim order may kindly be extended.
ಏನದು?
Other two
1
applicants.
to 3.
Please.
1 to 3. Delay condoned, abatement set aside, brought on record. Huh?
Interim.
One ಏನು ಅಂತ ನೋಡಿ. Delay is condoned. ಆಮೇಲೆ abatement set aside, brought on record as respondent number 1, A and B. Interim order ಇದ್ರೆ extend ಮಾಡಿ. Yes.
Please.
You have to correct that application
ಈಗಲೇ ಮಾಡ್ಕೊಡಿ.
and amend the cost title.
Please.
And file the amended cost title.
Please.
ಮತ್ತೆ mistake ಅಂತ
ಇಲ್ಲ ಮಾಡಲ್ಲ. Interim order may be kindly. Much of it.
ಹಾಕಿ.
Serial number 16. Amendment.
ಅಲ್ಲಿ ಅಂಡರ್ಟೇಕ್ ಬೇಡ, ಫೈಲ್ ವಕಾಲತ್ ಅಂತ. Yes.
Please.
Challenge the 18B may be passed over the lordship. It is being upheld by the division bench also. 18B, they have challenged the virus of the 18B, my lordship. It is being upheld by the division bench.
ಅಲ್ಲ 18B ಅಲ್ಲ ಏನಾಗಿದೆ ನಾವು 18B may not be much of relevance, my lord, because of the now ensuing election to the second prayer, my lord. Second,
my lordship, is already the.
No, what about first prayer B?
First prayer is 18B.
18B. Lord,
It is already upheld.
It's already upheld, my lord.
Then why you are seeking that relief?
My lord, now the my second prayer, my lord.
Second prayer ಗೆ ಬರೋಣ ಸರ್. First one ಏನು?
18B is upheld, my lord. 18B.
Then what is to be done now?
My lord, kindly see. Annexure H.
Sir, simple sir, don't complicate this.
Please.
Now since the virus of 18B is upheld.
Please.
Now what is to be done with regard to your prayer?
18B, I may not be pressing the.
ಅಷ್ಟನ್ನು ಹೇಳಿ.
Please.
ಅದು ಬಿಟ್ಟು come to page
Please.
number ಅನ್ಬೇಡಿ.
Please.
Counsel for the petitioner submits. But since virus of section 18B of Karnataka State Cooperative Societies Act 1959 is already upheld by the coordinate bench of this court, he is not pressing prayer B in the prayer column. Submission is placed on record. Prayer B, small b, bracket. Seeking to strike down the provision of section 18B of Karnataka State Cooperative Societies Act 1959. And to declare the same as unconstitutional is rejected as not pressed. Office is directed to take note of the same. Then what is the prayer B?
Lord, prayer B, Lord. Lord, the
Communication, impugned communication. What is annexure H?
Annexure H, my lord, is the communication issued by respondent number 3 to the election commission, page 49.
49. 49.
Please.
49. ಇರೋದೇ 38 pages ಇದೆ 49 ಅಲ್ಲಿ.
I'm sorry, my lord, matter was a translated copy.
34.
Please, annexure H, my lord.
Yes.
Please. ವಿಷಯ ಕಾರ್ತಿಕೇಶ್ವರ ಪಿಕಾರ್ಡ್ ಬ್ಯಾಂಕ್ ಕಡ್ಡೂರು ಇದರ ಆಡಳಿತ ಮಂಡಳಿ ಅವಧಿಯು ಮುಕ್ತಾಯಗೊಂಡು ಆಡಳಿತಾಧಿಕಾರಿ ನೇಮಿಸಿರುವ ಹಾಗೂ ಮತಕ್ಷೇತ್ರ ಖಾಲಿಯಾಗಿರುವ ಬಗ್ಗೆ ಸಹಕಾರ ಸಂಘಗಳ ಉಪನಿಬಂಧಕರವರ ಕಾರ್ಯಾಲಯ ಬಳ್ಳಾರಿ ಇವರ ಪತ್ರ ದಿನಾಂಕ 16/6/20. ಮೇಲ್ಕಂಡ ವಿಷಯ ಮತ್ತು ಉಲ್ಲೇಖಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕಾರ್ತಿಕೇಶ್ವರ ಪಿಕಾರ್ಡ್ ಬ್ಯಾಂಕ್ ನಿಯಮಿತ ಸಂಡೂರು ಬಳ್ಳಾರಿ ಜಿಲ್ಲೆ ಇದರ ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರ ಅಧಿಕಾರಿ ಅವಧಿಯು 16/6/2021 ಅಂತ್ಯವಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಜೂನ್ 21ರಲ್ಲಿ ಅವಧಿ ಮುಗಿದಿರುವ ಸಹಕಾರ ಸಂಘಗಳ 21-22 ರಿಂದ 25-26 ಅವಧಿಗೆ ಜಿಲ್ಲಾ ಚುನಾವಣಾಧಿಕಾರಿಗಳು ಹಾಗೂ ಸಹಕಾರ ಸಂಘಗಳ ಜಂಟಿ ನಿಬಂಧಕರು ಕಲಬುರಗಿ ಪ್ರಾಂತ ರಾಯಚೂರು ಇವರು ಚುನಾವಣಾಧಿಕಾರಿ ಹೊರಡಿಸಿರುತ್ತಾರೆ, ಅಧಿಸೂಚನೆಯನ್ನು ಹೊರಡಿಸಿರುತ್ತಾರೆ. ಆಯುಕ್ತರು ಚುನಾವಣೆ ಪ್ರಾಧಿಕಾರ ಬೆಂಗಳೂರು ಸುತ್ತೋಲೆಯಲ್ಲಿ ರಾಜ್ಯದ ಎಲ್ಲಾ ಪ್ರದೇಶದಲ್ಲಿ ಕೋವಿಡ್-19 ಸಾಂಕ್ರಾಮಿಕ ರೋಗವು ಹರಡುತ್ತಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ 2021ನೇ ಸಾಲಿನಲ್ಲಿ ಸಹಕಾರ ಸಂಘಗಳಿಗೆ ನಡೆಯಬೇಕಾಗಿದ್ದ ಚುನಾವಣೆಗಳನ್ನು ಮುಂದಿನ ಆದೇಶದವರೆಗೆ ಮುಂದೂಡಲಾಗಿರುತ್ತದೆ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ 16/6/21 ಶ್ರೀ ಕಾರ್ತಿಕೇಶ್ವರ ಪಿಕಾರ್ಡ್ ಬ್ಯಾಂಕ್ ಸಂಡೂರು ಇದರ ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರ ಅವಧಿಯು ಮುಕ್ತಾಯಗೊಂಡಿರುವುದರಿಂದ ಬ್ಯಾಂಕಿನ ದಿನನಿತ್ಯ ಕೆಲಸ ಕಾರ್ಯಗಳನ್ನು ಮುಂದುವರೆಸಿಕೊಂಡು ಹೋಗಲು ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ 1959 ಹಾಗೂ ಉಲ್ಲೇಖರ 3ರ ಸಹಕಾರ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ ಸೋಂಸೋ ರೀತ್ಯ ಸಹಕಾರ ಸಂಘಗಳ ಉಪನಿಬಂಧಕರು ಬಳ್ಳಾರಿ ಜಿಲ್ಲೆ ಬಳ್ಳಾರಿಯವರು ಕಾರ್ತಿಕೇಶ್ವರಿ ಪಿಕಾರ್ಡ್ ಬ್ಯಾಂಕ್ ಸಂಡೂರು ಇದರ ಆಡಳಿತ ಮಂಡಳಿ ಸ್ಥಾನದಲ್ಲಿ ಶ್ರೀ ಶರಣಬಸಪ್ಪ ಸಹಕಾರ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಯವರನ್ನು ಆಡಳಿತಾಧಿಕಾರಿಯನ್ನು ದಿನಾಂಕ 17/6/21ರಂತೆ ಅನ್ವಯವಾಗುವಂತೆ 3 ತಿಂಗಳ ಅವಧಿಗೆ ನೇಮಿಸಲಾಗಿರುತ್ತದೆ. ಸದರಿಯವರು 17/6/21ರಂದು ಆಡಳಿತಾಧಿಕಾರಿಗೆ ಪ್ರಭಾರ ವಹಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. ಶ್ರೀ ಕಾರ್ತಿಕೇಶ್ವರ ಪಿಕಾರ್ಡ್ ಬ್ಯಾಂಕ್ ನಿಯಮಿತ ಸಂಡೂರು ಇದರ ಅಧ್ಯಕ್ಷರಾದ ಶ್ರೀ ಜೆ.ಎಂ. ವೃಷಭೇಂದ್ರಯ್ಯವರು ಬಳ್ಳಾರಿ ಮತ್ತು ಕೊಪ್ಪಳ ಮತಕ್ಷೇತ್ರದಿಂದ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಸಹಕಾರಿ ಕೃಷಿ ಮತ್ತು ಗ್ರಾಮೀಣ ಅಭಿವೃದ್ಧಿ ಬ್ಯಾಂಕ್ ನಿಯಮಿತ ಬೆಂಗಳೂರು ಇದರ ಆಡಳಿತ ಮಂಡಳಿ ನಿರ್ದೇಶಕರಾಗಿರುತ್ತಾರೆ. ಸದರಿ ಪಿಕಾರ್ಡ್ ಬ್ಯಾಂಕಿನ ಆಡಳಿತ ಮಂಡಳಿಯು ಇಲ್ಲದಿರುವುದರಿಂದ ಶ್ರೀ ಜೆ.ಎಂ. ವೃಷಭೇಂದ್ರಯ್ಯವರು ಪ್ರಾಥಮಿಕ ಬ್ಯಾಂಕಿನಲ್ಲಿ ನಿರ್ದೇಶಕರಾಗಿರುವುದರಿಂದ ಈ ಪ್ರಕರಣದಲ್ಲಿ ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ 1918(1) ನಿಯಮ ಹಾಗೂ ಬ್ಯಾಂಕಿನ ಬೈಲಾ ಸಂಖ್ಯೆ ಅನ್ವಯವಾಗಿ ಮತಕ್ಷೇತ್ರ ಖಾಲಿಯಾಗಿರುವುದರಿಂದ ಮುಂದಿನ ಕ್ರಮಕ್ಕಾಗಿ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಲಾಗಿದೆ. Lord,
now what had happened? Why you are saying that it has become
infectious? That is
Now already the administrator has a and this annexes with now.
Whether election is held?
Election now they have 1 month more, my lord, for the election to be conducted for the respondent number 27/12 next month 27.
Then why you are maintaining this petition, sir?
My lord, that is what, my lord, now the annexure H, my lord, in principle requires to be my respectful submission. My lord, it requires to be quashed because now the calendar of events, my lord, they get to be.
No, if this order is to be quashed, who will be in charge of the society?
Society. This order, my lord, what
Board is not in existence now.
It is in existence.
No, board is not, it is also expired, my lordship.
Administrator was appointed.
Administrator was appointed, subsequently election were conducted. I am an elected representative.
When election was held?
In December, my lord, December 2021.
27/12.
December 2021 election was conducted.
That is so, automatically this will go. The board comes into picture.
Yes.
Where is the question of administrator continuing?
That is not, administrator is no more continuing.
So your petition is infructuous then? Why you are seeking the quashing of annexure H? If fresh election is already held after appointment of administrator.
It is held, my lord, I am the present president.
Then the board, the duly elected members take charge.
Yes.
Where is the question of
and I am continuing to be the director of respondent number 3
why
society.
You are seeking this misconceived idu?
Because of the subsequent event.
Yes. Automatically ಹೋಗುತ್ತಲ್ಲ elected representative ಬಂದ್ಮೇಲೆ. Do you mean to say administrator will continue?
No. Administrator will. I am the present.
Then why you are seeking such a relief, sir?
Yes.
ಆಯ್ತು ಇದು subsequent events.
Please, subsequent event because I have been elected subsequently.
Yes. No, admittedly, the election is already held. Then where is the question of administrator being in? No, his prayer is to quash annexure H. Prayer ಏನಿದೆ? Declaring the same is illegal ಅಂತ.
ಇಲ್ಲ. Annexure is a communication, my lord, by the
Now, according to you, the petition is still maintainable? Then? I don't know. What is your stand? What is your stand? Tell me. ಅದನ್ನೇ ಅಲ್ವಾ ನಾನು ಹೇಳ್ತಾ ಇರೋದು. ಹಾಗೆ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಅಂದ್ರಿ. Heard ಬೇಡ. Then it counsel for the petitioner. I'm learned so and so for respondent. You are for respondent number? 1, 2, 4. ಇಲ್ಲ 1, 2, 3. 1, 2, 3. 1 and 2. Submit that subsequent to annexure H, the election was held. Election is held to respond. Election is held to respondent number 3 is bank.
5.
Respondent 5. So
Please.
Respondent number 5 bank. And the elected representative have taken charge of the bank. And in view of the same, the petition is rendered infructuous. Submission is placed on record, petition is dismissed as the same is rendered infructuous. Yes.
But the elected may, the elected representative, that is the petitioner, my lord, is been elected.
ಇದ್ರೆ ಅವರೇ ಆಗ್ತಾರೆ, ಮತ್ತೆ ಯಾರು?
Yes, please.
Yes.
Serial number 17, Rakesh P. Bhatt, R.A. Devanand.
Hearing for petitioner in this case.
Yes. ಏನಿದೆ?
Lord. In
No instructions. No instructions. ಆಯ್ತು, ಏನಾಗಿದೆ ಅನ್ಸುತ್ತೆ? When you have written? ಅದಿರುತ್ತೆ. ಸರ್ ಒಂದು ಸ್ವಲ್ಪ ಪ್ರೋಬೋನೋ ಮಾಡಿ ಇರ್ಲಿ. Represent respondent number 4. Yes.
Lord, annexure P, page 301. Lord, WP number 23354 of 2021. My lord, 2 connected matters are there.
23354.
Please,
of
Lord.
2021.
Please. What is challenge is, my
Why
lord,
two writ petitions?
two writ petitions are filed.
Why?
Lord, the brief facts of this case, my lord.
Yeah, I'm asking you why 2 writ petitions?
My lord, by 2 writ petitions, 2 independent orders are there. Connecting, I mean to say, my
Petitioner
lord,
is same in the.
no, my lord, petitioners are different. But challenging the action of this third respondent in both the cases. Petitioners in both the petitions are members of fourth respondent society.
ಇದು ಕಿತ್ಕೊಂಡು ಬರ್ತಾ ಇದೆ. ಇದು ಕಟ್ಟಾಗಿ ಹೋಗಿದೆ, ಹೋಗ್ತಾ ಇದೆ. Yes, who are these petitioners?
They are the members of the fourth respondent society who are awaiting, my lord, allotment of site by the fourth respondent society. If I may be permitted to tell in brief, just, my lord, as to why this litigation
Yes.
arose. Lord, fourth respondent society was formed, my lord, for development of sites and to allot to its members. As per the bylaw of the society, my lord, once they form a layout and call for applications, they were required to prepare a seniority list and thereafter get it approved by the registrar of the cooperative society and had to allot it on the basis of that.
Yes.
They did not do so. On lottery basis, my lord, they issued for some persons without seniority, whoever they wanted to, they allotted the sites. This issue, my lord, came before this honorable court in independent litigation, my lord, between two members of the society, as per Annexure C, page 39. Annexure C, page 39 was a dispute between two members as to who is the owner of the site. But, my lord, the relevant portion,
Page number?
page number 39, my lord. Respondent number 4 herein is respondent number 2 before in this case.
Yes.
Lord, kindly take, my lord.
Yes.
Page 55. It was an independent dispute between two allottees, but court noticed that lot of irregularities are there in the functioning of the society and ordered the registrar of cooperative society to hold a detailed inquiry regarding the functioning of the society. Page number 55. Para number 20, my lord. Apart from this, the registrar of cooperative societies in Karnataka, on whose behalf this first respondent has acted, is hereby directed to hold detailed inquiry into the affairs of the society, particularly in the matter of allotment of sites in favor of its members, manner in which amounts collected and the manner in which such sites have been allotted in favor of the members, and if any manipulations of the records of the society in respect of such allotment, and to ensure proper remedial measures are taken under the provisions of the Act by issue of notice to such persons and by identifying the responsible and guilty persons for action.
Yes.
There was another direction also given to hold similar inquiry by the tribunal also. And this order was challenged by the society before the division bench, my lord, Annexure D, page 57.
R4.
R4.
Yes.
The relevant portion, my lord, is at annexure at page number 65. The writ appeal was partly allowed, but the court upheld the direction given by the learned single judge of holding inquiry by the registrar of cooperative society. 65, my lord.
Yes.
The writ appeal is allowed in part. The direction issued by the learned single judge directing the registrar of cooperative society to hold inquiry as per order passed by the learned single judge dated 24/11/2008 is confirmed. However, inquiry ordered to be held by Karnataka Appellate Tribunal against the appellant society is set aside.
Yes.
Lord, under Karnataka Cooperative Societies Act, my lord, Section 64, my lord, gives power to the Registrar of Cooperative Society to hold inquiry regarding the functioning of the society. Exercising that power, Lord, Registrar held an inquiry under Section 64, and any directions to be issued will be issued, my lord, under Section 68 of the Act. That directions were issued as per, my lord, Annexure E, page 66.
Inquiry was held by the
Inquiry
registrar.
was held by the Registrar of Cooperative Society. Around 20 charges were framed. And, my lord, a detailed inquiry was held after giving opportunity to the respondent number 4 society. And for each charges, my lord, a registrar gave direction as to these are the remedial measures that you have to take and this have to be done.
Illegal.
Annexure E, page 66.
ಇದೇನು enquiry report?
Enquiry Section 68 order. ಆ enquiry report ಆದ್ಮೇಲೆ what is the direction ಅಂತ kindly take, my lord, I will show just one, my lord, of similar. Page number 74. E kacheri. 74, my lord. For example, ಆರೋಪ ಒಂದು ಹೇಳೋದು 68 ಅಲ್ಲಿ ಸ್ಟಾರ್ಟ್ ಆಗತ್ತೆ. ಅದರದ್ದು discussion, what is the objection filed by the respondent number 4 society, and finally what is the inquiry officer's report, and what is the direction given by the registrar of cooperative society. For each charges it is there. Number.
Yes.
This Section 68 direction, my lord, is in the nature of an order that has to be complied by the society. Either it has to file an appeal or it has to comply this society. My grievance, my lord, before I take, my lord, through documents, with respect to this 20 charges, what happened? The society first gave an explanation to the Section 64 inquiry as to why these charges is not proper. The registrar negated those contentions and said that, look, no, you have not done properly, so you have to comply with these things. As a compliance report to that, my lord, first it filed a compliance report, giving the same reasoning as to what similar contentions that it had taken earlier. The third respondent who was there, my lord, he rejected that contentions and once again directed them to comply it. Once again, after 2 years, one more complaints report was filed with similar contention. Second time also it came to be rejected by the third respondent. Now, third time, my lord, after this, a secretary of the society files an appeal against this order of rejection. That came to be rejected by the appellate authority. After this, the third complaints report is filed verbatim similar, my lord. This complaints report is accepted by the society and charges are dropped. That is what I have challenged before this honorable court, that just because an officer changes there, my lord, he does not assume the power of review. And compliance report, what is earlier rejected twice.
This compliance report was filed and when it was rejected.
Please, my lord, that now I will take one.
The dates and events
ಮಾಡಿದ್ದೇನೆ. In synopsis, my lord, it is there. I can first compliance report, my lord, is dated 27/3/2014.
27/3/2014.
And its rejection, my lord, is Annexure G, page 162. That is dated, my lord, 11/7/2014.
Annexure
G, page 162.
Then
The second compliance, my lord, dated 12/4/2016. Annexure J, page 184.
When it was.
And
rejected.
that came to be rejected, my lord, on 18 to 2017, page, annexure K, page 112, my lord.
Thereafter, appeal.
Thereafter, an appeal is also filed, my lord, annexure L, page 243. By the secretary of the fourth respondent society.
When the
That
appeal
is
was
rejected on 19/6/2017.
filed. When the appeal was preferred.
The appeal was preferred, my lord, 2016-17. My lord, appeal 15/4/2017.
15.
15/4/2017.
Appeal was.
Appeal was rejected on 19/6/2017.
Rejected by.
By second respondent, by upper, the additional registrar of cooperative society, my lord. Annexure L, page 241. Then, Lord, for initiating proceedings, criminal prosecution against them, Lord, for non-compliance, notice is issued to them.
Who issued notice?
The third respondent. Order is passed to file FIR and that is passed, my lord, on 31/7/2017. Annexure M, page 244. They filed the third compliance report. Now, third, once again, the same compliance report, my lord, on 26/2/2024, 21. Annexure N, page 253, my lord, that is accepted. With respect to certain charges, my lord. Other charges, he says, once again, you have to comply.
Accepted by.
That is submitted, my lord, on 26/2/2024 is when.
4 or 21.
Sorry, apologies, my lord, 21. 26/2/2021, it is submitted. Third compliance report is submitted, my lord.
That was accepted.
That was accepted on 25/10/2021.
By whom?
By the third respondent. Different officer, but the authority is third respondent. On 25/10/2021.
25.
10/2021. In respect of few of the charges, my lord, not all. With respect to other charges, the same explanation what was given earlier, my lord, he did not accept it. They gave one more compliance, my lord, report. That is the second petition, my lord, what we filed, my lord. By order dated 23/3/2022, the same officer accepts the for other charges also, he accepts the compliance report and drops all the charges.
No, this acceptance report 2510 annexure.
Annexure P, my lord, page 303.
303. ಆಯ್ತು, ಅದಾದ್ಮೇಲೆ ಅನದರ್ ಕಂಪ್ಲೈನ್ಸ್ ರಿಪೋರ್ಟ್.
ಅದು 20 ಚಾರ್ಜಸ್ ಒಳಗೆ ಒಂದು 10-15 ಚಾರ್ಜಸ್ ಗೆ ದೇ ಅಕ್ಸೆಪ್ಟೆಡ್. ಫಾರ್ ಅನದರ್ 5-6 ಚಾರ್ಜಸ್ my lord, they don't accept this compliance report. That was kept pending, and all for others it was dropped. Then once again, the same compliance report is filed with respect to other charges also, the remaining charges. That came to be,
Fourth compliance report.
that is fourth compliance report.
When it was filed.
That was in second petition, my lord. That is when we, that is filed on 6/12/2022, my lord.
6/12/2021.
2021.
21.
Please, my lord.
That was accepted.
That was accepted on 23/3/2022.
22/3.
23/3/2022. That is in the second petition, my lord. That necessitates to file a second petition.
Annexure.
Annexure yes in WP number 9602 of 2022. My lord.
This annexure P is challenged in the first
Writ petition, and annexure yes is challenged in the second writ petition.
What are the grounds?
The grounds, my lord, that section 68 there cannot be an explanation to section 68 order. There has to be only compliance. What contentions they had to take earlier, they have taken it. The same cannot be a ground for dropping of the same proceedings once section 68 order is passed. The direction has to be either appealed and or it has to be complied with. For the purpose of society, my lord, section 68 is like a decree. They have to comply it, my lord. They cannot say that after that order is passed, the very same conditions what, and power of review is not there for the authority when they have already rejected twice. They have already rejected the same explanation and have asked them to comply. Third time, they could not have accepted it. So, my lord, jurisdictional issue as to third respondent did not have jurisdiction to accept the explanation. We could have only seen that whether compliance is there. One charges, my lord, I will show, my lord, voluminous are there. As to how, my lord, the same explanation is given all the time and rejected. And final, my lord, that explanation itself is accepted.
So according to you, the compliance report filed again and again are the same?
Are the same. It is initially what contention they had taken earlier, my lord. It is similar to that contention only they have taken till then. 2 times it was rejected. Third time it is accepted. In
yes.
Right. For example, can you take page 9 of the
So you may have to give a synopsis.
Please, my lord.
Because there are how many charges?
My lord,
8 charges.
8 charges are there, my lord.
What?
In this one petition, example, to show one example, my lord, regarding.
Tell you. See, you make a column.
Please, my lord.
What are the charge? And what is the first compliance report? What is stated in the first compliance
report
with regard to that charge?
That charge.
In the second compliance report.
Please, my lord.
Third.
Please.
And fourth. In third, few explanation is accepted.
Accepted.
Compliance report is accepted.
Accepted.
You mentioned that. And remaining fourth.
Fourth.
What is
Please.
the compliance report or what are the explanation?
I will make.
So that will be
Please,
easy.
my lord.
Otherwise,
I apologize,
it
my
will
lord.
be
I
very
should
difficult.
have done this
Ah.
by now, my lord.
It may not be possible.
1 week time may be granted, my lord. I will prepare
But
that.
make it very simple. Don't
Please.
complicate the issue,
Please, my lord.
right?
Please.
It will be easy to understand and it will be easy to pass orders also.
Please. One week, my lord. I will prepare that chart.
Prepare that. Because you may say the same explanation is given, same complaints report is filed. He may dispute that. So
Please,
and
my lord. I
again
will-
and again, we have
I
to
will,
consider.
with pagination and other thing, my lord, the reference,
Provide a copy to.
I will provide copy in advance.
Heard and counsel for the petitioner. No.
Comparison of last penultimate page of the connection, yes, dropping of charges relating to charge 126 9. The acceptance of other charges of the 11 charges. There is an effective appeal remedy there under 106H.
Why 106 is not in?
Lord, the issue is of jurisdiction here. For this reason, as to whether review itself was permissible. The question was the same authority has already, if that were to be the case, my lord, it is a case where twice the compliance report is rejected, an appeal is filed and rejected. After rejection of appeal, if the same authority can file an
Acceptance is by respondent number 3 alla.
respond number 3,
Joint registrar.
joint registrar.
106 appeal yarige.
No, my lord, the acceptance is by respond number 3, my lord.
Appeal is to
Other authority, registrar.
registrar.
No, additional registrar. For that reason, if that were to be the case, my lord, if appeal remedy, here is a case where twice the joint registrar has an exercise power rejecting his contention of accepting.
See,
And an
facts
appeal
I
is preferred. And an appeal is preferred by this.
Dismissed.
That was dismissed.
Yes.
Now,
So according to you, there is no review.
jurisdiction
power
at
of
all.
Review.
Question of jurisdiction itself is not there, my lord. And jurisdictional issue, my lord, can.
Without jurisdiction, an order is passed. Can it not be challenged? by
Lord, it can
preferring
be,
the
but
appeal?
it can be challenged before this honorable court. And
Sir, why 106 is to be bypassed?
Lord, when Lord, 106 is not bypassed. Lord, the honorable
Have we
Supreme
availed
Court.
that remedy of appeal?
No, I have not availed the available.
Why that is to be bypassed?
I will make submission on that also, my lord. That alternative remedy, appellate remedy,
Remedial or the statutory remedy?
it is statutory. But when jurisdiction itself is not there, if authority
Even
passes
then-
an order,
Even then, see the court, some court passes an order without jurisdiction. What should, you will rush to the High Court? Or you will challenge that in, by filing the appeal?
if it is on
statutory
merits, if it is on merits, my lord, one can understand. If it is the authority, my lord,
remedy. Whatever, sir, whatever. See, suppose the learned civil judge passes an order without jurisdiction. You will immediately rush to the High Court? Or you will approach the senior civil judge? As provided under CPC.
I will make submission on this point also, my lord. Next date of hearing, I will.
If such petitions are to be entertained, why the appeal provision is to be provided, sir? We can assume jurisdiction for anything and everything. Elladu
It is-
226.
Alan,
Yaru bed.
assuming the jurisdiction is different, my lord. It is not assuming.
Registrar bed, registrar bed, yaru bed. We are here.
When these kind of cases are there, where authorities, my lord, kindly see the conduct of the authorities as well.
Why you are not having faith in the system?
But the system itself has shown here as to what.
Madidar, sir, Obba officer hag madidare. Do you mean to say everybody you lose faith in the system itself? Very dangerous situation. Very dangerous situation.
The faith is there before this honorable court.
Fortunately, we are entertaining such petitions.
I will make my submission on this.
See, it is our duty to strengthen the system. ಎಲ್ಲದು ಬಿಟ್ಟು ನಾವೇ ಅಸ್ಯೂಮ್ ಮಾಡ್ಕೊಳ್ತೀವಿ ಅಂತ. 226 all powerful. ನೀವು ಹೇಳಿದ ಕೂಡ ನಮಗೆ ಖುಷಿ ಆಗ್ಬಿಡುತ್ತೆ. Pass an order. Why we should bypass?
None. No, I will make submission.
Do you mean to say the additional registrar is incompetent?
Incompetent,
Then
I wouldn't say.
System ಇದೆ sir, statutorily recognized procedure ಇದೆ. Why that is to, ಇದು 2021 ಇಂದ is pending. Unfortunately. In my view, such practice is to be discouraged. Whenever statutory remedy is available, there is no reason to bypass that. No, you apply your.
I will apply my mind. I will make my submission.
Third learned counsel for the petitioner, in part. Learned counsel, learned so for respondent number 1 to 3, and learned counsel for respondent number 4. Submit in unison that the petitioner has not availed the statutory remedy available for preferring appeal under section 106 of Karnataka Cooperative Societies Act. Counsel for the petitioner placed the time to convince the court regarding maintainability of the petition, bypassing section 106 of KCS Act, and to address his arguments on merits. This time. When it can be posted, nodi yavaga hearing.
Serial number 18, SP Shashidhar, then Ramachandra.
For respondent number 3 in this matter.
Interim order may be extended.
Interim order extends. ಏನಿದೆ ಈ ರೀತಿ ಇದೇನಿದು?
In this case, I'm for the petitioner, madam.
Who produced this? ಇದು enquiry report.
Enquiry report, madam.
ಇದೆಲ್ಲ ಯಾರು produce
I produced the enquiry report.
Sir, this is not the way to produce.
No, my lord.
ಇವೆಲ್ಲ ಗಾಳಿಪಟದಂಗೆ ಹಾರೋಗುತ್ತೆ.
No, my lord. No, my lord. I am producing the enquiry reports along with the charges.
So ಇದೆಲ್ಲ ಬೇಡ.
ಅದು ವಾಪಸ್
ಕೊಡಿ.
ಕೊಡಿ.
ಬೇರೆ ಬೇರೆ ಏನಿದೆ?
ಇದಕ್ಕೇನು ಮೆಮೋ ಗಿಮೋ ಏನು ಇರಲ್ವಾ? ಸರ್ ದಯವಿಟ್ಟು ಮೆಮೋ ಹಾಕಿ ಇಂಡೆಕ್ಸ್ ಮಾಡಿ ಕೊಡಿ. ಇದು ಏನು ಅಂತ ತಗೋಬೇಕು ನಾನು?
ಕೊಡ್ತೀನಿ. In this case, I am for the petitioner, madam. Nagpura Credit Cooperative Society registered under the Cooperative Societies Act is successfully running from last 35 years, my lord. It is A-graded cooperative society and having members 9,727 members, having 3 branches in Bangalore and paying the dividends to the member. Respondent number 3, Ishwarappa, is the one of the member. He contested the election for the post of director and he lost the elections. From the date onwards, he is always filing the complaint before the Registrar of Cooperative Societies. This is the 4th round litigation on the same charges and the same allegations, my lord. Earlier, the Assistant Registrar of Cooperative Society conducted the inquiry. Annexure C, my lord, Annexure C, page number 44, my lord.
Have you filed dates and events in the synopsis?
Yes.
Annexure
C, my lord.
So dates and ಈಗ 4th round litigation ಅಂದ್ರಿ.
ಹೌದು.
So ಅಲ್ಲಿ ಚೆಕರ್ಡ್ ಹಿಸ್ಟರಿ ಇದೆ.
ಹೌದು.
ಅದನ್ನ ಹೇಳ್ಬೇಕಲ್ವಾ? ಹೀಗೀಗ ಆಯ್ತು ಅಂತ.
ಅಲ್ಲ ಬರ್ತೀನಿ ಸ್ವಾಮಿ, ಬರ್ತೀನಿ ಸ್ವಾಮಿ.
ನಾನು ನೋಟ್ ಮಾಡ್ಕೊಳ್ಳಲ್ಲ ಸರ್, ನಾನು ಸುಮ್ಮನೆ ಐ ವಿಲ್ ಹಿಯರ್ ಯು. ಸ್ವಲ್ಪ ಹೋಮ್ವರ್ಕ್ ಮಾಡಿ, ಅದನ್ನ ಹಾಕೋದಕ್ಕೆ ಏನ್ ಕಷ್ಟ ಇದೆ?
ನೆಕ್ಸ್ಟ್ ಟೈಮ್
ಡೇಟ್ಸ್ ಅಂಡ್ ಇವೆಂಟ್ಸ್, ಸಿನಾಪ್ಸಿಸ್ ಏನೇನ್ ಆಗಿದೆ. Is it not easy?
ಆಗ್ಬೋದು. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ
I have to go on writing this.
ಹೌದು.
Why should I do that?
ಹೌದು, ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಆಗ್ಬಿಡಿ ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲ.
It is not a
ಏನಪ್ಪ?
fourth round inquiry. Matters may kindly see the annexure C. The first time on the basis of the complaints, order has been passed to conduct an inquiry under section 64.
ಆಯ್ತು, ನೀವಾದ್ರೂ ಅದನ್ನ ಹಾಕಿ ಅಲ್ಲ.
As they stated before this court, there was no inquiries earlier.
ನೀವೇನಾದ್ರೂ ಹಾಕಿದ್ರೆ ನಾವು ಅವ್ರಿಗೆ ಹೇಳ್ಬೋದಿತ್ತು ಇದಲ್ಲ ಅಂತ.
My lord, one submission, my lord.
I have filed my statement of objection, my lord.
May kindly peruse the writ petition page number 13, my lord.
Will not peruse anything, sir. You come up with the dates and events. Very simple, 1 page or 2 pages. Not more than that. Counsel for the petitioner prays for time to file short synopsis of the dates and events for better appreciation of the material, better appreciation of his contention.
2 weeks.
I list of 2 weeks.
Serial number 19, T.M. Choda Reddy, Jai Prakash Reddy. Connected matter, Varun J. Patil.
Petitioner in this case. Readings are not been completed, my lord. Objections are not been filed.
Lord, 19.2, my name is not, and I already filed wakalat, my lord. 19.2.
For whom?
Respond number 5, my lord.
Yes.
Response 5, Nana.
What about in other petitions?
Petitions, no, my lord. Only for 19.2.
You are not representing any respondent in other part. Yes.
On Jai Prakash Reddy is appearing for 2 cases, my lord. And pleadings has not been yet completed.
No, 19 allu respondent number 5 Jai Prakash Reddy.
How's one?
You are Mr. Reddy?
No, my lord. Nagarajan Naidu.
19.
Number 5, 19.2, respondent 5.
19.2, Basuraj is appearing for respondent.
Basuraj for respondent.
That's society, my lord. Society.
ಇಲ್ಲ ಅವರು 5
ಕ್ಯಾಂಡಿಡೇಟ್ 5 ಗೆ
ಎಲ್ಲಿದೆ ನಿಮ್ಮ ಹೆಸರಲ್ಲಿದೆ?
ತೋರಿಸಿಲ್ಲ ಅಂತ ಅಷ್ಟೇ. ನಂದಿ
ಆಲ್ರೆಡಿ ಫೈಲ್ಡ್ ವಕಾಲತ್.
I filed already ವಕಾಲತ್.
When?
My lord, 24 July 2025 ಜುಲೈ ನಲ್ಲಿ ಹಾಕಿದೆ.
For respondent number 5 in 19.2.
2 application.
But Basuraj ಅಂತ ಯಾಕೆ ತೋರಿಸಿದಾರಲ್ಲ?
ಅಲ್ಲ, that is
for the society.
Society, my lord.
He is for the beneficiary.
Beneficiary is nominee.
Beneficiary na society no member, but he says respondent number 5. ಯಾರು respondent number 5 ನೋಡಿ?
In petition and response.
19.
Nagaraj has to show respondent number 6 as 6.
ಅದರಲ್ಲಿ 19.2 ನಾನು ತಗೊಳ್ಳಿ. ಏನು, what is your name?
Nagarajan Naidu.
Nandish, my lord. Sri
Nandish. Party name is Nandish. He is a respondent number 5.
5. So and so submits that he has filed wakalat for respondent number 5. Office is directed to verify and show his name in the cause list.
Basuraj's name has to be shown as a R4, my lord.
Ali, first he so and so submits that he has filed wakalat for respondent number 5. Well, counsel Sri H.N. Basuraj has filed wakalat only for respondent number 4. This is directed to verify and show the name of Sri H.N. Basuraj for respondent number 4 and so and so Naidu for respondent number 5. The cause list. Matteno? Tell correct agida? Yes. Yes, what is this?
My lord, regarding since pleadings has not been completed, my lord. Pleadings has not been completed. They are not been filed any objection either by the society or by the.
ಅವ್ರಿಗೆ ಬಿಡಿ, ಏನೋ objections ಇಲ್ಲ ಅವರಿಗೆ.
Please, my please. Lord, this is case where, my lord.
How much time you may require?
10 to 15 minutes.
ನಿಮ್ಗೆ?
Regarding, my lord, appointment of nomination, state nomination, my lord, there is assisted by the state. That's the only point, my lord, lordship aware of.
Are they assisted society?
Please, that is the point, my lord.
According to you, it is not the assisted.
It is assisted
It is
society.
assisted.
Assisted society.
What is the dispute now?
According to me, it is not assisted society because by virtue of.
Why you are saying that it is a assisted?
There is no document to show that
Regarding
it has been
my lord,
assisted society.
ಅಷ್ಟೇನಾ ಅದು ಒಂದೇ ಪಾಯಿಂಟ್?
ಒಂದೇ point.
As per the reports, my lord.
Then what is the assistance given by the
My lord,
government?
state government, my lord, has given, my lord, Lord, I will produce the, my lord, that audit report, my lord, to, in respect of all cases.
First read petition ತಗೊಳ್ಳಿ.
Petition.
First one ತಗೊಳ್ಳಿ. 7887.
ಇದೆಯಲ್ಲ ಲೆಕ್ಕ ಪರಿಶೋಧನಾ ವರದಿ ಹಣಕಾಸು ವರ್ಷ 2019-20 ಅವರೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಾರಲ್ಲ.
Regarding, my lord, 1918 is concerned, there are no assistance, my lord. More, earlier, my lord, there is assistance from the state government.
Why it was not produced?
Not produced, my lord, I will produce that, that is the reason. I have it on next week, any date, my lord.
ಬರೀ ಇದೇ ಆಯ್ತು. Counsel for the petitioner and learned respondent pay for time. This time, next.
Interim order may be extended in all cases, my lord.
Yes.
In all cases, same, same.
ಇದ್ರೆ extend. 20.
Same, my lord.
Same.
Please, my lord.
Number 21 Arjun, 52, N. Ramachandra, Suraj Kulkarni.
ಆಗೋಗಿದೆ.
Yes, ma'am.
ಫೈಲ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. Are you filing a memo?
No.
Sorry, learn counsel for the petitioner and yes.
I have filed objections. In that R1 I have shown.
Submit in unison that since the election is already held on
25 to 23.
23, the petition is rendered infructuous. Petition is placed on record, petition is dismissed as the same is rendered infructuous. Yes.
Serial number 23.
My name is shown as R2 government is representing. I am for R3.
ನೀವು R3 ಗ
R3.
ಅದು
I have filed
first ಗೆ
objection.
ತಗೊಳ್ಳಿ. The Gururaj Kulkarni is representing respondent number 3. Office is directed to show his name for respondent number 3 in the cause list. Yes, next.
23, S. Kalyan Basuraj, Dayanand S. Patil.
Counsel for the petitioner is absent, no representation. Next.
Serial number 24 Arjun. 25, H. N. Basuraj.
My lordship, in this 25, they have challenged the interim order, my lordship. Earlier, there was no amended bylaws. Now the bylaw has been amended. It has to go before the same ARCS to decide on the merit. Because ಆ milk produce ಮಾಡೋದು ಆ ಹಳ್ಳಿಗೆ ಸೇರಲ್ಲ ಅಂತಿದ್ದಾರೆ. Now it has been added. It is in favor of the petitioner, they'll decide, my lordship. Now that jurisdiction, it's come under this milk produce. The both jurisdiction are in the same. So now as per the amended bylaw, they have to pass in on merit, my lordship. Only on the interim order, they had come before this court.
Yes, I will look into that, my lords. The recent amendments, my lords. A week's time may be granted, my
Let
lords.
it go before the ARCS, they'll decide on the merit, my lordship.
So for respondents, submits that. In view of the amendment.
Bylaws.
Amendment to the bylaws.
Bylaws, my lordship.
The petition does not survive for consideration and the matter is to be relegated
back to ARCS, my lord. Respondent number 1, my lord.
Respondent number 1 for decision on merits.
Please.
Then counsel for the petitioner prays for time to consider the said position and make his submission. This time. Next.
Serial number 26.
Grateful.
Rakesh P. Bhatt.
I appear for the respondent number 3.
They have not challenged the award. Section 46. They have not challenged. They have challenged the option.
The auction.
No, award is challenged here.
Award is not challenged, Lords.
Lord, award is
Award
challenged.
has already.
Against the award, my lord, there is an alternative remedy of filing an appeal under
Alternative 46 remedy. ಅದನ್ನ ಇಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ.
prayer B is concerned, it has become infructuous, my lord. Auction was challenged and the date of auction is
Why you are
already.
challenging the award before this court?
No, petitioner is not there. He is for respondent.
You are for respondent.
Lord, I am for respondent number 3, my lord.
Yes. For the petitioner is absent, no representation. Then the GA for so and so. You are for respondent number
3, my lord.
3. Submit in unison. ಏನು objections award could not have been challenged before
ಹೌದು,
this.
ಯಾಕಂದ್ರೆ 46 ಅಲ್ಲಿ ರೆಮಿಡಿ ಇದೆ, ಸೆಕ್ಷನ್ 46 of Savard Act 1997.
Challenging the award.
And the auction notification also, it has become infructuous. Now fresh notification has to be issued.
Is not maintainable before this court, as he has to prefer an appeal. He has to challenge the same under section 46. 46 of this.
Savard Act 1997, Karnataka.
What about prayer number 2?
Lord, the auction dated 9/2/20.
ಸಬ್ಜೆಕ್ಟ್ ಟು ಪೇಮೆಂಟ್ ಹೇಳಿದ್ದಾರೆ, ಅದು ಮಾಡಿಲ್ಲ ಕಾಣುತ್ತೆ, ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ.
ಆಕ್ಷನ್ ಇನ್ನೂ ಆಗಿಲ್ವಾ?
ಆಕ್ಷನ್ ಆಗಿಲ್ಲ, ಸ್ಟೇ ಆಗಿಲ್ಲ, ಸಬ್ಜೆಕ್ಟ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಅಲ್ಲ, ಆಕ್ಷನ್ ಆಗ್ಲಿಲ್ಲ. ಆಮೇಲೆ ಆಕ್ಷನ್ ಇಂಟ್ರಿ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ರು, ಕಂಡೀಷನಲ್ ಇಂಟರಿಮ್ ಆರ್ಡರ್, ಅದನ್ನ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಕೇಳಿದ್ರು, ಅದನ್ನು ಕೂಡ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ದಿಸ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್ ವಾಸ್ ರಿಜೆಕ್ಟೆಡ್ ಬೈ ದಿ ಗವರ್ನರ್ ಸಿಂಗಲ್ ಜಡ್ಜ್ earlier.
7/2/2023, an interim order of stay was granted subject to deposit of
20 lakhs within 6 weeks.
ಅದು ಫಿಗರ್ ನಲ್ಲಿ 20 ಇದೆ, ವರ್ಡ್ಸ್ ನಲ್ಲಿ 25 ಇದೆ.
ಅದು ಫಿಗರ್ ನಲ್ಲೇ ತಗೊಂಡ್ರು 20 ಇದೆ, ಅದನ್ನು ಕೂಡ ಡೆಪಾಸಿಟ್ ಮಾಡಿಲ್ಲ.
At least 20 lakhs within 6 weeks from the date of order. However, the said amount was never deposited by the petitioner. Senate Council also submitted that even though the petitioner sought for extension of time for deposit of the amount, the same was rejected as per order dated 23/3/2023.
And
what is the difficulty in proceeding to auction?
Yes, my lord. Subsequently, another auction notification was issued. That against that order, against that auction notification, my lord, another writ petition has been filed, and that is pending consideration, my lord. WP number 14,537.
Subsequently,
yes,
another auction notice was issued, and the same was challenged by the petitioner by preferring WP number
14,537 of 2023.
The same is pending consideration. In view of the same, the writ petition is rendered infructuous.
Please, my lord.
Dispose ಮಾಡಬಹುದಾ?
Yes, sir. Some reason doesn't survive.
Infructuous. Petition is rendered infructuous.
There is another petition, my lord.
That is was subsequently another auction notice.
Another auction.
You have challenged it.
Please,
then why, how your petition is maintainable?
Lord, annexure D, my lord, there is annexure D. Annexure D is the award, my lord.
Barni 230 ಬನ್ನಿ. ಅವಾರ್ಡ್ ಇಲ್ಲಿ ಯಾಕೆ ಚಾಲೆಂಜ್ ಮಾಡ್ತಿದ್ರಿ?
ಅಲ್ಲ, ಅದಕ್ಕೆ ಇನ್ಫ್ರಕ್ಚರ್ಸ್ ಆಗ್ಬಿಟ್ರೆ ಕಷ್ಟ. ಆಲ್ಟರ್ನೇಟಿವ್ ರೆಮಿಡಿ
ಅದನ್ನ ನಾನೇನು ಮಾಡಲ್ಲ. ನಿಮಗೆ ಇಲ್ಲಿ ಹೊಸ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ನಾನು ಯಾವ್ದ್ರಲ್ಲೂ ಕೊಡಲ್ಲ.
No, my lord, but
there you avail that ಅಷ್ಟೇ. ಒಂದು ಎಲ್ಲ ಮಾಡ್ಕೊಂಡು ಇಲ್ಲಿಂದ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ನೋ.
No, it is not cause of action. I had challenged the auction notice if that has become infructuous, my lord.
Correct.
If these two
subsequently, admittedly, another action notice was issued. You challenged it by filing separate writ petition.
Please, my lord.
ಮತ್ತೆ?
No, that is there. So far as auction notice
whether
is
the award could be challenged before this court.
Alternative remedy is there, but
why you came before this court?
I came, but that should not.
What is the alternative remedy?
But I should have filed appeal.
Under?
But before the KAT, I had to go, my lord.
Huh. You bypass KAT.
True, my lord. But if, my lord, my concern is, now I have prayed two prayers.
Sir,
If your
what is
lordship,
the remedy? It is left to you.
at least if that observation is there, my lord, if
Be
that
fair.
is not there, if that is not there, then my lord, already I have challenged this before this honorable court. This honorable court says it has become infructuous if that is there. My lord, I will lose that remedy also.
That is your fate, sir. Then why you chose this forum? Bypassing KAT.
Auction notice was there at that point of time, my lord.
KAT ಏನು ಮಾಡಲ್ವಾ?
KAT
Because ನೀವು ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬೇಕಲ್ಲಿ. ಇಲ್ಲಾದ್ರೆ ಫ್ರೀ ಆಗಿ ಕೊಡ್ತೀವಿ ನೋಡಿ, ಎಲ್ಲ ಫ್ರೀ ಆಗಿ.
ಅಲ್ಲ ಇದು ಕೊಡ್ಲಿಲ್ಲ ಈ ಕೇಸ್ ಒಳಗೆ
ಕಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ.
ಅದಕ್ಕೆ ಖುಷಿ ಅನ್ಸುತ್ತೆ.
ಈ ಕೇಸ್ ಒಳಗೆ ಡಿಪಾಸಿಟ್
ನಿಂತ ಕೂಡಲೇ ನಾವು ಕೊಡ್ತೀವಿ, ಏನು ಕೇಳಲ್ಲ.
I understand, but
You cannot bypass, sir.
no,
Statutory remedy ಏನಿದೆಯೋ ಅದನ್ನ
ಅಲ್ಲ ಸ್ಟ್ಯಾಚ್ಯೂಟರಿ ರೆಮಿಡಿ ಹೌದು ನಾನು.
Yes.
Now, I should not be put in a worse condition than what I am there, my lord. Infructuous.
Who is responsible for your condition? Huh? I am not responsible.
ಅದು ಇನ್ಫ್ರಕ್ಚುಯಸ್ ಆಗಿದ್ರಿಂದ ನಾನು ಅಲ್ಲಿಗೂ ಹೋಗಕ್ ಬರೋದಿಲ್ಲ ಅಂತ.
ಗೊತ್ತಿಲ್ಲ ನನಗೆ. But infructuous ಅಂತೂ ನಿಜ.
ಬರೀ one prayer
See, I cannot grant your first prayer. First prayer, what is the relief claimed in the first prayer? And second prayer, infructuous.
Second prayer infructuous. First prayer, my lord, if it may be kept open, my lord.
ನಾನೇನು ಮಾಡಲ್ಲ. That is left to you.
ಅಲ್ಲ ಅದು infructuous ಅಂತ ಹೇಳಿದ್ರೆ ನಾನೀಗ if I my lord.
ಫಸ್ಟ್ ಪ್ರೇಯರ್ infructuous ಅಂತ ನಾನು ಹೇಳಲಿಲ್ಲ. ದಯವಿಟ್ಟು ಮಿಸ್ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಮಾಡ್ಕೋಬೇಡಿ. Second prayer is rendered infructuous ಅಂತ, that is the submission made by both the learned counsel. Now tell me what should happen to your first prayer?
Either
ಅಲ್ಲಿ ತಗೊಳ್ಳಿ, learned counsel for the petitioner fairly concedes that prayer number 2 in the petition is rendered infructuous in view of issuance of the second auction notice, which is the subject matter of another petition submission. ಅಷ್ಟೇ. Yes, number 1 ಇದೆ.
Number 1 ಗೆ alternative remedy in accordance with law, at least.
ನಾನು ಏನು ಹೇಳಲ್ಲ ಸರ್, ಅವ್ರದ್ದು objection ತಗೊಳ್ತೀನಿ. So and so submits that with regard to prayer number 1, the petitioner has bypassed the statutory remedy to approach a statutory remedy of approaching the Karnataka Appellate Tribunal. Admittedly, there is a alternate efficacious statutory remedy. Hence, the petition does not survive for consideration. Petition is disposed of. Yes.
New petition was, there is urgency in this matter. Reason your lordship has ordered not to count of the count the vote of the speaker who was dictated in the open court. It has come and the result should be announced along with the petitioner votes. Now the president president, vice president vote in the election is there. Tomorrow it may be taken.
ಹಾಗಾಗಿದೆ, ಯಾರು ಮಾಡಿದ್ದಾರೆ ನೋಡಿ.
It's 25. There is an increment.
But there is a reason given your lordship why ಅಂತ ಹೇಳ್ಬಿಟ್ಟು, but I have not given the opportunity.
I never pass such order. ಅದೇನೋ ಮಿಸ್ಟೇಕ್ ನಲ್ಲಿ ಆಗಿರ್ಬೇಕು. ನೋಡಿ ಅದನ್ನ ಬರ್ತೀನಿ.
It's 25. There is an interim order.
Interim order is
Great. 30 urgent ಆಗಿದೆ, 30.
ಇದರಲ್ಲಿ ಲಿಸ್ಟಲ್ಲಿ ಏನಿದೆ ಮತ್ತು ಸಬ್ಮಿಟ್ ಮಾಡೋದು ಫೈಲ್ ಇದು ರಿಮಾರ್ಕ್ ನೋಡಿ ಸರ್ ಅದರಲ್ಲಿ ಮೆಮೊ ಇಲ್ಲ ಇಲ್ಲಿ ಮೆಮೊ ಆಗ್ತಿದೆ
ಫೈಲಲ್ಲೇ ಇದೆ ನಾನು ನೋಡಿದ್ದೆ ಫೈಲಲ್ಲೇ ಇದೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರೆ ಏನಂತೆ ವಿಡ್ರಾ ಚೇಂಜ್ ಮಾಡೋಣ ಸರಿ ನೀವು ಆ ಥರ ಇದ್ರೆ ಚೇಂಜ್ ಇದೆ ನಾನು ನೋಡಿದ್ದೀನಿ ಅದು ವಿದ್ಯಾರ್ಥಿದ್ದಾರೆ ಟೋಟಲ್ ಮೆಮೊ ಅದರಲ್ಲೂ ಇಂಟ್ರಲ್ಲೂ ಇದೆ ನಾನು ನೀಟಾಗಿ ನೋಡ್ಬಿಟ್ಟಿದ್ರೆ ಇದರಲ್ಲಿ ಇರಲಿಲ್ಲ ಸೀರಿಯಲ್ ನಂಬರ್ ಇವೊಂದು ಕೆಲಸ ಮಾಡಿ ನೀವು ಹೋದ್ಮೇಲೆ ಕಳಿಸ್ಕೊಡಿ ನಾನು ಅದಕ್ಕೆ ಸೈಡಲ್ಲಿ ಕ್ಲಾಪ್ ಹಾಕ್ಬಿಟ್ಟು ವಾಪಸ್ ಕೊಡ್ತೀನಿ ಸರಿನಾ ಏನಾಯಿತು ಮೇಡಮ್ ಬರ್ತೀನಿ ಅನ್ನಂಗೆ ಆಯ್ತದೆ ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರ ನನಗೆ ಹಾಂ ಹೌದು ಸರ್ ಅವ್ರು ಇರಲಿಲ್ಲ ಆಫ್ಟರ್ 2 weeks List 1 230 matter, serial number 35, Varun Jaykumar Patil, DL Sanjeev, S Saravana.
Writ petition 16803. The password.
ಸರ್ ಆ ಕಡೆನೂ ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಇದ್ದಾರೆ ಸ್ಪೆಷಲಿ ಇದು 230 ಅಂತ ಇತ್ತು ವಾಟ್ ಇಸ್ ಟು ಬಿ ಡನ್
If they are going to any other date convenient for them, it's subject to lordship, let them take it, but password not today.
counsel for the petitioner prays for time
Correct.
yes time ಬೇಡ ಬೇಡ ಅದ್ರ ನೆಕ್ಸ್ಟ್ ಆದ್ರೆ ಬೆಟರ್ ಹಾಂ ಹಾಗೆ ಅಷ್ಟೇ ನೋಡ್ಕೊಂತೀವಿ ಎಸ್ ಬೆಟರ್
Please.
8th or 9th December at 2:30 or general list
230 is better. It's short point.
yes 2:30
ಇದು ನಿಮ್ದೆ.
Serial number 31, N Ramachandra. Serial number 31.
ಇದು 35 ನಲ್ಲಿ ಗವರ್ಮೆಂಟ್ ನೀವು ಇದ್ದೀರಲ್ಲ
ಪ್ಲೀಸ್
35
ಪ್ಲೀಸ್
ಅದರಲ್ಲಿ ಒಂದು ಸ್ವಲ್ಪ ಅಲಾಂಗ್ ವಿತ್ ದಿ ಕೌನ್ಸಿಲ್ ಆನ್ ರೆಕಾರ್ಡ್
ಪ್ಲೀಸ್
ಒಂದು ಸಿನಾಪ್ಸಿಸ್ ಡೇಟ್ಸ್ ಅಂಡ್ ಇವೆಂಟ್ಸ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿ
ಪ್ಲೀಸ್
ಬಿಕಾಸ್ ದೇರ್ ಆರ್ ಸೋ ಮೆನಿ ಪಿಟಿಷನ್ಸ್
ಪ್ಲೀಸ್
ಹೂ ಆರ್ ದ ಪಿಟಿಷನರ್ಸ್ ವಾಟ್ ಈಸ್ ಚಾಲೆಂಜ್ಡ್
ಪ್ಲೀಸ್
at a glance I can understand
please lordship given date on 8th man
8th and ಯಾವಾಗ 8th 30 continuation 31 counsel for the petitioner is absent, no representation. ಏನಿದೆ ಪ್ಲೇಯರ್ ನೋಡಿ ಪಿಟಿಷನ್ ಏನಿದು ಸೀರಿಯಲ್ ನಂಬರ್ 31
Please, my lord. Silence.
in order of KAT counsel for the petitioner is absent, no representation. No interim order is passed in that.
Lord, I mean, a colleague is not my lord.
ಸ್ವಲ್ಪ ವೆರಿಫೈ ಮಾಡ್ಕೊಂಡು ಬರ್ಲಿಕ್ಕೆ.
Please, please.
Absent, no representation. List on.
Serial number 32 urgent, 33 Vijay Raghav Sarathi, TB Sandesh.
Respondent, my lord.
33. Counsel for the petitioner is absent, no representation. ಯಾವಾಗ ಮುಂದೆ ಹಾಕ್ಬೋದಲ್ಲ? ಲಾಸ್ಟ್ ಚಾನ್ಸ್ ಆಗಿಲ್ಲ, ಅದಕ್ಕೆ ನೋಡಿದೆ ತಗೊಂಡು. ಏನು ಇಂಟ್ರಿ ಮಾಡ್ರಿ?
Preparation of the my lord.
You are for respondent number? 4 ಅಲ್ಲ. 8 opposes grant of time on the ground that the interim order is operating, due to which the election for the society could not be held. So the
Preparation of the voter list, my lord.
preparation of voters list for holding election is stalled. List finally. Yes.
Serial number 34 Sandesh, VR Sarathi.
ಇಲ್ಲ ಒಂದು ನಿಮಿಷ ಕೊಡ್ಬೇಡಿ, ಇನ್ನೆಲ್ಲ 9th ನಂತರದ್ದು. ಪಿಟಿಷನ್ ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಮಾತ್ರ, ಬೇರೆ ದಿನ ಫಿಲ್ ಮಾಡೋದು ಬೇಡ. ಎಲ್ಲ 4 weeks ಹಾಕ್ತಾರೆ. ಅದು ತಗೊಳ್ಳಿ, ಕೆಲಸ ನಮ್ಮ ತಗೊಳ್ಳಿ, ಸುಮ್ಮನೆ ಹಾಕಿದ್ದೆ ನಾನು ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿಡೋದು. ವರ್ಕಿಂಗ್ ಡೇ ಫ್ಯೂ ಇದೆ ಕಡಿಮೆ. ಲಾಸ್ಟ್ ಫ್ಯೂ ಡೇಸು ಭಾಳ ಕಷ್ಟ. ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಕಡಿಮೆ, ನಾಡಿ ಫ್ರೈಡೆ. ನಾನು ಅಪ್ ಟು 3:30 4 o'clock ಕೊಡ್ತಿರ್ತೀನಿ ಅಷ್ಟೇ. Yes, what is the prayer? ಯಾರು contesting ಯಾರು?
Respondent number, my lord. Same, my lord. Earlier case is concerned petitioner, my lord.
ಯಾರು?
Or Vijay Raghav Sarathi. We are Sarathi, my lord. In respect of 33 is concerned. Same council. There is caveat.
ಏನ್ ನಿಮ್ ಪ್ರೇಯರ್ ಏನು? ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇದೆ?
Order is, my lord, challenging.
Annexure J and G, D.
Page number 84.
After that, the authority conducting the election and the society running successfully. In the meanwhile, after lapse of 1 year, the respondent of both by the appeal under section 106, stating that the primary.
No, appeal against what?
Against the registration of new society.
Registration in the month of January.
They have filed the appeal on 11/9/23.
ಯಾರು? respondent number 4. What is the ground?
Now that they are within 1.2 kilometers. ಹಾಗಾಗಿ ಅದನ್ನ ರಿಜಿಸ್ಟರ್ ಮಾಡಿ ಕೊಟ್ಟು
Respondent number 4 is not a member.
Not a member, nowhere concerned. Nothing.
Respondent number 4 yaro. It is also a society?
Society.
Illa. Individual.
Individual member.
President of another society.
Society.
Another society.
Hmm.
Now, election audit ಆಗಿದೆ. Dairy is the divisional society.
Now what is the order passed? What are
Passed by courts. They have filed an application for
maintainability?
Maintainability, question is the maintainability of appeal. They have no local study, nowhere connecting with the society, and he is not a member of it.
Aitu. Appeal was allowed?
No, no.
No.
Then
Pending.
Dismissed. My application is dismissed.
what is it?
Giving any proper reason.
What is your application? Maintainability.
Please.
Oh, interim order you are challenging.
Please.
Why you are saying appeal is not maintainable?
2023
Agli. On merits it will be decided, sir.
Section 12, my lord, 106, very clearly say that, my lord. Any pertaining to registration is concerned. Appeal is 106 is maintaining.
Now appeal is already preferred.
Please.
They have filed in the village area, they have filed.
Delay ಮೇಲೆ ಒಂದೇ ಹೇಗೆ ಸರ್ ಮೆರಿಟ್ ಮೇಲೆ ನೋಡ್ಬೇಕಲ್ವಾ? ಸರ್ ಎಲ್ಲದನ್ನು ಇದು ಮಾಡಿ ಇಗ್ನೋರ್ ಮಾಡಿ ಆಲ್ರೆಡಿ ಸೊಸೈಟಿ ಇಸ್ ರಿಜಿಸ್ಟರ್ಡ್ ಸೊ ಲೆಟ್ ಇಟ್ ಗೋ ಅಂತ ಹೇಳಲಿಕ್ಕೆ ಆಗುತ್ತಾ? ಇಫ್ ಇಟ್ ಈಸ್ ಅಗೇನ್ಸ್ಟ್ ದ ಪ್ರೊವಿಷನ್ಸ್ ಆಫ್ ದಿ ಆಕ್ಟ್. So merits ಮೇಲೆ you have no case. ಆಯ್ತು ಸರ್, what is the apprehension? ಆನ್ ಮೆರಿಟ್ಸ್ ಅವ್ರು ಹಿಯರ್ ಮಾಡಿದ್ರೆ ನಿಮ್ಮ ಅಪ್ರೆನ್ಷನ್ ಏನು? ಅವ್ರ ಅಪೀಲ್ ಅಲೋ ಆಗುತ್ತೆ ಅಂತ. ದೆನ್ ಎಲೆಕ್ಷನ್ ಅಂದಲ್ಲೇ ಪಾಲಿಟಿಕ್ಸ್ ಇರುತ್ತೆ, ಅದನ್ನ ನೀವು ಮತ್ತೆ ಸಪರೇಟ್ ಆಗಿ ಏನು ಹೇಳೋದು ಬೇಡ. ಇಷ್ಟರೊಳಗೆ ಅದನ್ನ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೋದಿತ್ತಲ್ಲ, ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ಅಪ್ರೋಚಿಂಗ್ ದಿಸ್ ಕೋರ್ಟ್. ಈಗಲೂ ಹೋಗಿ ಎಕ್ಸ್ಪಿಡಿಷಿಯಸ್ ತಗೊಳ್ಳಿ, ಅಲ್ಲಿ ಆನ್ ಮೆರಿಟ್ಸ್ ಲೆಟ್ ಇಟ್ ಬಿ ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್. ಎಲ್ಲ ಅಡ್ಡದಾರಿಗೆ ಹೋಗ್ಬಾರ್ದು ಸರ್, ರೈಟ್ ಟ್ರಯಲ್ ಮೆಥಡ್ ನಲ್ಲಿ ಹೋಗ್ಬೇಕು. ಸರ್ ಫೆಬ್ರವರಿ ಇನ್ನೂ 3 ತಿಂಗಳಿದೆ, ಅಷ್ಟು ದಿವಸ ಯಾಕೆ ಇಟ್ಕೋಬೇಕು? ಸರಿ, ಇದನ್ನ ಯಾವಾಗ ಹಾಕಿದ್ರಿ ನೀವು? 11. ಮೊನ್ನೆ
17/11.
ಗೋ ಬಿಫೋರ್ ಭಾಳ ವಿಡ್ರಾ ಮಾಡಿ ಆನ್ ಮೆರಿಟ್ಸ್ ಲೆಟ್ ದಿ ಯಾರ ಮುಂದೆ ಇದೆ ಅದೀಗ? ARCS.
Respondent number BRCS.
Respondent number 2. Appellate authority. Let him consider on merits and dispose of expeditiously. ಎಷ್ಟು ದಿನ ಬೇಕು ಅಪೀಲ್ ಹಿಯರ್ ಮಾಡೋದಕ್ಕೆ ಅವರಿಗೆ? ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಯು ಹ್ಯಾವ್ ನೋ ಕೇಸ್. ಹೋಗ್ತಾ ಇಲ್ಲ ಹೇಳಿದ್ನಲ್ಲ ಸರ್, ಇಫ್ ಯು withdraw this petition, I will direct the respondent number 2 to consider the merits. No, ಅಂತದ್ದು ಯಾವುದು ಮಾಡಲ್ಲ. Then argue the matter. I will consider. Either ಅಲ್ಲಿ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಮಾಡಬೇಕು, ಇಲ್ಲ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಮಾಡಬೇಕು. Yes, proceed. Annexure J and G. ಏನಿದು J ಏನು?
J order, my lord. Impugned order, my lord. Order sheet.
G ಏನು?
Application filed by the respondent.
Consequently, allowed the application regarding maintainability filed by the petitioner. Okay. What is D?
D,
What is D?
D, annexure D.
Appeal.
Appeal.
ಇದನ್ನು ನಾವೇ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬಿಡುದಾ? ನಾಟ್ ಮೇಂಟೈನಬಲ್ ಅಂತ. ಆಯ್ತು. ಎಸ್ ಬನ್ನಿ ನೋಡಿ ಕೇಳಿ, ಅವ್ರೇನೋ ಹೇಳಿದ್ರು ಅಂತ ನಾಳೆ ಇದು ಮಾಡಬೇಡಿ. ಯಾವಾಗ ಹೇಳಿದ್ರಿ? Sir, you have to take a decision. You must know the consequences. How can you avoid that, sir? ಅಂದ್ರೆ ಇಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ತಗೊಂಡ್ರೆ ಯು ಕ್ಯಾನ್ ಅವಾಯ್ಡ್ ಅಂತನಾ? ಇಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್
There is no ground at all to regarding political intervention is concerned, my lord. No, there is no plea dated before. There is no pleading at all in the writ petition.
Is it the pleading? Even if it is pleaded, ಎಲ್ಲಿದೆ? Ground number?
No, my lord.
ಎಲ್ಲಿದೆ? ಮತ್ತೆ ಎಲ್ಲಿಂದ ಅದು ಅಪ್ರಹೆನ್ಷನ್ ಬಂತು? ಪಿಟಿಷನರ್ಗೆ ಇಲ್ಲದೆ ಅಪ್ರಹೆನ್ಷನ್ ನಿಮ್ಗೆ ಎಲ್ಲಿಂದ ಬರುತ್ತೆ? ಏನ್ ಮಾಡೋದು ಹೇಳಿ? ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಪಿಟಿಷನರ್ seeks permission of the court to withdraw the petition. Submission is placed on record. Petition is dismissed as withdrawn.
Serial number 35 Arjun, list 2, serial number 1, S. Saravana, Dada Kalandar.
ಯಾವುದು serial number? Yes, you take notice for respondents.
Respondent number, my lord.
One,
1, 3, 4, 5, 6, 5, my lord.
1, 3 to 5. AG takes notice for
4 and 5, my lord. 4 and 4 also returning officer.
3 to 5.
Please.
Alva. 3 to 5. 1, 3 to 5. You are for?
Actually, I am appearing on behalf of the advocate Dada Kalandar. He instructed me with ಅವ್ರೇನು ಕೇವೇಟ್ ಹಾಕಿದ್ದಾರೆ, ಕಾಪಿ ಏನು ಕೊಟ್ಟೆ ಇಲ್ಲ ಅಂತ ಹೇಳಿ. ಕೇವೇಟ್ ಇದೆ. So you need a copy of the
ಯಾರು
petition.
respondent number?
No, respondent number 7.
7.
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ?
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ.
ಇಟ್ಸ್ ಸರ್ವ್ಡ್ ಮೇಲ್ ವಾಟ್ಸ್ಆಪ್ ಮುಖಾಂತರ ಮೇಲ್ ಅಲ್ಲಿ ಸರ್ವ್ ಮಾಡಿದೀವಿ.
ಅವರು ಮಧ್ಯಾಹ್ನ ಹೇಳೋದ್ರು, ಮಧ್ಯಾಹ್ನ ತನಕ ಇಲ್ಲೇ ಇದ್ರು, ಕಾಯ್ತಾ ಇದ್ರು. ಅವ್ರೇನೋ ಮಧ್ಯಾಹ್ನ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಇದೆ, ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ, ಅದನ್ನ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು. ಅವರು
ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ವಿ ಆರ್ ಪ್ರೊಡ್ಯೂಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಈಗಲೂ ಒಂದು ಸೆಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಈಗ ಜಸ್ಟ್ ಕೊಟ್ಟಿದ್ರೆ ನಾನು ಅವ್ರಿಗೆ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡ್ತೀನಿ.
Floods,
Kindly.
the mail has been sent, WhatsApp has been sent, and we have informed them, my lords, that the copies are sent by texting them.
Instructions ಅವ್ರಿಗೆ ಯಾವ್ದಕ್ಕೆ
Sir,
ಸರ್?
counsel for the petitioner submitted.
My lords, acknowledgement is filed along with the writ petition itself.
Is served on the caveat petitioner, oblique respondent number 7. Acknowledgement is filed before this court. Proxy counsel for the caveat petitioner, respondent number 7, please.
It's a very small issue, my lords, because the dispute is still pending before the ERCS. Lords, on 18/9/2025, there is a special meeting called. That's the meeting of the board. If your lords were to take page number 23.
What is that you are challenging?
Lords, now, this meeting minutes of 18/9/2025 is manipulated to show that there is a delegation in favor of the seventh respondent, and he wants it to participate as a delegate from the society when there is no resolution.
Who respondent number 7?
Respondent number 7. Lordships may kindly see page number 23. But I'll just make my submissions. Your Lordships may hear the other side. No difficulty, my lords.
I'll list it tomorrow. Tomorrow.
Please, my lords. Tomorrow, I think. Act Kodi.
Serial number 2, yes, Saravana.
Lords, a special meeting of the board is convened.
1 minute. Yaru.
Lords, in this,
To take notice for respondent number 1, 3, 4, 5.
1, 3, 4, and 5. 2 election authority.
Devraj.
So Devraj and council is directed, it takes notice for respondent number 2. 5, 7. Yes.
Lords, page number 25. Lords, I just give 2 facts which are necessary. Meeting is convened of the board for the purposes of choosing a delegate. Now, in that, there are 13 members. One will be the president. President will preside over the meeting.
Yes.
Now,
Equally divided.
equally divided. So, president has casted the vote, and therefore the delegate form is submitted. Now, the delegate form is not accepted only on the ground. President could not have exercised his vote. He could not have exercised his vote by relying upon 14 AG 10 rule. Only for elections, there are only 2 types of elections under the entire scheme of Cooperative Societies Act. One is for the board, the other one is for office bearers. Erade elections irodu. Adu bitte bere yavadu election illa. Delegate and all is only a meeting. It's only a meeting. Now, if your lordships were to see page 25, just read this and take your lordships to the relevant provision. ಸಂಘದ ದಿನಾಂಕ 26/9/25 ವಿಷಯ ಸಂಖ್ಯೆ 25 page 25. ಅದ್ರಲ್ಲಿ ನೆಲಮಂಗಲ ಅಂತಿದೆ, ಅದರಲ್ಲಿ ನಮ್ದು ಶರ. Why they have not accepted ಅಂತ. ಸಂಘದ ದಿನಾಂಕ 26/9/25 ವಿಷಯ ಸಂಖ್ಯೆ 3 ನಡವಳಿಕೆ ಅಂತಿಮ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ನಿಯಮ 14 AG 10 ನಮೂದಿಸಿ ಸದರಿ ಕಾನೂನಿನ ಅವಕಾಶಗಳನ್ವಯ ಸಭಾಪತಿ ಹೆಚ್ಚುವರಿ ನಿರ್ಣಾಯಕ ಮತವನ್ನು ನೀಡಿ ಡೆಲಿಗೇಟ್ ಅನ್ನು ಕಳುಹಿಸಲು ತೀರ್ಮಾನಿಸಲಾಗಿರುತ್ತದೆ. ಈ ಸಂಬಂಧ ಸಂಘದ 6 ಜನ ನಿರ್ದೇಶಕರುಗಳು ದಿನಾಂಕ 27/9/25 ಬ್ಯಾಂಕಿಗೆ ಮನವಿ ಪತ್ರ ನೀಡಿ ಬ್ಯಾಂಕಿನ ಸಾಮಾನ್ಯ ಚುನಾವಣೆ ಸಂಬಂಧ ಡೆಲಿಗೇಟ್ ಕಳುಹಿಸುವ ಸಂಬಂಧ 6 ಜನ ಪರ ವಿರೋಧ ಸಮಬಲ ಬಂದಿದ್ದು, ಈ ಸಂಬಂಧ ಸಂಘಗಳ ಸಹಾಯಕ ನಿಬಂಧಕರ ಸಲಹೆ ಪಡೆದು ಲಾಟರಿ ಮುಖಾಂತರ ನಿರ್ಣಯ ತೆಗೆದುಕೊಳ್ಳಬೇಕೆಂದು ಮನವಿ ಮಾಡಲಾಗಿದ್ದರೂ ಸಂಘದ ಅಧ್ಯಕ್ಷರು ಸಹಕಾರ ಸಂಘಗಳ ನಿಯಮದಂತೆ ನಿರ್ಣಯವನ್ನು ಅಂತಿಮಗೊಳಿಸಲು ನನಗೆ ಅಧಿಕಾರವಿದೆ ಎಂದು ತಿಳಿಸಿ ಸಭೆಯನ್ನು ಮುಕ್ತಾಯಗೊಳಿಸಿರುತ್ತಾರೆ. ಆದರೆ ಇದಕ್ಕೆ 6 ಜನ ನಿರ್ದೇಶಕರು ವಿರುದ್ಧವಿರುತ್ತದೆ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಸೋನ್ಸೋ ನಿಯಮ 14 AG 10ರಲ್ಲಿ ಚುನಾವಣೆಯನ್ನು ಹೊರತುಪಡಿಸಿ ಯಾವುದೇ ವಿಷಯದ ಮೇಲೆ ಪರ ಅಥವಾ ವಿರುದ್ಧ ಸಮಾನ ಮತಗಳು ದೊರೆತರೆ ಸಭಾಪತಿಯು 2ನೇ ಅಥವಾ ನಿರ್ಣಾಯಕ ಮತ ಚಲಾಯಿಸಲು ಹಕ್ಕುಳ್ಳವನಾಗಿರತಕ್ಕದ್ದು ಎಂದು ಇರುತ್ತದೆ. ಸಂಘದ ಸಭಾಪತಿಯು ತೆಗೆದುಕೊಳ್ಳುವ ತೀರ್ಮಾನ ಸೋನ್ಸೋ ಅಧಿನಿಯಮ ಪ್ರಕರಣ ಸೋನ್ಸೋ ಪರಿಭಾಷೆ ಮತ್ತು ನಿಯಮ 14 AG 10ರಲ್ಲಿ ಚುನಾವಣೆಯನ್ನು ಹೊರತುಪಡಿಸಿ ಎಂದು ಮತ್ತು ಸದರಿ ಪ್ರತಿನಿಧಿ ನೇರವಾಗಿ ಚುನಾವಣೆಗೆ ಸಂಬಂಧಪಟ್ಟಿರುವುದರಿಂದ ಹಾಗೂ ಸಂಘದ ದಿನಾಂಕ 26/9/25 ಆಡಳಿತ ಮಂಡಳಿ ಸಭೆಯ ವಿಷಯ ಸಂಖ್ಯೆ 3 ತೀರ್ಮಾನದ ನಡವಳಿಕೆ ಅವರೇ ದಾಖಲಿಸಿರುವ ರೀತಿಯ ಚುನಾವಣೆಗೆ ಸಂಬಂಧಿಸಿದ್ದಾಗಿದ್ದರಿಂದ ಬ್ಯಾಂಕಿನ ಆಡಳಿತ ಮಂಡಳಿ ಸಾಮಾನ್ಯ ಚುನಾವಣೆಯಲ್ಲಿ ಮತ ಚಲಾಯಿಸಲು ಮತ್ತು ಚುನಾವಣೆಗೆ ಸ್ಪರ್ಧಿಸಲು ಹಾಗೂ ನಾಮಪತ್ರ ಹಿಂಪಡೆಯಲು ಡೆಲಿಗೇಟ್ ಆಗಿ ಕಳುಹಿಸಲು ತೀರ್ಮಾನ ತೆಗೆದುಕೊಂಡಿರುವುದರಿಂದ ಸಂಘದ ತೀರ್ಮಾನಿಸಿ ಕಳಿಸಿರುವ ಡೆಲಿಗೇಟ್ ಪರಿಗಣಿಸದೆ ಸಂಘವನ್ನು ಅನರ್ಹ ಮತದಾರ ಪಟ್ಟಿಯಿಂದ ಅನರ್ಹ ಮತದಾರ ಪಟ್ಟಿಗೆ ಅನುಬಂಧ ನಾಯಕಕ್ಕೆ ಸೇರಿಸಲಾಗಿರುತ್ತದೆ. ಇದರಲ್ಲಿ 14 AG, if your lordships were to see, rule 14 capital AG 10. It is AJ, it is not AG, it is AJ. AJ, J ಹಾಕಿದ್ದಾರೆ. If your lordships were to see 14 AJ speaks about general meetings.
ಈ J ಏನಿದೆ sir?
AJ,
J10 my lord.
J for Japan.
ಅಲ್ಲ ಸರಿ.
10.
ಅದರಲ್ಲಿ
14A is ಏನದು?
14 capital AJ, AJ, yes.
14A is presentation of nomination.
Yes, ಅಲ್ಲ 14 AJ ಅದಕ್ಕೆ ಹೇಳಿದ್ದು. ಆ ABCDEF ಆದ್ಮೇಲೆ ಮತ್ತೆ AJ ಬಂದಿದೆ.
Yes. General meetings.
General meetings. ಅದರಲ್ಲಿ 10.
All decisions shall be taken by a simple majority of the member present at the ground general meeting unless
Yes.
otherwise.
All decisions shall be taken by a simple majority of the members present in the general meeting unless stated otherwise in the act, rules or the bylaws. When there is equality of votes for or against the decision on any subject other than election, the chairperson of the meeting shall have the second or casting vote. That's what is meant by election has to be reckoned with reference to the elections as defined under the act itself. There are only two types of elections which is contemplated under the act. One is the elections for the board, the other one is elections for office bearers. Other than that, everything else is a general meeting. There is no election which takes place. And choosing a delegation, my lords, is never an
Defined
election.
under?
Pardon, my lords?
Defined under, election is
Lords,
defined.
If your lords were to see, there are only two types of election. First is election to the board of directors.
ಎಲ್ಲದು, where it is defined?
That is at section final authority. ಇಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡೋದಲ್ಲ ಅದನ್ನ ಇದಿದೆ 39 capital A.
In act my lord.
Of the act, section 39 capital A.
Conduct of elections.
Please.
Yes. ಇದು ಒಂದು.
Election of the society, casual vacancy, experience.
Office board, it shall be done immediately. ಅಲ್ಲ. And the second election is election to the office bearers. ಅಷ್ಟೇ ಎರಡೇ ಇರೋದು. ಮಿಕ್ಕಿದ ಏನೇ ತೀರ್ಮಾನ ತಗೊಂಡ್ರು ಕೂಡ everything forms a part of the decision making process by the collective body, that is the governing body. ಅವರು ಹೇಳೋದೇನು ಅಂದ್ರೆ delegation is eventually for the purposes of going there and participating in the election. Election ಗೆ ಸಂಬಂಧಿಸಿರೋದ್ರಿಂದ we want to attract 14 AJ 10 ಅಂತ. That is not correct.
ಇಲ್ಲೂ ಎಲೆಕ್ಷನ್ ಅಂತಾರೆ, 6 ಆ ಕಡೆ 6 ಈ ಕಡೆ ಅಂತ.
6 and 6 ಇದ್ದಾಗ elections ಬರೋದಿಲ್ಲ. In every meeting,
That is-
let us assume that we want to undertake any expenditure. I put it for vote. 6 and 6 comes. Then, or I want to purchase a property on behalf of society. 6 and 6 comes. Then somebody, the president will vote. This is a decision like that only. The question of selecting a delegate or nominating a delegate, it is actually the user of the word is nominating a delegate.
14 AG my lord very clearly say that the word used by election means my lord to regarding pertaining to the relation to the any election. This delegation also my lord to send the society from the federal society for the purpose of the election only.
ಅದು
Delegate, whether he will be nominated or elected.
Delegation for my lord representing the federal society.
ಅದನ್ನ clarify,
Be elected or nominated.
nominated.
Nominate.
Then
Lords, can I just request your lords may kindly take rule 9. That clarifies the object or the purport of rule 14 AJ 10.
rule 9.
Rule 9. Chairman to have a second or casting vote. In the event of equality of votes on any matter other than the election of a member of the board or the office bearers. Chairman of a meeting of a cooperative society shall have the second vote,
To delegation
not a
means,
delegate.
to delegate, my submission is, my lord, to regarding, my lord, it is not 2/3 majority, because not simple majority, because they send to the delegate to the, that federal election is concerned, because they will vote, my lord, in respect of the federal society is concerned.
Correct. ಅಲ್ಲಿದು election ಆಯ್ತು. ಇಲ್ಲಿ
No, so that is the reason, my lord, the intention of the law is very clear, my lord.
this what do you say regarding the rule 9?
Now, any event equality of the votes other on an any matter other than election, my lord, that is said.
Further.
The election other than election of the members of the board or office bearers, the chairman of the meeting, the cooperative
Say
society.
again, there is reference to only 2 elections,
Please,
not for any election.
regarding, my lord, but rule AJ is very clearly say that, my lord.
ಹೇಗೆ?
AJ is very clear.
So if that is to be accepted, as the learned senior advocate puts it,
Please.
in every decision there will be election.
No, regarding, my lord,
2 ಜನ ಇದ್ದಾಗ
Please.
it's bound to happen. 6
ಅವಾಗ ಪ್ರತಿ ಸಲನೂ
వాళ్ళు ಟಾಸ್ ಮಾಡ್ತಾರೆ.
pass ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
No, regarding, my lord, I am saying that not election is concerned.
Here also a resolution is to be passed nominating the delegate.
Please. Why? Because I'm saying that the delegation 18BL ಬರೋದು ಅವರಿಗೆ. To regarding, they will pass an order based on the, my lord, 2/3 majority. They send the delegation voting to the federal society.
Delegate ಗೆ 2/3 majority ಬೇಕು.
Please, ಅಲ್ಲ, I mean, majority.
Simple majority.
Please, simple majority.
Change ಮಾಡಿದ್ರೆ, if it is changed,
18B, my lord, kindly see.
section 21, section 21 speaks about how the delegate is appointed.
ಅಲ್ಲ ಅದೆಲ್ಲ complications ಯಾಕೆ? Rule 9 is very clear.
Rule 9 is very clear. Only two elections are recognized.
To in this,
Why we should complicate that?
to regarding 9 is concerned, my lord, I have it tomorrow, my lord, I will take instructions on that point.
ಏನು instructions ಇಲ್ಲ, very simple
No,
language
my
ನಲ್ಲಿ
submission, my submission is, my lord.
scope for any.
So, no, here, my lord, they will only say that AJ 10 ಅಂತ ಹೇಳಿಲ್ಲ ಅವರೆಲ್ಲೂ. ಇದು 9, rule 9 ಎಲ್ಲೂ accept ಮಾಡಿಲ್ಲ.
Restrict ಮಾಡಿಲ್ಲ.
14 AJ has to be read with rule 9. It speaks election. What is election is amplified in rule 9. It will not go beyond what is said in rule 9.
On that regard, my lord, my reply, my lord, I have it on tomorrow, first matter, my lord, I will say.
The petitioner being the director of. The petitioner has approached this court for seeking issuance of writ in the nature of mandamus, directing respondents 1 to 4 and 7 to permit what is this prayer? Permit the petitioner's 6th respondent society. Permit respondent number 6 society, I think.
6, please.
ಏನಿದು prayer?
If you made saying that alternatively at least you draw the lots, you cannot disqualify one society.
ಅಲ್ಲ ಇದೇನ್ರಿ permit the petitioner's 6th respondent society to read the amendment.
To participate as a delegate. 6th respondent is the society. Now 6th respondent is disqualified from being the member of the federal society.
Now petitioner is the delegate now.
Petitioner is the delegate.
Sorry. Now what is your prayer?
Petitioner represents the 6th respondent.
Yes.
The 6th respondent should be permitted to participate, notwithstanding this order is what we are asking.
Now petitioner is to be permitted to represent respondent number 6 society.
That I tomorrow by the time we present to us, I think. If I am necessary application for that.
Taking direction. To respondent number 1 to 4. Seeking permission for the petitioner to represent respondent number 6 delegate. In the general election to be held for respondent number 6 bank, scheduled to be held on 7/12/2025. Third section. The senior advocate for the petitioner contends that respondent number 6 society is having 13 members in the board. One member is acting as president. The general election for respondent number 7 is scheduled to be held on 7/12/2025. Respondent number 6 society was required to send its delegate. Accordingly, the meeting was held where 12 members have divided equally. Acting under section 14 AJ rule 14 AJ capital bracket 10 of cooperative societies rules. The president casted vote, which resulted in nominating the petitioner as the delegate. Now the impugned order now in view of impugned order. Annexure E What is Annexure E?
Lord, this is 13D5. Okay. List.
The ineligible voters list for respondent number 7. This is ineligible voters list for respondent number 7.
7 society.
7. Annexure E is the ineligible voters list for respondent number 7 society for the election that is scheduled to be held on so and so. The only reason assigned to include respondent number 6 society in the ineligible voters list is that the president has cast his vote as the members stood divided. Section 14 AJ 10 is interpreted to hold the nomination of the delegate is considered as an election. Therefore, held, the president could not have cast his vote. Next, Learned Senior Advocates drawn the attention of the court to Rule 14 AJ 10 read with Rule 9 of Karnataka Cooperative Societies rules to contend that Rule 9 makes it very clear that the election referred to in Rule 14 AJ 10 means only to the general election to elect the member of the board or the office bearers general election of members of the board and election to the office bearers and election to the office bearers. When the delegate is to be nominated, no election will be held there as it is only a nomination. Therefore, inclusion of respondent number 6 society in the ineligible voters list is bad under law. Accordingly, he prays for allowing the petition. A contra. Order shifnally heard so and so. Now respondent number 6 and 7 notice 6 and 7. What should happen? What about 7?
7 will not, there is a standing motion appearing regularly for the PCC bank. Find out the standing counsel and give it a.
Issue notice to respondent number 6 and 7. Learned counsel for the petitioners sought seeks permission to serve respondent number 6 through hand summons. Permitted. Counsel for the petitioner seeks permission to serve the standing counsel for respondent number 7 bank. Permitted. But you have to pay PF for both.
Please,
In the meantime, you verify this.
please, please.
The word used for petition of a delegate is appointment. Even under section 21, which speaks about the appointment of about the delegate, also speaks as appointment rule. And then section 21(3) also speaks about change in the appointment. It's never an election.
Learned senior advocate further contends that section, as per section 21
Section 21
of so and so.
2E1. Section 2E1, which defines delegate, E1A, speaks about appointment. 21 also speaks about appointment. Never an election.
Serial number 3, Rochelle George Jacob, B.S. Pramod.
Preliminary. Yes.
Multi-state cooperative society. Multi-state cooperative society. There are 2 matters. WP number 31005, the first matter. 31005 is not filed challenging the refusal of the proposed amendment to the bylaws.
Now, who is the petitioner in both these petitions?
Both the petitioners
Same petitioner. Yes.
Question before your lordship, my lords. Both are interlinked, my lords. The Register of Cooperative Society has sought to appoint an administrator, my lords. On the ground that notice was issued to them, issued to the petitioner, we are not sought to reply to the notice. And based on a joint inspection report, without taking note of the fact that the joint inspection report was challenged and set aside by the Kerala High Court. So therefore, as on the date of passing the impugned order, based on the joint inspection report, that order was not there. That's the first basic point.
Why it was quashed by Kerala?
Kerala High Court, my lord. So that
Kerala High Court quashed it.
because, my lord, the order, no jurisdiction, my lord. Your lordship may kindly see that annexure, order was page 60, annexure P, page 64, my lord.
1 minute.
The order was passed by who? Order was registered by who? Which register? Register, yeah, register, joint register. Of which Kerala?
We cannot.
Page 64 may be kindly seen, my lords. Your lordship's question is basic. The reason is joint register Kerala's report was challenged before the Kerala High Court, not Karnataka, my lord. The administrator which is sought to be appointed in this petition is based on the joint inspection report of the joint register of Kerala. Page Kannur, page 64 of the writ petition in WP number 31005 may be kindly seen, my lords.
That is before Kerala High Court.
Kerala High Court, it was challenged and it was set aside. Your lordship may kindly see exhibit.
Why that report is made applicable here?
Because based on that report, now the joint registrar here seeks to appoint an administrator without knowing, without taking note of the fact. fact that
That report is concerning petitioner number 1.
Petitioner number 1, yes. It's a multi-state cooperative society, my lord. That's the reason, my lord. It jurisdiction limits to Karnataka, Kerala, Tamil Nadu, Andhra, my lord.
Multi-state.
Cooperative society, my lord. That is how, my lord.
Page number 28.
Karnataka, Kerala, Tamil Nadu.
And Andhra, my lord. And amendments are-
Page number 20.
Telangana also.
And please, page number 28, if I may request, my lord, your lordship will get the jurisdiction, my lord.
Page?
28, my lord.
Yes.
ಈ ಕೇಸಲ್ಲಿ 32.
32, I'm sorry, 32, my lord.
Page number 32.
32,
ಇಲ್ಲೂ ಇದೆಯಲ್ಲ ಕರ್ನಾಟಕ, ತಮಿಳುನಾಡು, ಕೇರಳ, ಆಂಧ್ರ ಪ್ರದೇಶ್.
please, my lord.
Certificate of registration.
Please, my lord. So these are the 4 states. In the impugned order, your lordships will get it in this case, my lords, is at page number.
Page number 37.
That is what is here, man. Now, what is challenged is the annexure F, page 37, my lords.
Necessary F.
This amendment of bylaw as was moderated down.
First case. Second case.
The lordship, the Indian Cooperative Society for so and so, so and so, so and so has submitted an application for amendment of bylaws. On scrutiny, it is observed the application has not been submitted within 30 days from the date of general meeting at which the amendment to the bylaw was passed, as the amendment application dated so and so was received by the department so and so. Further, the liquidation process, this is important, my lord. Further, the liquidation process of the society has been initiated by this office, hence no amendment proposal to amend the bylaws can be considered. There are 2 aspects to it, my lords. This amendment has been initiated in the subject matter of the next petition, my lords. If your lordship may kindly take the connected petition in WP number 31007. The impugned order is at page number, my lords.
Page number 41.
Page 43, my lords.
42.
If this order goes, my lords, at page 43 in the connected petition, automatically this order is liable to be set aside. Page 43, my lords.
Annexure L.
Annexure L, the operative portion is at page 43. The Indian Cooperative so and so, so and so, so and so rule made as per the inspection report conducted under section 108 of the MSC Act 2002 by the Register of, this is important, Register of Cooperative Society, Government of Kerala. It reveals that the above society involved in banking without permission of the Reserve Bank of India under the Banking Regulation Act. Therefore, the above society called for personal hearing above central register so and so, along with relevant documents to explain the matter, but nobody appeared from the society. Therefore, it is seen, it has been decided to initiate winding up of the society under so and so, so and so, and the rules were there. And in case any objection for the same, it may be brought to the notice of the undersigned within 15 days from the date of advertisement, failing which an action will be initiated to wind up. Our respectful submission, this order on which they have sought from the Register of Society of Kerala, they have sought to initiate, that has been set aside by the Kerala High Court. If that is set aside, automatically the notice issued to us also, based on that report also goes. So therefore, my lord, if this initiation to appointment administrator goes, my amendment to the bylaws saying that liquidation has sought to be initiated, that is why we will not permit to amend the bylaws, will also have to go, my lord.
So there was only one report.
Only one report.
Kerala Registrar.
Kerala Registrar.
And that was set aside by
the Kerala High Court, my lord. This, without taking note of that, they sought to initiate that and not issue notice to us. And your lordship, that's the thing, fact, my lord. Judgment is at page 44 of the Kerala High Court, my lord. The next page. That's the only aspect, my lord. If the report on which they seek to issue notice And one other important, the notice we could not reply because notice is given to the wrong address, Manoj. I was able to point out that also, Manoj. Anyway, that may not be of any consequences because Manoj, notice is pursuant to the inspection report to call for objection. When the report itself is not there, Manoj, the question of replying to the notice does not arise.
Kerala High Court order.
That is at page 44, Manoj. Your Lordship, that at page 44, the operative portion is at page 55. Page 54, Manoj, the para 21. Para 21, Manoj, page 54. In my considered view, the scope of inspection under section 108 is quite comprehensive. Nothing comes in the way of the first respondent in having a thorough inspection conducted into the affairs of the petition. My Lord, quoted page 54, para 21, my Lord, right at the bottom. In my considered view, the scope of inspection under section 108 is quite comprehensive. Page 55. Nothing comes in the way of the first respondent in having a thorough inspection conducted into the affairs of the petitioner society. What cannot, however, be lost sight of is the first respondent is only a delegate under a particular statutory provision and is expected to act within the four corners of said provision. While submitting his report to the central government, the first respondent can as well urge the government to take immediate remedial measure vis-a-vis any particular society. If at all his affairs are scrupulous or in violation of the statutory provision, it assumes some importance to note that the concern through exhibit filed under so and so contain copies of the press report on the occasion of the inspection conducted by the first respondent. Both the exhibit P4, P5 news report in the vernacular have uniformly reported the inspection was conducted with an element of hostility and a certain evitable evidence looks place at the time of the inspection, at least owing to intervention of the outsider. The presence of the police is not denied either. If it is a mere inspection of records or the business activity of the petition society, I do not see any compelled need for the first respondent to make such a elaborate arrangement and inspect the petition society premises with under police protection. I do not see any element in the counter to effect that there is any resistance by or threat from the petitioner society. Since all the observations are only prima facie in nature regarding the nature of inspection the petitioner has undertaken, the court does not want to comment further. The fact that however remains that apart from seizing the record, the person also closed on the premises. The excuse supplied by the first respondent that there was nobody to take care of the branch, it was closed and the key was kept with them. It is indeed the specific contention of first respondent that the person in charge of the branch fled the place, but be that as it may, it was very hard to comprehend how on the occasion of mere inspection by the first respondent, especially under section 108, the personnel of the petition society fled from the scene of abandoning the branch. The news report, though cannot be elevated to the status of proven document, nevertheless leaves sufficient telltale signs concerning what could have transpired on that eventful day. It is only serves the interest of justice if the court declares the petition society in the light of exit P1 certificate is entitled to carry on business operation in the state of Kerala. This court consequently further directs the first respondent not to obstruct the petition business activity. Further, as a consequence, person shall hand over the keys so and so to the statutory provision. So therefore, my Lord, last pet peace, I hope the first respondent does not release arrogantly to himself the powers not vested in him and thereby act beyond the call of duty in the name of protecting public interest. This having been done, dated, my Lord.
Is it the very same report was on the
same that your Lordship will get it at page 45, exhibit R1H is the report, copy of the report dated 17/8/2015. Immediately thereafter, my Lord, this is we do not know about this report and quashing of the report here, my Lord. Then pursuant to annexure L, they refer to this report here.
Which is already quashed.
Which was already quashed by then. Page 43, which I read out in the same petition.
At 42 date.
42, your Lordship will get the date as 16th May 2016. With the cost on
19th August.
19th August 2015. This is 2016, my Lord. My lord, being a multi-cop, now that they have failed in Kerala, my lord, now they want to appoint an administrator in Karnataka. Based on the same inspection report. And then, and in the connected petition, my lord, they don't allow the amendment of the petition on the sole ground that, my lord, we have initiated liquidation, and this is the year 2016, we are in 2025, it's still functioning, my lord. There are lacks of.
No, is there any report from Karnataka?
No, my lord, no, absolutely nothing.
And
Undisputed
liquidation based on?
Kerala report, which I just pointed out, my lord, and which has been quashed. That is not in dispute, my lord.
There are two restrictions are there. The first petition is regarding allowing the amendment. Under the Multi-State Cooperative Act, once the agent after aging, within 60 days they have to submit. Here they are not submitted. That is the principal rule.
No, see, the specific contention is that the report referred to in Annexure L is the subject matter of writ petition before Kerala High Court.
Page number 36, what is the phrase? Petitioner, the Multi-State Cooperative having its head office in Bangalore, state of Karnataka, as an operation in 4 states, which includes the state of Kerala. Initially, the petitioner filed a public request to the declaration and declaration to gather its operations in state of Kerala. They also sought for further directions against alleged adverse media to have been indulged in any of the respondent cases as regards to discrimination of operation. This court on 13/7, much before 17/8 report. This court on 13/7/2015 issued a directive declaring the respondent any press or other media communication as a state or discrimination. Once again, the petitioner opposed this court by filing an IA number so. The events of the petitioner mean that on 13/8/2015, on or about 2 a.m., the first respondent without any notice of intimation came to the office of the petitioner society at Kannur along with a platinum of press persons, some political activities, and also 2 jeeps of cheap loads of police personnel. It is a specific contention of the petitioner society that the first respondent intimidated the office staff present in the branch and intimidated the register and computers kept at the office. Apart from closing down the branch, seeking judicial intervention, the petitioner tried to interrogate. No report was established. So, I know this come to last the relief, case number 57. What is the finding? Para 26. It only serves the interest of justice if the court declares that the society in the light of exhibit Stevens certificate is entitled to carry on its business of the state of Kerala. This court consequently further directs the first respondent not to obstruct the petitioner's business activities further. As a consequence, the first respondent shall hand over the keys of the branch to the personnel of the petitioner society as soon as they approach him. Short of permissible statutory measures as have been stipulated in the NCS Act 2022. The first respondent or any other authority exercising the power directly or as immediately shall indulge in misinformation or vilification by way of adverse media, meeting or reportage. Next paragraph. It is however made absolutely clear that if the first respondent or any other authority has got the power under any statute, be it NCS Act or any other event regulatory regime, this judgment of the court does not come in his or her way of taking further action against the petitioner society, if at all it has been involved in any illegal operations or operations without proper license. At the same time, the said authority shall be guided by the rule of law and fair procedure. No report has been set aside. My lords come to page number 45. The documents, whatever they have produced, they have not produced the report. It is respondent to the report.
R1H, page 45.
No, that is respondent has produced.
Question is.
His contention is that. Yes.
No, it's not.
That report annexure L.
NH R1H, that is last document in page 45.
That respondent has produced.
Okay, no, it does.
Your relief is not with reference to that report.
Your Lordship may, board on your Lordship may kindly see page 46, IA number 3, my lord.
Basically, in the writ petition, it is not your prayer to quash annexure L. That is the report, enquiry report. And that was not the relief granted.
Just listen to the court.
That was not the relief granted by the court.
Your Lordship may kindly see page 46, my lords. Once again, the petitioner approached the court in I number. The grievance of the petitioner is that on so and so 2 p.m. the first respondent without any notice or intimation came to the office of the petitioner along with so and so, so and so. The specific
One incident is highlighted.
So therefore, the incident is highlighted of the event which took place on 13th of August. Subsequently, my lords, they filed this. We brought it to the notice of the
Whatever
court.
may be, but you
No.
have not seen this
No.
writ petition. The petitioner has not challenged the report submitted by the registrar of Kerala.
The court examined the report of 17th August 2015 and said, your law, para 15 at page 52 may be kindly seen, my lords. Page 52, para 15. Thus, my lords, thus statutorily speaking, section 108 concerns itself with inspection of books of accounts of multi-state corporate. Further, the specific procedure has been prescribed as is evident from the above extracted provision. Once a multi-state cooperative society has been inspected in terms of section 108 of the MSCS Act, the inspecting authority can only make a report to the central government, which in turn is required to take appropriate decision based on the inquiry report. So the finding is given here. The
When
Lord
there is
so-
no prayer, sir.
No,
When
prayer-
there is no prayer to
I bow down
quash
to your
or
lordship.
to set aside that report.
I bow down to your lordships, my lords.
Prayer is entirely different relating to an incident.
Correct,
Where
my lord.
some persons have came and
My lords, there is
high-handed action.
there is no prayer. There is a finding given in para 50. There is a finding given.
And operative portion also.
I'll read.
There is no relief with regard to the report.
I'll point out, my lord. I'll answer your lordship's query, my lord. I'll just answer your lordship's query. Understand, my lord, because your lordship again at page 52, para 15, it deals with statutory speaking, section 108. Your lordship may just kindly turn to page 43, my lord. 43, my lord. As per the inspection report conducted under section 108 is the subject matter, even in the impugned order. At page 43, my lords, it refers to the very same.
No, there may be reference because the respondent has
Inspected in terms of section 108, this is when the page 53, the inspecting authority can make a report to the central government. Which
it is only a passing remark.
No, not with
made
the
by
finding, my lord. It is a finding given. Then I'll leave that, my lord. I won't stop at
That
that.
is the case.
The
The
mere-
court should have set aside that report.
Page 54, can I request page 54, para 19? The mere perusal of annexure R1G makes it clear the power has been delegated to the Register of Cooperative Societies, state government only to inspect any multi-state and submit a report to the central government. This is a finding of law, my lord. As per the circular, only to submit a report to the central government. It is not in dispute the first respondent may have received a complaint from different quarter concerning so and so. Further exhibits filed along with the counter. This is what my learned friend has produced. Do not show at least prima facie there is a needle of suspicion as regards the business tactics alleged to have been adopted by the petitioner society. Is a finding, my lord. Fact. In my considered view, the scope of inspection under section 108 is quite comprehensive. Nothing comes in the way of the first respondent to have in having a thorough inspection conducted into the affairs of the petitioner. What cannot, however, be lost of its sight of is that the first respondent is only a delegate under a particular statute provision and is expected to act within the four corners of said provision. While submitting his report, the central government, the first respondent can as well urge the government to take immediate remedial measures vis-a-vis a particular, if at all the affairs of suspicion. So, if I may stop here, Malot, let's assume for a moment, Malot, it is not, the finding ultimately is their authority is excessive. Now, assuming for a moment, Malot, your lordship says it is not. The fact that finding on first principle, the same thing applies even today, saying that the notice issued to me and initiation of action which do
the petitioner here.
Same petitioner.
Same petitioner.
Same petitioner.
What prevented you from challenging that report? Why it was not challenged?
My lord, it's in Kerala. It's not the, no, the question is, my lord,
No, Kerala High Court only. The petitioner is
No,
Indian cooperative.
we have got relief over them, my lord. No, assuming the report is there, I'll keep the report. They don't have the initiative to initiate administration. It's only the central government they can do. The finding is, as per their own circular annexure R1G, the finding is they can only recommend to the central government for remedial measures. They have no authority to issue notice to me.
Now you are challenging what?
This order, annexure page 43, which they do not have authority, is a finding which the Kerala High Court has given at page 44, 45, and 54, 55, and 56.
This is annexure L.
Yes, about on theology. Annexure.
That was issued by the Ministry of Agriculture and
Based on
Farmers
this,
Welfare.
based on this page 43, my lords.
No, it was not by the Karnataka registrar.
No, based on 108, my lords. Page, your lordship, page 43, I'm sorry, my lord. I should
Register
have-
of Cooperative
Registrar, page 40. So and so under section so and so and so.
No, 43 in which writ petition? 31007.
Yes, my lord, yes, my lord.
That was issued by Joint Secretary of the
No,
Government of India.
Based on this report, my lord.
Report.
Yes. Report was not set aside by the Kerala High Court.
No, Kerala High Court.
It has stated you reported the central government to proceed further. Accordingly, it was reported to the central government. The central government issued this annexure L.
And that's available.
My lord, no, the inspection, what our respectful submission to your lordship kind consideration is, my lord. The inspection report, which is the subject matter of Kerala High Court, my lord, was considered, my lord, and it has been dealt with at page 55 and 56. And at page 57, maybe kindly see.
Writ petition that was not the subject matter. The respondent has produced it as an exhibit,
Annexure R1H, the 17.8.
There is no finding with regard to that.
The finding is, my lord.
Report itself is there. Page number 59.
Exhibit R1G ಗೆ ಇದೆ.
Page number 59.
RH is there, my lord.
RH ಗೆ ಇಲ್ಲ.
R1H is the report dated 17th August,
Yes.
which is produced at
Where
page
is the finding? Where is the finding to that? No. Even that was not set aside by the.
No, I would confess it was not a subject matter of prayer.
Yes.
It is on from records.
There was no such prayer and no such relief was granted.
Your lordship, page 58, this is only I have, my lord, page 58. I hope. It is hoped that the first respondent does not relish arrogantly to himself the power not vested in him and thereby act beyond the call of his duty even in the name of protecting public interest.
Correct.
And what is interesting also, I'll point out, my lord, your lordship may kindly see the way the first respondent arbitrarily has gone about. Page 43, your lordship will get, my lord. Page 43. This is which address is given?
This old address. First is old address.
Your lordship may kindly see, page 43, notice dated 2/6/2016. 22/2/2016, then 18/4/2016 and 10/5/2016 is given to the different address where I am not residing. Whereas the second notice dated 15th March 2016 was issued to me, that is annexure R4, page 19, to which I have replied on 29/6/2016 without considering the same. What your lordship may kindly see, these three notices given to different address which I don't receive. One notice issued to the correct address, I send a reply. But in page 43, they say, therefore, the above society was called upon for personal hearing before so, along with all relevant documents to explain the matter, but nobody appeared in society. That is factual inquiry. Your lordship may kindly turn to page 13.
Counter affidavit filed by them on 16/4.
On 16/4, my lord.
Counter affidavit.
Winding up proceedings. Is it not an appealable order?
No, the question is not if principle of no, this is not an here, my lord. What I'm trying to say is next portion, your lordship may kindly see the what I'm agreed. This is not appealable. Therefore, it is decided to initiate winding up without my note, without issuing notice to me. You issue notice to somebody else.
No, one notice is served and you have replied it.
And they have to consider that notice and pass order based on that.
No, even then, is it not a appeal?
No, my lord, there's no appeal against
Yes.
it.
Huh?
Section 19 of the multi-state court is Act, my lord.
Act for the multi-state cooperative system.
86 itself says, 86 itself says, provide an opportunity.
Because in another case, they've gone in appeal, my lord. Against the amendment, they went in appeal got dismissed, now they are before the, my lords, in 31005. Here.
Page 86 maybe, section 86 maybe.
Here there is challenge the annexure L notice, my lord, which is the order initiating the binding order.
Your Lordship, page section 86 may be kindly seen. If the central registrar after audit. My lord, one court, copy please, court.
99.
No, before 90 days, Your Lordship, may kindly see the 80
Review of chapter.
Section 86 may be kindly seen.
Respect to the provisions of section 100.
1 minute, sir. 86, is winding up.
Correct, this is what they are seeking to initiate now, winding up. If the central government after audit has been conducted under section 70, or a special audit has been conducted under 77, or an inquiry has been held under section 78, this is where we come, Malad, or an inspection has been made under section 79, or section 108, Malad, is of the opinion the society ought to be wound up after giving the society a reasonable opportunity of making representation by order, direct it to be wound up.
Yes.
My question is, Manoj, that reasonable opportunity which is ought to be given is not section 86.
If such an order is passed,
Section 2.
what is the remedy?
Section 99. Request word 99.
Appeals.
Hello? Appeal and review. Subsection 1, my lord. Subject to the provisions of section 100, in appeal shall lie under this section against. But yes, my lord, an order made by central registrar under section 86 directing the winding up of a multi-state court.
No, this is, Your Worship, the order of winding up, page 43. Therefore,
Initiate,
decided to
decided
initiate
initiate.
winding up. Therefore, there is no order of winding up. This is an order. Just keep quiet.
You senior advocate and engage ಮಾಡಿ ಸುಮ್ಮನೆ
I
ಇರ್ಬೇಕು.
apologize.
Sir, repeatedly I am seeing, you are causing embarrassment.
I apologize.
You should have that patience, sir.
This is a case where they are seeking to initiate winding up, Manoj. Therefore, Manoj,
That is annexure L is passed by the registrar of cooperative
this
society.
is passed by the joint registrar, government
Central
to the
registrar.
central registrar, Manoj. This is to initiate, because what they say, therefore it is decided to initiate winding up of the society. So therefore, there is no order of winding up.
Then there is no cause of action then.
No, cause of action is, my lord, now if they decided to initiate without considering, if they considered my objection and reply, my lord, the question is, it causes, and they rejected my amendment saying that I will not, because we have initiated winding up, we will not allow your amendment in the connected writ petition. Your Lordship may kindly see, my lord, either you kill him or you let him live. You are not killing him, you are not letting him live here. The point is this, my lord, I don't have a provision for appeal if you pass an order of winding up. If at least I'll go on appeal. Now you are saying that I'm going to initiate, I have no remedy. I'm before your lordships to show that, my lord, this notice was not served. One notice is served, I file a reply.
See, if it is to be consider annexure L,
Please, my lord.
the last one, page number 43.
Please, my lord.
Therefore, it has been decided to initiate winding up of the society under the provisions of MSCS Act and rules made thereunder. In case of any objection for the same, it may be brought to the notice of the undersigned within 15 days. Whether any reply was given.
No, your lordship may kindly from the date, the problem here is, I'll kindly repeat full sentence. 15 days from the date of advertising, failing which, therefore, my request, before you advertise, you consider my objections. If you are not able to consider my objection because notice is not served on me, because all the three notices are given to different address, I'll point out. One notice is given to the right address.
Even according to you, this is not the order for winding up.
I bow down to your lordship.
As per this, you are permitted to file your objections within 15
After
days.
the advertisement, my lords, I want your lordship may kindly, this is, from the date of advertising, because once an advertisement,
The advertisement will be given.
Your Lordship may kindly see page 42, my lords. I am therefore directed the 16th May to enclose the advertisement in the leading to publish. I've got lakhs of members, my lords, who have,
The advertisement they propose to do,
that is here only written, my lords, saying that you are trying to, will initiate winding up.
winding up.
So therefore, my lords, Your Lordship may kindly see, my lords, if winding up is a serious matter, causes serious consequences, it will create hue and cry among the.
But this is applicable 99.
No, it's not, my lords, Your Lordship, I'll just.
The order made by the central registrar
Permit
under
me to read
section
99 for a
96
moment
directing
once
winding up.
again, my lord. I'll read
When
99.
it is to be advertised,
No, my lord.
there must be an order.
No, there is no order. I bow down. That is one more defect, my lord. When it is to, I'm grateful to my lords, my lord. When there should be advertisement, there should be an order, then advertisement, not put the cart before the horse. I bow down to your lordship, my lord. You cannot say that I will kill you without passing an order. My lord, this is incomplete.
They have not only passed an order, they provided opportunity for you to file your objections.
What is the point after winding up notice giving me opportunity to file objections?
Why you are saying that this is not the order of winding up?
There is no order. That's why, my lords, your lordship, they themselves are saying decided to initiate.
Very same can be the ground under 99F.
My lords, I have got 3 submissions for your lordship's kind consideration. My lords. First is, my lords, section 108, very same document has been examined by the thing. They've shown how arbitrary they have acted against us. I'll put it.
Not the writ petition concerning the report.
No, I'll stand corrected. It is a case where the respondents have sought to inspect the premises of the petitioner in an arbitrary, illegal manner, and the court has said.
You have not challenged that report.
My lord,
why the petitioner has not challenged that?
there's no provision to challenge in the report in the sense, my lord. What we have sought to do, your lordship may kindly see here, based on that report, they sought to issue us notice.
Maybe, sir, you are aggrieved by that report, right?
My lord.
Are you not aggrieved by that report?
If the report is to be acted upon, they're issuing me notice at para 2. I would have replied. They have not given me the notice to reply. Before that, they've.
At least now it is brought to your notice that such a report is there.
No,
Are you not aggrieved?
No, if
by
I
that?
give a reply to them, they may drop it, my lords. Based on this.
Simple thing.
Yes, let them.
Thing.
So
Go
let
and give the reply.
But let them not. My only request is it should be pre-winding up notice. It should be pre-winding up notice, my lords. Your lordship may kindly see it can't be post-winding up notice. Your lordship.
You cannot.
Your lordship may kindly see if a winding up notice is given.
The petitioner cannot blow hot and cold. At one stage, you are saying there is no order for winding up.
I'm not saying, my lords, let them say there is an order, my lords. Where's the order? Let them show there's an order. I'm not saying anything.
No, at the same breath, you are saying the moment the advertisement is published, it means winding up.
My lords, I'm not saying, I'm just reading from what is written here, my lords. I can't say what they have written. They have only said that we are directed to initiate. So therefore, according to them, it is a case of initiation. My lords, it is, I can't say there is an order when they're saying that we are trying to initiate. It's a case of initiation of winding up by them. My case is, my lords, first 2 submissions is these notices were not served on us. The notice which they have served on us, they have sought to reply, but they go on the premises as if I have not replied.
Strangely, even in this, of course, you say it is a Kerala report, so you are not challenging it here.
Please, my lords.
But even before Kerala High Court, you have not challenged that report.
Therefore, your lordship may kindly Kerala High Court, what we sought to do is the action, what is comes out from the reading of the order is the arbitrary illegal action of the respondents going and
Pursuant to the report.
Prior to the report. The report is dated 17th August. This is incident took place on 13th July. Your lordship may kindly see page 46. Page 45, last report is 17th August is the report.
Time of filing this writ petition before Kerala High Court.
It was not there, my lord.
The
That is
report was not
there, my lord. That
And thereafter, you have not filed any.
from the judgment, I should bow down and show that it is not there, my lord.
Yes.
I should
So your contention that the report is already set aside cannot be accepted.
From the finding, your lordship may take to that there is no finding of setting aside, but there is a finding as to the extent the action of the respondent is arbitrary and illegal, at para number 21.
That is on the facts pleaded in the petition.
No, finding.
13/8/2015, 2
Correct.
PM. the first
Facts finding in the
respondent
petition, my lord, if the whole purpose of how they gone upon and done the inspection is held to be bad, then naturally the report looks to, my lord, this is I'm not saying this is a report which says, my lord, you
Sir,
foreign
what- Sir, please answer. What prevented the petitioner?
well, I need not
from
challenge,
challenging?
assuming I don't challenge, that cannot be held against me, my lord. So that cannot be held against me if I did not.
You are not aggrieved by the report.
I'm not saying I'm not aggrieved by that report, my lord. The Kerala High Court itself has said that the whole initiation is bad. Assuming I'm not challenged, that cannot be a ground for winding up without giving me an opportunity, because the section 86 requires for me to be given an opportunity. Lordship, page 73 may be kindly seen, my lord. Hold on, 73 ಅಲ್ಲ? Okay, page 8, 1 second. Page 8. Your lordship may kindly turn to page 53, page section 86, then I'll come. Your lordship, after giving the society a reasonable opportunity of making representation by order, direct. So therefore, reasonable opportunity should be there. As your lordship pointed out, there should be an order, then directed to be wound up. Then comes paper publication. That is the requirement of section 96, against which I have got an appeal under 99. So therefore, just because an inspection has been done, that is not a ground for filing an appeal or being aggrieved.
Is whether the central registrar has passed an order, separate order for winding up. As required, as referred to in section 86. Tagol. All these arguments in WP 31007.
31007, that's the main petition. That's the main petition.
Yes. 31007 ಅಲ್ಲಿ the petitioner a multi-state cooperative society. I am the member thereunder. Have approached this court seeking issuance of writ in the nature of certiorari to quash the notice dated 16/5/2016 issued by respondent number 2, produced as per annexure L, comma beda, semicolon agi, to quash notice dated 29/4/2016 issued by respondent number 1, produced as per annexure K, and to restrain respondent number 1 from initiating or continuing any liquidation process against petition number 1 on the basis of annexure K and L. Heard so and so. The senior advocate for the petitioner contended that an inquiry was held under section 108 of the same act.
Same act, same.
108 of 108 of the Multi-State Cooperative Societies Act 2002, wherein after referred to as so and so. And the report said to have been submitted. The said report was quashed by the High Court of Kerala. in WP number 20985 of 2015, with a order dated 19th August 2015, produced as per annexure M. In spite of that, respondent number 2 has issued the order as per annexure L dated 16th May 2016, deciding to initiate winding up proceedings against this petitioner society under the provisions of MSCS Act 2002. This order annexure L was passed without giving any opportunity to the petitioner. Next paragraph. Council submits that even though in annexure L at page 43, there is reference to various notices issued to the petitioner, none of these notices were served. Only one notice was served on the petitioner, and the petitioner has issued a befitting reply without taking into consideration the said reply. A decision was taken to initiate winding of proceedings, which is bad under law. Next paragraph. A senior advocate also contended that there is no order as required under law passed by the central registrar to initiate winding of proceedings. Under such circumstances, even winding of proceedings as referred to under section 86 of so and so Act 2002. Under such circumstances, section 99F of the Act cannot be invoked by the petitioner. Hence, the petitioners are before this court seeking to quash so and so. For control and the counsel for respond, you are for respondent number? Respondents opposing the petition submitted that even though the report as per report is not produced before this court, report is produced. Annexure. Annexure. N.
All two. I also produced.
The petitioner produced it. Page number?
59.
N.
Annexure N dated 17/8/2015 is issued. Highlighting various illegalities. By the joint registrar. The inquiry report by the joint registrar.
Joint registrar Kannur, page 65, my lords.
Kannur, joint registrar Kannur. The said report was never challenged by the petitioners till date. Annexure M
15 and 16, where the report is
the order
produced.
passed by
48,
the
48.
Kerala High Court is not in respect of the report.
Court directive, we are not.
Annexure N. There was no such prayer made in the petition, nor any relief is granted in respect of the report submitted under section 108 of MSCS Act. Next paragraph. In spite of giving sufficient opportunity, our learned counsel submitted. No objections was raised with regard to the report, and the same was reported to the central government, the central registrar, who in turn passed an order to initiate winding up proceedings. Therefore, it is an order under section 86 of so and so act. Which is available under section 99F of the act. Without recourse to the statutory remedy that is available, the petitioners have approached this court. Hence, the petition is not maintainable. Next, the counsel for respondents pays for to highlight whether there is any separate order for winding up passed by the central registrar under MSCS Act 2002. Okay, order sheet nalli heard so and so for further hearing. ಯಾವಾಗ ತರಕ್ಕೆ? ಯಾವಾಗ? Yes, thank you.
Serial number 4 urgent.
Which are? ಅದು ಇಲ್ಲ. ನಾಳೆಗೆ ಯಾವ್ದು ಹಾಕಿದ್ವಿ?
If I may request, I think
ಆಯ್ತಲ್ಲ.
Your Worship, if any interim order is there, kindly.
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್.
ಏನಿದೆ?
9th. Sir, ನಿಮ್ದು ಹೆಸರು 10th ಇಲ್ಲ. 9th.
Madam.